Good morning, everyone. We had this video introduction, because our conference is in a hybrid format. Distinguished guests, ladies and gentlemen, dear friends of arbitration, welcome to Bucharest. It is a real pleasure to open this edition of Bucharest Arbitration Days. This event become a tradition because the Romania commercial arbitration deserved to have an annual meeting on the arbitration practitioner from all over the world. As every year, this edition is in a hybrid format to allow more people the possibility to participate. So many thanks to our partner, Wolters Kluwer Romania. Thank you also Charter Institute of Arbitrators, Greener Arbitrations, Transnational Dispute Management, Young Romanian Arbitration Practitioners, and our media partners, Biz Lawyer, Juridice, and Universul Juridic. Thank you all for being here and supporting this event. This year is a special one for us. Our court is celebrating 70 years of existence, so Romania has a rich tradition in the arbitration field, having a permanent arbitration institution since 1953, and a court practice that is generally receptive to the idea of arbitration. Also, Romania has a strategic position in the movement of capital between East and West, but also between North and South, and the development of a culture of commercial arbitration can only be beneficial to the business environment. This year, the topic of our conference is stakeholders' role in international arbitration. All 8 panels during 2 days will address topics related to the current expectations from international arbitration from the perspective of the stakeholders' role in the arbitration process. International arbitration involves various stakeholders and all accepting the idea of arbitration as a valid and legitimate dispute resolution mechanism. From arbitration institutions to users, from arbitrators to external counsel, from third-party founders to hearing or artificial intelligence providers. Traditionally, every year we have at least 2 keynote speakers. This year we have 3 special guests, 2 from United States, Professor George Berman, professor at Columbia Law School, USA, and also another special guest is Martina Polasek, Deputy Secretary General, International Center for Settlement of Investment Disputes, Old Bank from United States, and one special guest from Romania, Mrs. Corina Corbu, the President of the Supreme Court of Romania, High Court of Cassation and Justice. Thank you so much for coming to our conference, to all of you. Thank you to all the participants in this edition of the conference and for your contribution to the success of this edition of conference. I wish you all of you a fruitful debate, and I look forward to discuss and meeting you during these 2 days. So now, considering the topic of Professor Berman's lecture, that is national courts as stakeholders in international arbitration, let me introduce you Mrs. Corina Corbu, the President of the Supreme Court of Romania, to give us a speech. Thank you again, Mrs. Corbu, for your presence here to our conference, and the floor is yours.
Mulțumesc, domnule președinte. Domnule președinte, domnule profesor Berman, distinși invitați. Vă mulțumesc, în primul rând, pentru invitația de a fi alături astăzi de dumneavoastră la acest eveniment special dedicat celei mai vechi, dar și celei mai prestigioase modalități alternative de soluționare a litigiilor, arbitrajul. Mă bucură în același timp această oportunitate de a onora cea de-a 70-a aniversare a Curții de Arbitraj Comercial Internațional, instituție care îmbină tradiția și prestigiul profesional la un standard remarcabil. Doamnelor și domnilor, deși se declanșează ca efect al unei clauze compromisorii sau unei convenții arbitrale, care sunt rezultatul intereselor private ale părților, este, după părerea mea, indubitabil că activitatea de arbitraj prezintă și o importantă componentă de utilitate publică, de interes social, astfel încât aș dori să fac câteva considerații legate de aceste aspecte din perspectiva judecătorului. Din punctul meu de vedere, arbitrajul răspunde la două necesități esențiale care țin de specificul raporturilor juridice dintre profesioniști. În primul rând, vorbim de nevoia ca litigiul să fie tranșat de o persoană specializată, care deține o cunoaștere profundă nu doar a dispozițiilor legale aplicabile unui domeniu, care nu de puține ori este unul de nișă, supra-specializat, dar și a practicilor comerciale și concurențiale specifice. În al doilea rând, vorbim de nevoia ca litigiul să fie tranșat cu maximă celeritate, astfel încât perturbarea pe care o aduce raporturilor comerciale obișnuite între cele două entități care chiar pe întreaga piață pe care acționează acestea să fie reduse la minimul absolut necesar. Din ambele perspective, arbitrajul și-a demonstrat în timp capacitatea de a oferi un răspuns pertinent și viabil acestor două necesități. Însă valoarea acestei modalități de soluționare a litigiilor devine tot mai evidentă astăzi, când viteza raporturilor sociale și comerciale, ca efect al unor noi tehnologii, a devenit amețitoare față de ceea ce se întâmpla în urmă cu 20-30 de ani. Nu numai viteza de desfășurare a raporturilor comerciale a crescut, dar și complexitatea acestora. În zilele noastre este deja uzual, spre exemplu, ca doi comercianți din țări diferite să încheie un contract de livrare de mărfuri prin mijloace de comunicare la distanță, cu transmitere instantanee, activându-se în același timp un contract de transport al mărfurilor respective dintr-o terță țară sau chiar de pe un alt continent, cu toate acestea și cu toate aspectele colaterale, ținând de asigurarea transportului, a regimurilor fiscale, a preluării în gestiunea mărfurilor și așa mai departe. Ori această creștere exponențială a complexității raporturilor comerciale presupune un efect direct corespondent în ceea ce privește complexitatea reflexiei juridice a acestor raporturi, în special în caz de litigiu, de a cărei soluționare profesionistă și rapidă depinde uneori chiar menținerea pe piață a uneia dintre societățile implicate. Fără îndoială, tuturor acestor provocări le răspunde astăzi arbitrajul. Prin formarea în timp a unui corp de arbitri cu un grad înalt de specializare și cu expertiză în domeniile de nișă, cu privire la care o specializare reală a judecătorului este foarte dificil de obținut. Întrucât, pe de o parte, lipsesc resursele pentru o paletă atât de diversă a acțiunilor de formare profesională continuă ale magistraților, iar pe de altă parte, pentru că specializarea obținută doar studiind aspectele teoretice sau practica judiciară nu va putea asigura niciodată aceeași profunzime a cunoștințelor, cu acea rezultând dintr-o activitate practicată îndelung în domeniile respective. Ca urmare, mi se pare că unul dintre principalele aturi ale arbitrajului este capacitatea acestuia de a oferi o cale de soluționare rapidă a litigiului, care este adaptată necesităților concrete impuse de natura acestuia. Cunoștințe de specialitate, nu de puține ori din domenii diverse, cunoaștere directă a practicilor comerciale din area de interes și așa mai departe. Cu alte cuvinte, vorbim de o soluție tailor-made, adaptată intereselor comerciale directe ale părților. Din această perspectivă, arbitrajul este o modalitate de soluționare alternativă a litigiului, care nu are ea însăși doar o natură litigioasă, contradictorie, dar care are și capacitatea de a stimula opțiunea părților către alte modalități alternative de soluționare a litigiului de natură amiabilă. Experiența arbitrului poate conduce părțile nu doar către o soluție impusă acestora, cum o face judecătorul, dar și către o soluție negociată, care să permită o soluție de tip win-win, care se întâlnește, din păcate, în foarte puține cazuri în cadrul procedurilor judiciare. Mai mult, chiar dacă nu se va obține o astfel de soluție negociată direct de către părți, arbitru are o mai mare libertate decât judecătorul în a avea în vedere și alte considerente în pronunțarea unei soluții, cutumele, considerentele de echitate, dar și poziția comercială a părților pe piață pot constitui astfel de exemple. Acolo unde o aplicare rigidă a legii poate conduce la o soluție care pare foarte favorabilă din punct de vedere financiar părții care a câștigat litigiu, dar care, prin efectele sale, provoacă scoaterea de pe piață a celelalte părți și, ca urmare, conduce la imposibilitatea urmăririi în concret a acestea pentru sumele datorate, arbitrajul poate conduce la o abordare deopotrivă mai inovatoare și mai rațională a legii, care să provoace în final efecte pozitive mai puternice sau mai durabile în timp. Ca judecător, nu privesc astfel arbitrajul ca o activitate de natură jurisdicțională aflată în competiție cu aceea a instanțelor judecătorești. Și cred că între cele două este o relație de evidentă complementaritate, care oferă părților care recurg la convenția sau la clauza arbitrală o modalitate profesionistă, specializată de a obține în mod rapid soluționarea litigiului apărut în cadrul raporturilor lor profesionale. Și aceasta este perspectiva pe care trebuie să o avem ca judecători atunci când avem de soluționat o acțiune în anulare împotriva hotărârilor arbitrale, ori o cale de atac împotriva hotărârilor pronunțate de Curtea de Apel în soluționarea acestea, respectând cu strictețe limitele controlului judecătoresc în această materie, nu doar ca efect al legii, dar și al prestigiului profesional excepțional, dobândit pe drept de această profesie prin modul în care ea a evoluat pe parcursul ultimilor 70 de ani. Doamnelor și domnilor, dispozițiile actuale ale Codului de Procedură Civilă asupra acestei problematici reprezintă un progres semnificativ față de reglementarea anterioară. Progres care se datorează într-o mare măsură influenței doctrinare și prestigiului profesional ale profesorului Viorel Mihai Ciobanu și lucrărilor sale de referință în acest domeniu. Și deși sunt unul dintre reprezentanții puterii judecătorești, nu pot să nu apreciez din punct de vedere profesional și criticile formulate de către regretabilul profesor Ciobanu la adresa unor soluții din practica judecătorească, care restrângeau, spre exemplu, posibilitatea exercitării recursului împotriva hotărârii, prin care se soluționa acțiunea în anulare împotriva hotărârilor arbitrare, critici care au fost ulterior, critici care până la urmă au stat la baza unor corecții legislative. Acesta este un bun exemplu de complementaritate între practica arbitrală, practica judecătorească și doctrina juridică și arată cum dezbaterea și schimbul de idei, chiar și în contradictoriu, pot genera evoluția și clarificarea unor instituții juridice. Astăzi, actuala reglementare asigură o viziune echilibrată asupra sferei controlului judecătoresc cu privire la hotărârea arbitrală, permițând garantarea drepturilor și principiilor fundamentale, ținând de respectarea normelor procedurale sau de dreptul la apărare și asigurarea egalității părților. Însă lasă totodată atât de necesara marjă de apreciere arbitrului, garantând astfel valorificarea cu adevărat a profesionalismului și chiar a atribuțiilor de mediator, de conciliator ale acestuia. Doamnelor și domnilor, mai există însă o modalitate în care practica judecătorească și cea arbitrală trebuie să se completeze și să se influențeze reciproc și care este una mai apropiată de atribuțiile specifice ale înaltei curți. Și mă refer aici la unitatea, la coeziunea și coerența practicii judiciare, în ceea ce privește tratamentul juridic al raporturilor dintre profesioniști. Așa cum este normal ca instanțele arbitrale să urmeze în practica lor hotărârile cu caracter obligatoriu ale instanței supreme, prin care a fost oferită o interpretare unitară pentru unele dispoziții legale, procedurale sau aplicabile fondului cauzei, este la fel de normal ca în procesul de documentare și de elaborare a unor astfel de soluții de principiu, instanța supremă să cunoască și să valorizeze practica arbitrală, tocmai ca urmare a înaltului nivel de profesionalism și de expertiză de specialitate care transpare în aceste hotărâri. Din această perspectivă, sper să facem cu toții mai mult pentru diseminarea și cunoașterea acestui tip specific de jurisprudență. În final, aș dori să revin la tema noastră în discuție de astăzi, manifestând aprecierea și respectul Înaltei Curți pentru toți acei implicați în activitatea de arbitraj desfășurată sub egida Camerei de Comerț și Industrie a României. Împrejurarea că această activitate este în plină dezvoltare, atât sub aspectul numărului de cazuri, cât și a valorii litigiilor deduse acestei modalități de soluționare, constituie, cred, cea mai bună modalitate de evaluare a calității acestor activități de natură jurisdicțională. Și mi-aș dori, cel puțin în nume personal, ca în anii următori să vedem din ce în ce mai puține arbitraje internaționale, chiar dacă poate asta ar putea la prima vedere să supere oarecum, care să privească situația unor societăți din România sau chiar a statului român însuși, atunci când apare ca participant la raporturi juridice private, și să atingem nivelul de încredere și de credibilitate, care să permită ca acestea să fie, în schimb, deduse căilor interne de arbitraj, însă întotdeauna prin libera opțiune a părților în acest sens. În nume personal, dar și ca reprezentant al Înaltei Curți, vă adresez tuturor cele mai bune urări de reușită profesională. Vă mulțumesc tuturor!
Thank you very much, Mrs. President, for your kind remarks. I know that your program is very busy, and I appreciate very much your presence here to our conference. And also I appreciate the presence of your colleagues, judges from High Court of Cassation and Justice presence here in our conference. Welcome to our conference. And now I invite you to listen the message sent us by the Minister of Justice, Mr. Cătălin Predoiu. Unfortunately, Mr. Predoiu is in a meeting at the government in this moment, but he sent us a message. I would like to mention that Mr. Predoiu is our colleague arbitrator in our Court of Arbitration attached to the Romanian Chamber of Commerce. So please listen the message.
Ladies and gentlemen, I'm honored to stand before you today as one of your own, a lifelong lawyer and arbitrator on the esteemed list of the Court of International Commercial Arbitration attached to the Romanian Chamber of Commerce. Bucharest Arbitration Days is a significant event, bringing together brilliant minds in the field of arbitration, and I am privileged to have the opportunity to deliver this opening speech. Today, I want to reflect on Romania's remarkable tradition in international arbitration. It may come as a surprise, but even during the communist regime, international arbitration flourished in our country. The cooperation among socialist nations within CAIR paved the way for Romania's emergence as a hub for international dispute resolution. Since the 1970s, we have produced renewed experts recognized globally for their arbitration expertise. Romania has consistently demonstrated its commitment to and promotion of international commercial arbitration. Compromissory clauses have become an integral part of major privatization agreements, infrastructure contracts, and strategic deals involving state entities. As evidence of our dedication, Government Decision Number 1 per 2018 stands as a shining example of Romania's resolve to utilize arbitration as the preferred mechanism for settling public procurement contracts in specific domains. Moreover, I am delighted to announce that Professor George Berman, a distinguished authority in the field, will grace us with his presence and deliver a speech on the role of national courts in the ecosystem of international arbitration. Such initiatives and events serve as catalysts for enhancing the utilization and quality of international arbitration in Romania. I am optimistic that they will contribute to further growth and development in our field. As a practitioner and a public servant, I closely monitor the evolution of investment arbitration, particularly within the intra-EU context. The legal conflicts between EU law and intra-EU bilateral investment treaties, the uncertain future of the Energy Charter Treaty, and the ongoing process of reforming the investment state dispute system are significant issues that will shape the future of investment arbitration in Europe. It is imperative that we navigate these challenges with diligence and ensure a harmonious and effective framework for the protection of investments. Romania recognizes the vital importance of foreign investments and their proper legal protection. Concurrently, our vibrant and diverse arbitration community serves as an essential driving force in our continuous development. The Bucharest Arbitration Days exemplify our dedication to fostering an environment that encourages growth, knowledge exchange, and the pursuit of excellence. With that, I wish all participants an extraordinary and fruitful experience during the Bucharest Arbitration Days. May the rich agenda and insightful discussions pave the way for a brighter future in international arbitration. Thank you and best of luck.
Thank you so much. Again, Mrs. President, you're present here. The message given us by the Ministry of Justice is a sign of a trust in arbitration as a mechanism for solve the disputes inside the environment, economic environment. So I take this sign as a strong sign of trust in our court of arbitration and, of course, in arbitration in general. As I told you before, one of our special guests for the conference is Professor Berman. Professor Berman is a professor of law at Columbia Law School in New York and a highly experienced international arbitration in both commercial and investment arbitration. He has conducted arbitrations regularly since 1980, before all the leading international arbitral institutions. Professor Berman arbitrates disputes in all sectors, including general commercial contracts, construction, intellectual property, energy, oil and gas, and many others. Professor Berman also serves regularly as expert witness before international arbitral tribunals. He is the chief reporter of American Law Institute's Restatement of the U.S. Law of International Commercial and Investment Arbitration, and co-author with Emmanuel Gaillard of the UNCITRAL Guide to the New York Convention. Professor Berman is a professor affilié at the École de Droit Institut de Sciences Politiques in Paris, professor in the Genève LLM in International Dispute Settlement, and professor at Georgetown University Law Center in US. He is founding member of governing board of International Court of Arbitration of the ICC Paris, and he is currently member of the Standing Committee of International Court of Arbitration of the ICC and the ICC Commission of International Arbitration. He co-chairs the Global Board of Advisors, New York International Arbitration Center, and is a council member of the American Arbitration Association and board member of the Center for Conflict Prevention and Resolution. He is also a fellow of the Charter Institute of Arbitrators in London. Professor Berman is a co-editor-in-chief with Rob Smith of the American Review of International Arbitration and editorial board member of the Revue de l'Arbitrage. Professor Berman is the author of numerous books, articles, and book chapters on international arbitration. He's a graduate of Yale Law School, and he has received international recognition for his achievement in his professional career, including being awarded Doctor Honoris Causa by University of Freiburg in Switzerland, Université de Versailles in France, Université César Vallejo from Lima, Peru, among others. Professor Berman is the Jean Monnet Chair in European Union Law, conferred by Commission of the European Union. So I thank you very much for coming in Bucharest. It's a big honor for us to be here. And it's my pleasure to give the floor to listen to your speech. Professor Berman, I invite you here.
Thank you.
Thank you very much.
Well, of course, I thank you sincerely and deeply for that comprehensive introduction. And of course, to the organizers of Bucharest Arbitration Days for the opportunity to be here. It's a real pleasure. I have to confess, this is my first time in Romania. I hope it isn't the last. It's a real pleasure to be here. I wasn't told that I would be speaking after the president of the court, the Supreme Court of Romania, when I decided to speak on the subject of national courts as stakeholders in international arbitration. It's a challenge to follow her, but I especially wanted to identify national courts as stakeholders in international commercial and investment arbitration, precisely because we do not tend to think of national courts as stakeholders. I expect that we will hear a good deal over the next 2 days about stakeholders in the form of counsel, arbitrators, users, experts, arbitral institutions, third-party funders, investors, and states. But I thought I should broaden my lens a little bit and think about the potential stakeholding interests of other actors. The only other one that I entertain discussing, but I know it will come up often in the next 2 days as a stakeholder in international arbitration, is the European Union, which has made itself a major stakeholder in international arbitration. It is responsible itself for becoming a stakeholder in international arbitration. I have lots to say on that subject, but I won't here do that. Now, I understand that there are a large number of judges in the room, and they are far better situated than I am to address the question of national courts as stakeholders in international arbitration. I'm an arbitrator, but not a judge. I am therefore an outsider, but it did occur to me that it might be interesting to hear what an outsider might think would be the stakes of national courts in international arbitration. So I do not speak to you as an expert on the subject of national courts as stakeholders, but I nevertheless welcome the opportunity to think about this, and that's what I've done. Obviously, by way of background, we have to recognize that national courts are stakeholders more generally than in the arbitration context. So, of course, I want to acknowledge, before I focus on international arbitration, that national courts are stakeholders in more general respect. And I can mention 3 that occur to me. One of them is their distinct and profound interest in, first, judicial independence. That makes them stakeholders in the sense of having a distinct interest at stake. Second, in having before them competent advocates. I think the task of national courts is facilitated and dependent on the quality of the advocacy. And of course, judiciaries have an interest in the resources that are made available to them. But we're not here to talk about national courts in general. So I want to turn my attention to the particular topic, which is what appears to me to be the interests of national courts in the international arbitration context. And I want to structure my remarks carefully. So what I'd like to say at the outset is that I can think of three important respects in which national courts are stakeholders. And I want to discuss each in turn, I hope not at great length. Now, the first, I would say, and it's the least of the three, least interesting perhaps of the three, but national courts are public bodies, and they therefore have a public interest, as all public actors do, in the international arbitration regime and the domestic arbitral regime in any given country. As public interested, as interested from a public policy point of view, national courts have an interest in the quality, the integrity, and the value of the international arbitration enterprise. Now, in this respect, they are observers. So my first view is simply national courts as observers, and that's not the most interesting, but I think it needs mentioning. Now, my second set of remarks will be, as you might expect, the interest of national courts as participants in the arbitration process. They are actors. They have functions to perform. And so I would like to talk a bit about national courts in the capacity of participants in the arbitral process. Now, the third and the most I think, interesting from my point of view, and the one in which I've really given more thought than the others, is national courts as bodies that have their own institutional interests, upon which international arbitration impinges, arguably even challenges. So, again, I want to speak first very briefly about national courts as public interest viewers of international arbitration, then national courts as actors in international arbitration, and finally, national courts as entities that stand to be challenged by, impinged upon by the international arbitration regime. So you'll bear with me, those are my three subtopics. Now, first, to begin with national courts as public interest observers, there's really very little to say. Like other observers, I like to think that national courts view the private resolution of international disputes as having considerable virtue, as a positive development. I think I heard the president of the court suggest that she is of that view, that international arbitration, viewed through a public interest lens, represents a healthy and valuable alternative avenue for the resolution of international disputes. In other words, I see national courts as looking with a kind of neutral favor at the putative advantages of international arbitration. Whether those advantages are real or not, have been achieved or not, is not the question before me. But I think we all know what the putative advantages of international arbitration as compared to national courts are supposed to be, ideally. And this is, of course, well known to all of you, but probably worth mentioning. And the President has already referred to these. Savings in cost and time, the potential for procedural innovation and informality, the ability to identify and designate one's own decision makers, one's own judges, expertise, specialization, a greater degree, if one seeks it, of confidentiality, an ease or relative ease in the enforcement of international awards as compared to national judgments, and perhaps above all, from an investment arbitration point of view, as a supposed neutrality. Now, what I mean to say is that I am going to assume that national courts are in principle, consciously or unconsciously, amenable to the idea of sharing the adjudicatory burdens with privately constituted arbitral tribunals. If I'm right that national courts acknowledge the utility of international arbitration as an alternative, then I think we might fairly characterize national courts as broadly pro-arbitration, to use an overused term, pro-arbitration. Now I want to turn to my second perspective, which is national courts as participants or actors themselves in the arbitral process, which requires identifying, of course, their functions that they're called upon to perform in the international arbitration context. Now, we know that national courts have a significantly reduced role in addressing the merits of a dispute when those disputes have been submitted to international arbitration. It will not be the function of national courts to directly or independently address the merits of the disputes that produce the awards that come before courts eventually. But national courts also do not view or cannot view international arbitral tribunals as functioning according to the procedural and other ground rules that national courts employ themselves when they resolve international disputes. I like to think that international arbitration is not bound by the civil procedure rules that prevail in the countries in which they sit. If international arbitrators are bound by national practices, the first place to look, I suppose, is the lex arbitri. But though, and this is obvious, though reduced in the two ways I indicated, though reduced, the functions performed by national courts, everybody in this room knows, are of fundamental importance. And that too has already been alluded to. I like to think of national courts as actors in a three-act play, a three-act spectacle. And you know what those three acts are. I'm going to discuss each briefly. The first is enforcing or declining to enforce an agreement to arbitrate. The second is intervening in an arbitral proceeding in one way or another. And the third, obviously, is policing, in a general sense, the awards that result from an arbitration, whether on the occasion of a set-aside action or an action to enforce an arbitral award. Let's first talk about that first function, enforcing or declining to enforce an arbitration agreement. Now, at this stage of the life cycle of an arbitration, I think the stakes of national courts lie in two places. The first is the scope of the inquiries that national courts are invited to make into the question of arbitral jurisdiction, and the standard of judgment that they are to employ in addressing the contours of arbitral jurisdiction. In other words, what are the questions that national courts may legitimately ask before enforcing an arbitration agreement or declining to do so? And to what extent should they give what I call anticipatory deference or advance deference to the tribunal that will be constituted at a later point in time? I will simply say in passing that we know that jurisdictions differ greatly in this respect. And we spend much time in the law school talking about this question. And we know, for example, that there is a sharp contrast between the conception of the judicial role in enforcing arbitration agreements as between, for example, on the one hand, France, and on the other hand, the United States. That is to say, the conception of the scope of the inquiry and the standard of judgment that is to be utilized in addressing that question. Now, I have really no idea, maybe I will hear over the course of this event, whether national courts think or believe that they have an interest of their own in the breadth and depth of the jurisdictional inquiries that they make. I've never thought about this before, but do you judges in the room, do you have a preference? Do you have, seriously, a preference as to the degree of breadth and depth into which you are in a position to go when asked to enforce an arbitration agreement? Do you favor the enhancement of your authority? Do you favor a reduction to modest levels of your involvement? That's a question to which I have no answer, but to which I'd welcome an answer, because we seldom think about that. Do national courts care? Do they actually care about the breadth and depth of their inquiry at this stage of the arbitration life cycle? Now, there is a second interest about which I'm more comfortable making a judgment at this stage, this initial stage. And that is the interest that national courts have in having reasonable certainty of what is the scope and what is the standard of judgment that they are expected to exercise. How much certainty do they have about the contours of their role? Were I a judge, I would benefit from having a stronger sense than I might otherwise have of what is expected of me when faced with an arbitration agreement that will either be enforced or not enforced. And I'm not convinced that that interest, the interest of national courts in knowing the contours of the inquiry they're expected to make, I'm not confident in the degree to which they have been given guidance on that question. When you think about it, to be precise, both Article 2 of the New York Convention and Article 8 of the UNCITRAL Model Law both say nothing more than that courts may refuse enforcement of an arbitration agreement if they find the agreement null and void, inoperative, or incapable of being performed. And that's all we're told, both by the treaty and by the UNCITRAL Model Law. Now that, quite honestly, is not much by way of guidance. It really doesn't tell us meaningfully the inquiries, the specific inquiries that a court is entitled to make, nor does it tell us the degree of what I have just called the anticipatory deference, or the deference in advance of the arbitral tribunals to come, nor does it tell us what law is to be applied in determining whether or not a condition for the enforcement of an arbitration agreement is satisfied. For example, the validity of the arbitration agreement. I won't go deeply into this, but it is a preoccupation of academics. This is a preoccupation of academics, and to some extent, a preoccupation of practitioners. And I won't go into American law, that's not why you're here. But we spend a lot of time thinking about whether the role of national courts depends upon the nature of the factor involved. And we draw a distinction between what has come to be called gateway and non-gateway issues, on the assumption that the court's role is at its highest when it comes to gateway issues being defined as those upon which the legitimacy of arbitration depends. The legitimacy of arbitration depends. And they include, of course, whether an arbitration agreement has ever been formed, whether if formed, it is valid, and whether if formed and valid covers the dispute at hand, and whether and to what extent a non-signatory can be held bound to an arbitration agreement. And the common theme among all of those is the principle of consent that is inherent in all four of those inquiries. But there are other inquiries on which the enforceability of an arbitration agreement depends, but which will be left primarily to the tribunal and not to a court. Those are the non-gateway issues, and the best examples of those, for example, are: did a party waive its right to arbitrate? Has the dispute already been adjudicated so that res judicata is in play? Has a precondition to arbitration in a multi-tiered arbitration situation been satisfied? And even has the statute of limitations on the dispute run? I simply want to suggest that every legal system has an opportunity to decide which are the issues among those many threshold questions that courts have a role, and how big a role is it in making those determinations. And I simply say, in the United States, that's how we look at it. There are those that are gateway, there are those that are not gateway, and the role of the court. So what I mean to say here is that national courts, I would suppose, favor certainty as to the extent of their role at this stage, both in terms of the scope of the inquiry they conduct and the standard of judgment they observe in addressing that. I don't have more to say about the role of courts at this first stage in the life cycle of an international arbitration. We get next to the question of national courts as interveners. National courts as interveners in an ongoing arbitral proceeding. And where do the interests of national courts lie here? Now, I'm again going to make an assumption, of which you may disabuse me, that national courts welcome, I may be wrong, but they welcome the opportunity to perform a certain number of functions that arise during the lifetime of the arbitration itself. And we know what those functions principally are: appointing or replacing an arbitrator, making interim relief available to parties in the arbitration, and making documents and other forms of evidence available to the parties. Do courts seek to minimize their activity in these respects? Do they embrace the opportunity to participate in these forms? Again, that I do not know, but I suppose the interest of national courts depends upon whether or not the system is enabling them to perform these functions in an able and competent fashion. The question, again, is whether, and this is a question national courts must ask, is does the international arbitration regime in their country enable them to perform these functions ably? Does it permit them to do so? Does it allow them the exercise of discretion that I assume they welcome? Again, you may disabuse me of that assumption, but that national courts welcome a certain scope of discretion in deciding, in particular, whether to grant interim relief or award access to documents. How well national courts are able to accomplish these purposes bears importantly on the efficacy of arbitration. The efficacy of arbitration depends in no small measure on the extent to which courts find themselves in a position to execute these functions. That strikes me as an outsider, once again, that strikes me as something national courts would care a great deal about. Now, you'll be glad to know I come to my third and last phase, which is the role of courts in policing the awards that result, whether in a set-aside or an enforcement action. And I assume this is a set of functions to which national courts attach the utmost importance. And what is at stake here for national courts? And I think, unsurprisingly, the interest of national courts here is to have at their disposal a normative regime that permits them to perform this policing function on a principled and coherent basis. Now, here at least we have the New York Convention, particularly Article 5. We have the UNCITRAL Model Law, Articles 34 and 36, that go a long way in this direction of enabling national courts to know what is expected of them, and indeed what they are permitted and not permitted to do. And we don't only have the New York Convention, but we do have what was referred to earlier, which is the UNCITRAL Guide to the New York Convention. And we also have the website that has been produced in support of the New York Convention, with which you may be familiar, and which has been produced and maintained by the law firm of Gaillard, Bani Fatemi, and Shelbaya, as well as, I'm proud to say, Columbia Law School. Now, when national courts determine the validity of an arbitration agreement, the procedural fairness of the hearing that took place, the possibility that the tribunal has exceeded its authority or rendered an award whose enforcement would be contrary to public policy, they all contribute not to what I just mentioned, is the efficacy of international arbitration, but rather the legitimacy of international arbitration. Now, all I mean to say here is that national courts have a stake, I would suppose, in the clarity and the quality of the standards by which set-aside and enforcement decisions are made. I hasten to add, however, that in some countries, the national courts themselves are the architects of that system. I'm sad to say that it is the case in the United States that setting the ground rules for how courts are to function in international arbitration is decided by the courts themselves with little, if any, guidance by Congress. The Federal Arbitration Act is 95 years old. It will celebrate its centenary in 2025, and it is pathetic. It is a pathetic statute. It offers no guidance. The ground rules in the United States for international arbitration have been established by the courts. Now, here the courts don't so much have an interest as they have an obligation to fill the void that Congress has left. I will tell you that the American Law Institute, which produces the restatements, is now entertaining the possibility of drafting a new Arbitration Act, which would be the first in nearly a century. It's remarkable. We have the oldest and least adaptive arbitration law in the world. Now, I stress that because we tend to think of courts as being the recipients of guidance by legislatures. And I have to point out that in some legal systems, they get no guidance from legislatures. Now I come to my third and last viewpoint, and that is not how national courts have a public interest, not how national courts are actors in a three-act play, but how national courts have their own institutional interests, their own, and they pre-exist arbitration. They exist independent of arbitration. What are their interests? What are their interests as an institution? And how does international arbitration impact their interests, their own interests in it? This fascinates me. I'm not well positioned, as well as many of you, to know what arbitration does to courts, what it does to them, how it affects them and their own functioning. But I want to give it a little bit of thought. And I have two important respects in which I think this can be approached. Now, the first is a little bit cynical, but I'm not ashamed to present it to you. It's a bit cynical. It is sometimes said in the United States, without proof, of course, that national courts favor arbitration because it allows them to clear their dockets. Now, there can be no question that courts would have vastly greater caseloads if international arbitration was not around to siphon off as many cases as it does. Now, this sounds cynical, but I have to tell you, again, that in the United States, there is a growing sentiment that our courts are over-eager to send parties to arbitration, over-eager to send them to arbitration, and to send them to arbitration under circumstances when, in principle, they shouldn't do so. If only, for example, that there are severe doubts as to whether the parties agreed to arbitrate and what they agreed to arbitrate. Courts in the United States are offloading a vast number of cases to arbitration, and there are questions about whether that has been overdone. And I'll leave that there. The second and last comment I want to make about national courts' own interest as institutions is, I think, the most interesting and most important. And that is national courts' concern for the effect of international arbitration on the integrity of national law. National courts have an obvious stake in the integrity of national law, and more particularly, the integrity of the decisions that are made implementing national law. They have a very direct stake in whether national law remains in the form and of the quality that it is without arbitration causing detriment to that. And here I'd like to share with you two reservations that one can have, two concerns that one can have on this subject. The first one, and you've heard about this, but it's worth mentioning, is the possibility that this large-scale diversion of cases, this massive diversion of cases from courts to arbitral tribunals, will cause detriment to the sound and coherent development of national law. Now, this is a matter that has concerned, most notably, certain common law jurisdictions. The United Kingdom is the prime example. You probably have heard of the famous speech given by the Lord Chief Justice of England and Wales in 2016, the title of which was "Developing Commercial Law Through the Courts, Rebalancing the Relationship Between Courts and Arbitration." He gave voice to the concern that international arbitral tribunals are depriving, through no fault of their own, national courts of principal authority in determining the content of national law and the development of national law. I hasten to add that this is, if it's a concern, it's a greater concern in common law jurisdictions than civil law jurisdictions, because in common law jurisdictions, courts view themselves as the architects and the creators of civil and commercial law. I'll quote him briefly. "The consequence of the growth of international arbitration has been the undermining of the means through which much of the common law's strength, its excellence, was developed. A danger not merely to those engaged in dispute resolution in London, but more importantly to the development of the common law as the framework to underpin international markets, trade, and commerce." And it is, in fact, precisely this concern that has led, as I think you know, to the sprouting in countries, various countries around the world, of international commercial courts. Okay, new units of national courts specifically designed to stem the tide of international cases going to arbitration and not to national courts. The development of these international commercial courts in China, in Singapore, and in many other jurisdictions, it's meant to reassert, to reaffirm and reassert the authority of national courts over the quality and content of national law. And on the question of the contribution of international commercial courts to stemming the tide of arbitration, one of the most well-known spokespersons is the Chief Justice of the Singapore Supreme Court, who on several occasions, but as recently as last month, gave a lecture in Bahrain entitled "The Transnational System of Commercial Justice and the Place of International Commercial Courts." I call this the repatriation of international commercial cases from tribunals to courts. I'm not saying that this is my view. What I am saying is that it is a widely held view, particularly in common law systems, that international arbitration is siphoning off cases that, if they came before courts instead, would enable the courts to develop the law themselves primarily. Now, the second and related but distinct concern from the point of view of national courts' own institutional interests stems from the fear that international arbitral tribunals may misapprehend and misapply national law in the cases that come before them. I hasten to add, I'm not worried about that, but I am cognizant of the fact that some national courts may be fearful that the integrity of national law is compromised by the fact that its application is in the hands of tribunals rather than courts. Now, just how fearful should a nation's courts be to the introduction of the possibility of error in arbitral awards? If there were a great deal of error, if there were demonstrably a great deal of error introduced into national law by arbitral tribunals, I think you'll agree with me that would be of great concern. And that would be very worrisome. I don't happen to think that's happening. However, my comments would be incomplete if I didn't tell you or remind you that the jurisdiction most fearful of error by arbitral tribunals and intolerant of error by international arbitration actors is the European Union. In the noted Achmea case, you will remember the CJEU justified its invalidation of intra-EU arbitration agreements and intra-EU awards on the ground that tribunals lack authority to make preliminary references to the European Court of Justice and therefore can fall into error in their apprehension and application of EU law. Why? Because they do not have guidance by the European Court of Justice in the form of preliminary rulings. So that I think with enormous exaggeration, it is argued that arbitral tribunals have a corrupting effect on the integrity of national, or in this case, European Union law, so much so that the autonomy of the European Union is said to be at stake. I have every confidence that this question will arise over the next 2 days. And this is not the time or the place to delve into those matters here of whether there is corruption in the broadest sense of the term, whether there is corruption of EU law by international arbitral tribunals. I think not, but there we are. So I want to conclude, I'm sure you want me to conclude, that as I said at the outset, I make no claim to knowing how or why national courts might see themselves as stakeholders in international arbitration. And I do not know whether I have captured the concerns that national courts harbor vis-a-vis international arbitration. But I tried to think long and hard and deeply about where those concerns might lie. And I may or may not be correct, but at the very least, for what it's worth, I'm telling you what an outsider imagines those concerns to be, and imagine what the interests of national courts are in the view of national courts. And I stand to be enlightened, I'm sure, on that subject by you all. I hope you, with all the judges in this room, I hope you have tolerated my intrusion into your sphere of activity. But I do think national courts are stakeholders, and we don't think enough about it. Thank you very much.
Thank you very, very much, Professor Berman, for your kind remarks. I'm sure that during these 2 days of a conference, we will have more questions than you, and also I think we will have the answer to these questions. So thank you again, President Corbu. Thank you again, Professor Berman. Now we take a short break, not coffee break, a short break, 3-5 minutes, and then we will continue with the first panel. Thank you.
We have the pleasure of starting the discussions and the panels of this conference. As I was driving this morning and sitting in traffic, a lot of things naturally came to mind about life in general, but also about this conference in particular. And one thing which came to mind, one idea which came to mind was that, you know, thinking about money, money is a terrible master, but an excellent servant. And I think that, you know, if we were to describe the purpose of the discussions of this particular panel, speaking about money as an excellent servant could be a nice way to put it. We are going to be discussing about a relatively recent occurrence in modern international arbitration, but not only international arbitration, arbitration in general, and litigation in general, to speak more generally, which is third-party funders as stakeholders in international arbitration. They have step by step become a presence which is more important and more appreciated, and which enables parties who maybe lack the funding or do not wish to allocate the funds. They have the money, but for some reason they prefer to use it to some other better destination than funding litigation. Then we have this kind of service that we can use now, and we are using it, including in Romania already. So we have already projects in Romania, arbitration projects involving Romanian entities, which are the third-party funded. We have a great line of speakers. I will start with a few words of introduction for each of them. First, next to me is Lucy Green. She is a director of External Advisors. She has spent her entire career in the legal market, formerly as a private equity transactional lawyer, and more recently held senior strategy roles within the sector, working primarily with corporate legal departments. She led on European corporate strategy at a large litigation funder, and her skill set spans disputes finance, including transactional and strategic advice, acting as consultant to law firms and businesses to maximize opportunity from their litigation assets. Then we have also Alice Fremont-Wolf. She's working with Nivelian, a well-known funder of litigation and arbitration. She's market head for Austria and the Central Eastern European region within the firm. And before joining Nivelian, she was the Secretary General of the well-known Vienna International Arbitration Center for 10 years. She's a lecturer for arbitration at the Institute of Civil Procedure Law at the Law Faculty of the Vienna University. And I will stop here because she asked me specifically not to be long with her presentation. And last, but of course, as the saying goes, not least, we have Joe Tirado. He is a partner and co-head of international arbitration and ADR at Garrigues in their London office. He's highly experienced and globally recognized as a ranked individual for international arbitration and ADR. He has over 30 years of dispute resolution experience and has handled hundreds of cases across a broad range of industry sectors of counsel, arbitrator, mediator, exceed conciliator, and expert determiner in more than 65 jurisdictions, which is quite impressive, I have to say. Now, we have structured this panel as a sort of fireplace conversation. Of course, there is no fireplace. There will be a conversation, however, and I will try to start, you know, by thinking at the initial stage. Let's say that let's assume that the party believes that it has a case, and for some reasons, the party wishes to use third-party funding. How would that party kickstart the process? Lucy, if you could start.
Yeah, so thinking about, is that better? Yeah. So when you're thinking about a case for potentially for funding, I think the most important thing at the beginning is to really think about why, as a business, you want funding. There are lots of different funding products available, and in order to access the right product, it's really important to understand what it is you're trying to achieve with funding. Different products serve different purposes and solve different problems for a business. So there are options around, say, financing single cases, and that is where a funder will pay your fees and expenses associated with that one case. And that is essentially a cash flow solution. It provides the company with immediate liquidity. Or there might be a situation where actually you've got multiple cases that you wish to have funded, in which case you would want to be looking at sort of a multi-case finance discussion, also called portfolio financing. And that enables you to access funding across a broad range of cases, potentially including defence side funding, and which is why it's really important to understand that at the outset if you want to bring in other cases. And there's also the options around something called a monetization, which is essentially a balance sheet solution. It enables you to realize the value of your asset earlier than you might otherwise be able to do. And if the company is wishing to realize the asset value and use that capital today in their business, then it's a different product that they might wish to access. So I think at the beginning it is really important to understand exactly what you require the financing for, so that you're having the right conversations from the beginning. I think that the next thing that's really important to think about is actually who is being funded. Because often it's the claimant that's directly being funded, but in some situations you might be looking at funding the law firm themselves, especially in a situation where the law firm is taking some element of risk on the case and acting on either full or partial contingency. So in that situation, the law firm might just have a direct retainer with their client and be dealing behind the scenes separately with a funder. And so then obviously the discussions are slightly different. So really understanding who it is that is going to be funded and why, and what that structure might look like. But then sort of, coming back to the claim itself, in terms of, getting funding for a particular case, it's really important to step back and before picking up the phone potentially to a funder and saying, I've got a case, I think it's really important to not rush in immediately, but to think about, is this case something that is potentially investable by a third party? Is there a claim that somebody will want to take a stake in? And law firms have a really important role to play in advising on what that might be, and looking at what the criteria is. And just in broad terms, you need a claim that is, obviously that is meritorious, that has a strong prospect of success. You need to look at sort of the economics of the claim. What's its value compared to the amount of funding that you're seeking. And there needs to be a level of proportionality, and there also needs to be the ability to actually enforce against any award. So, there's no point in having an award on paper that ultimately you can't enforce, because, that's not going to give a funder any return. And so it's really important that those things are sort of mapped out very early on before approaching funders, because I think if you pick up the phone to a funder and you haven't got the answers to all those questions at the outset, it can slow down the process, and it can also put you in a position where lots of funders have looked at the opportunity but haven't been in a position to make any kind of offer. And suddenly, that your case has a bit of a reputation, as it were, in the market. And I think it's really important that actually when you go to that funder the first time, you are selling a really attractive investment opportunity and that you've really done your homework. So working with a law firm or an independent advisor about the options around what funding product is most appropriate for you, and also the things that you might need to address to ensure that your case is most likely to receive investment. And then I think when you get to that stage, obviously, you're now thinking about who do we approach? Which funder to approach? Who do we pick up the phone to? Who do we speak to? And it can be quite daunting. Litigation funding is a really growing market. There are more funders that are investing in litigation assets all the time. And they have access to different capital, different risk appetites. Different funders like different cases, have access to capital sort of immediately, or there might be a sort of a long delay depending on their internal processes. And so it's really important that you actually do the due diligence in terms of making sure that you approach the right funder for your particular case. Often we hear at our firm that cases have been rejected across the market, and often that's simply because the wrong funder has been approached, or a funder who doesn't have the necessary capital available at that time, or their risk appetite has changed for the time being, and that actually hinders the opportunity for the case to get funded, which is a shame, because there are other funders who may be interested. And so, again, this is something law firms can help with to the extent that they understand the funding market and the different funders that are out there. Independent advisors who work across the funding market and have sort of that bird's eye view of what funders are doing, what cases they're interested in, will also be in a good position to advise claimants and law firms as to matching the right case with the right funder. So I suppose overall, it's just in terms of, kickstarting that process, it's thinking about why you want funding, who actually is the funded party, is this a case that, in theory has the right criteria to attract funding, and thinking very carefully about who that funder might be. And I think if you can follow those steps, then it gives the case the sort of greatest chance and prospects of attracting a funding offer. Yeah.
Okay, thank you. Now, assuming that the decision is made and funding has become likely, I would wonder what would be the description of a typical funding process? What would be the role for the lawyers? How are negotiations going on? Alice, if you can help us with this?
Yes, of course. Thank you very much. Well, first of all, it's a pleasure to be here. I really enjoy being in Bucharest after such a long time, and a special thanks to the organizers for having invited me. It's a real great pleasure to be here. Well, to the funding process, I think there are several steps, that flow quite naturally. First of all, usually we get contacted either by the case leading lawyer or by the client itself, that they have a potential funding opportunity for us. So what we do first is to conclude a confidentiality agreement, like an NDA, with the client and the lawyer, in order to protect any information that is transmitted to us. And also, when we get approached directly by the client, one of the most important steps is then that we really request that the client is being represented by a lawyer in the course of the funding process. It might be a bit different when we get approached by big corporations who have a very sophisticated in-house team that do a lot of the work sort of in-house, but usually the selection of the lawyer that is being done by the client and also the vetting of that law firm is a really important step for us. So ideally, as Lucy has mentioned, we receive a memo with the key elements of the case that will allow us on a preliminary assessment to see whether that meets the funding criteria that the particular funder has, like the threshold of the claim, the risk appetite, what kind of jurisdictions, do you have that in-house expertise or not? And so that we are very quickly in a position to let the lawyer, the claim holder, know, well, this is something where we want to look into more deeply, or whether this is something where we would refrain for various reasons, and we would be quite transparent on that matter. So after this sort of first assessment, we kind of start this internal due diligence process, meaning that we request more information from the lawyer and the client. And here, you know, the lawyer's role is quite clear. The lawyer has his responsibility versus the client. So we don't want to interfere and cannot interfere in this client-attorney relationship. And it's really the lawyer's obligation or duty to really represent the client with whom we eventually conclude the litigation funding agreement, to represent the client in this process and make sure that all the information is being provided. So we kind of test the case and ask all that stupid questions, starting sort of as a reverse engineering with the question, can this be enforced? Because the funder receives its share, the success fee, only when eventually the money comes in. So the first question is always, what is the solvency situation of the respondent? Are the assets available? And sometimes you really have to start with an asset tracing exercise even before you continue with the rest, because what can you do with an award or a state court judgment if it cannot be enforced? So after we have done this sort of preliminary assessment, we prepare a term sheet where we set out the basics of, you know, the pricing mechanism. After we have obtained also information on the budget, we will talk about, you know, numbers a bit later, so I refrain at the moment of going into this more deeply, and also the basics of the litigation funding agreement that is to be concluded later on in the process. And this term sheet usually also provides us with an exclusivity period to really then dig into the matter more deeply for a period of around 8 to 10 weeks, depending on the complexity of the case. Because here, after this step, we really invest our own time and money to get to know the case better. Sometimes we would then even, or very often, engage external counsel for the funder to look into a particular matter. Let's say, for example, I'm responsible for the whole CEE region, and naturally I'm not an expert in any particular area of a particular law in that region. So if a key question comes up that might, you know, is crucial for a particular case, we hire external counsel who do a so-called red flag due diligence for us, pointing us to issues that we might not have seen or the local council has not seen. And the whole exercise is therefore to make the case waterproof, to really see, you know, what are the risks, might there be any counterclaims, has there something been forgotten? And in parallel, you know, we already start negotiating the litigation funding agreement, again with the client being our sort of business partner with the aid of the lawyer. And there are model agreements, but of course, there's always room for negotiation. I mean, there are some certain terms that are sort of set in stone, but others, especially on the commercial terms, you know, what is the success fee? What, you know, how is this been done? I think there's really room for negotiation. So if all that is being concluded, we internally provide conclusive investment proposal that we submit to our internal body of approval. And if that approval is being granted and the litigation funding agreement has been negotiated and it's been signed, then immediately the money according to the drawdown that is also part of the litigation funding agreement, you know, sort of planning. You don't give the money that you deployed all at once, but you have different steps. Sometimes you can even build in conditions. For example, if you have this asset tracing exercise, you can say, okay, we fund the asset tracing at the beginning, but if that is negative, you have a possibility to end the funding, because then naturally it doesn't make sense to proceed the funding. So once, you know, this is being done, and we get monthly or quarterly invoices, we pay the invoices, but the case is then being conducted by the lawyers and by the clients, and at least continental European funders, they would not interfere in the proceedings. So we have done our work before. Yeah, and after positive conclusion of the case and the money has been received, then the success fee is being distributed according to the waterfall that is being set out in the litigation funding agreement. That's it in a nutshell, basically.
Assuming that a litigation funding agreement has been concluded, now there is one practical question, also a legal one. The question is, how much do you disclose? If you have an obligation to disclose, if so, what do you actually disclose? Joe, can you assist us with this?
I'll do my best. Good morning to everybody. First of all, let me just echo the words of thanks to Cosmin, the Centre and the Chamber for the very kind invitation to be here. As my American colleagues would say, I'm truly very excited to be here. As a Brit, we don't normally get excited about much other than football perhaps, but I really am. It's 20 years since I was last in Bucharest, and I had the opportunity yesterday to have a wander around, and I can see you've been busy in those 20 years. I congratulate you. The place is transformed. Also, it coincides, I think, with the last 20 years of great evolution within the third-party funding area. In fact, it's been around longer than that. In the 90s, it started in domestic litigation in Australia. But I think what we then saw it move into, from litigation into investment arbitration, and more recently, in the last decade or so, into commercial arbitration. And truly, it has been well, in my jurisdiction, it's been revolutionary. It was a revolution that wasn't made a lot of noise about, but the whole concept of third-party funding was just not available to us for hundreds of years, and that changed not that long ago. And so the whole ability to be able to access third-party funding has truly, I think, opened access to justice to many claims. But that said, what I would say, before I actually answer that question, let me, if I may, add a comment to Lucy's introduction in terms of the funders, because I think we all have a different notion of what the funders are. And all I was going to really add is that in the last 10 years, if not an explosion, there has been an enormous increase in the number of funders available, both the traditional funders, but also right from private equity to distressed asset sections of banks. There's a lot of money out there chasing claims. So the biggest issue is really trying to identify the right ones. And I think either a broker can really help you target the funders. It's a global market. There are some funders who are based in Latin America, for example, that will be particularly keen on Latin American type claims, but it's a huge market. And I just make the point because it's worth pointing out that's a fantastic advantage for us as users and for clients, because where there's more competition, generally you get better terms. And so it is worth shopping around. But it's forever evolving, and more players no doubt will come in and specialize even more. The last decade as well, I think, really has, and now getting to the point about disclosure, coincided with this kind of global push. It's really come from the investment arbitration world towards transparency. Some will recall the 2014 UNCITRAL rules on transparency in treaty-based investor-state arbitration and the related, sadly not that successful to date, Mauritius Convention. Only 9 countries ratified that so far. But there has genuinely been this push, I think, to greater openness, and you see in places like the ICC now that they'll publish lists of who's sitting as arbitrators. But I think certainly we can all agree a key foundation of international arbitration is the impartiality and independence of an arbitrator, and that's true whether you're sitting as a sole arbitrator, a member of a tribunal, or the chair. And I think the test for removing an arbitrator under most arbitration rules, including the UNCITRAL model law, is, quote, justifiable doubts as to impartiality and independence, close quotes. And I think we could probably summarize that impartiality is needed to ensure that justice is done, but independence is needed to ensure that justice is seen to be done. So a very fundamental aspect of any arbitration. And so where it relates to third-party international arbitration, the relationship between a funder and an arbitrator, or in some cases, it may be the involvement of the same funder in more than one case, where that same person is acting in different capacities, and one as counsel and another as arbitrator, may impact the impartiality and independence of the arbitrator, leading to potential conflicts of interest. The many types of example, one may be, for example, where an arbitrator is not using funding himself, but his firm is. We've heard about the portfolio funding, and it could be argued, there may be a perception that if people are not, if it's not made aware that there is that at least relationship on a firm level, it could be perceived that that arbitrator may well favor the firm with the benefit of the funding because of not wanting to having an alternative agenda for his or her own firm. So the whole issue of conflict of interest has certainly been, I think, the leading motor for discussion in this space in the last few years. And I think what we saw back in 2015 is when it really all started kicking off. There were a number of initiatives, the IBA, but also there was Queen Mary issued one of their surveys, and in which 76% of international arbitration practitioners surveyed agreed that disclosure of the existence of a third-party relationship should be mandatory. So this is back in 2015, I say, and 63% agreed that disclosure of the identity of the funder should be mandatory. So this has been evolving, I think, with ever greater pace since 2015. As I mentioned, the IBA and ICA have also had task force looking into the question. The IBA guidelines on conflicts of interest 2014 arguably was the first regulatory instrument to extend conflicts of interest rules in international arbitration to funders. And so, as we all know, they're not binding in the absence of an agreement by the parties, but the IBA guidelines are increasingly seen, I think, as representing the international standard for determining conflicts of interest and independence of an arbitrator. And there, the guidelines define third-party funders as relevant to a conflict analysis if they have a, quote, direct economic interest in the award. I'll come back to that in just a moment, because I think it's we need to pause for thought on that. And that really, I think, is the basis from where we are seeing the momentum in the various rules. The ICC has long favored approach that the party should disclose the existence of third-party funding. That goes back to 2015 again, in their decisions on costs in international arbitration. And the ICC allowed tribunals discretion on the issue, meaning that the tribunal could order disclosure of funding information if it believed the third-party funding exists. Things moved on, and furthermore, in 2016, the ICC's note to the parties and arbitral awards on the conduct of arbitration stated that arbitrators should consider, quote, relationships with any entity having a direct economic interest in the dispute or an obligation to indemnify a party for the award, end of quote, when making disclosures, which would include a third-party funder. And then in the latest version of the ICC rules, this is Article 11.7, I'm not going to read it out in detail, it's now made it finally mandatory for parties to disclose the existence of third-party funding and the identity of the funder. Having said that, though, the disclosure of even though it's now mandatory, the disclosure of the third-party funders, its scope extends only to, quote, the existence and identity, close quotes, of any third-party funders, and does not require the disclosure of more detailed information, for example, the funding agreement itself. And the ICC also adopts a rather broad definition of third-party funding, referring to it as, again, quote, an arrangement for the funding of claims or defenses under which a non-party has an economic interest in the outcome of the arbitration without particularizing any contingency requirement or conditions in the arrangement. And as to what might qualify, you will legitimately ask, an economic interest, the 2021 ICC guidance note clarifies that the following circumstances would not normally fall within the scope of disclosure under this Article 11. They are intercompany funding within a group of companies, fee arrangements between a party and its counsel, that I do want to just repeat, fee arrangements between a party and its counsel, or an indirect interest such as that of a bank having granted a loan to the party in the ordinary course of its ongoing activities rather than specifically for the funding of the arbitration. In the interest of time, there are many other rules. I just refer you to Singapore International Arbitration Center, Hong Kong International Arbitration Center, Vienna International Arbitration Center, and of course ICSID have all, in its most recent rules, adopted a disclosure requirement. So there is this growing momentum. And before I kind of, in the interest of time, wind up this long answer to your question, Cornell, let me just say, I think one issue that's still out there, and I think the elephant in the room is the bit I read, and I was deliberately focusing on the ICC because that's arguably the most developed, but the exclusion of fee arrangements between a party and its counsel. I don't know the statistics, we probably never know, but it's arguable that the lawyers are probably the biggest funders of all funders. And I think that relationship leaves a lot to be desired. It strikes me, there's a blatant conflict of interest of all of us to not really have to face that and put us under rigorous ownership. But I don't understand why it's justified on the basis of client confidentiality. But if you are being funded by a law firm, don't you need to know that as the opposing party, as if it was being funded by someone else? I leave that as an open question. I think it's one of those ones that people rather not look too closely at. But actually, I think the reality, if we're being truly transparent about it, and if we are behind the move towards transparency, that's something we will need to look at even more closely. I think for the time being, it's definitely more the focus on the traditional funders, for want of a better term, but things are moving, and I think this is going to be the subject of ongoing debate, and hopefully debate here going forward.
Cornel, can I say one word? I couldn't agree more for one thing, but I think we should not forget that, you know, the discourse is about, you know, impartiality and independence of arbitrators. And I think for that reason, you don't need to disclose the lawyer, because the lawyer is already known, if you just think it from the conflict of interest purpose. And I think that's sort of the rationale. And I think we are, you know, trying to get more and more information because we want to know what is the influence. And if we go down that road, I completely agree that it also should be known to the other side whether, you know, the lawyers have an interest or not. But in terms of what do you need to know from the funding agreement in order to determine whether there is a conflict of interest, it's really just the name of the funder and the fact that the case is being funded. Because if you start to disclose or have a mandatory disclosure requirement of the whole funding agreement, you know, each funding agreement is really tailor-made. It contains a sophisticated pricing mechanism that when it's being read, even only by the tribunal, it can reveal the strategy behind the case. Maybe you have built-in incentives for an early settlement as a funder. If you read that, you could conclude, oh, maybe the case is not that strong. That's why they, you know, are betting for an early settlement. Or there are other issues in the agreement which really would give the other side a complete unfair advantage if it would be disclosed and has no bearing on the purpose of the disclosure, which is to avoid a conflict of interest on the side of the arbitrator. And that's, I think, what we always tend to forget if we talk about the disclosure. We always want to know more, but such is life.
Just an additional point to make in relation to disclosure, which is actually really interesting because arbitration is in this way different to litigation. So when you're wrapping up an award and arguing for payment of your costs, in arbitration, in recent cases, there have been awards of third-party success fees as part of the award of costs, and that's not allowed in traditional courts in litigation, but has recently been allowed in relation to arbitration awards, which arguably gives a benefit to arbitration over litigation. But to the point of what is reasonable to disclose, I think, you know, obviously there are arguments for and against of how much of your funding arrangements you should disclose. But in terms of requesting your success fee as part of your costs order, then arbitration panels have argued that at the very least you need to disclose that your claim has been funded to the other side in order to merit the return of your success fee. If they were unaware that your case was being funded and didn't have an opportunity perhaps to factor that into discussions potentially around settlement, then the tribunals have argued that would not be reasonable. So at very least that is something to bear in mind at sort of the outset, as should we disclose the agreement itself, regardless of how much of that agreement you decide to disclose.
Cornel, I can't resist the the temptation just to pick up on what our keynote speaker, Professor Berman, was talking about. This may be one area of the recovery of costs where arbitration could be a positive way of developing the law and leading the way for courts, as setting an example. So I think when we were hearing about courts being concerned about actually arbitration, perhaps diluting the gene pool in terms of what it can offer, this might be, because I don't understand why that distinction there should be that distinction between international arbitration and courts.
Yes, I agree, and I think there is opportunity for arbitrators to lead the way in various areas of law, and the courts, you know, could take inspiration from what arbitrators do. Now, we have limited time, obviously. What I would suggest you is to take a new round of questions and then pause for a moment and address to the room. If there are questions from the room, we will take them after the following round. If there are no questions, which I doubt, because I already see hands which are waved at us, we will continue with the questions. Now, Lucy, let's assume that after discussing with the party who is interested, you, as an advisor, realize that maybe customary or not necessarily normal, but standard litigation funding is not the best option which is possible for that party, but some other options could be available, such as insurance or other options. How do you make this assessment?
Yeah, so I guess it goes back to that first point of really understanding why the claimant is looking for funding and what their objectives are, what they're trying to achieve.
But the idea is that when you're talking about, you know, ways to solve an issue, litigation funding is not necessarily the only answer.
Correct. So there are other options. Increasingly, we're seeing parties look to insurance. Managing litigation risk as part of M&A transactions is very well known, and it's a common product that's used in corporate transactions and when you're buying companies. But recently, there's been a lot of innovation around litigation risk management for live disputes, and insurers are always developing new possibilities in terms of insuring. The main difference is that if liquidity is not the main issue for you as a company and why you're seeking funding, insurance is a good option because in most cases, it provides a cheaper alternative and enables you to simply insure your own costs that you expend in deciding to litigate. So your legal fees and your expenses can be insured. There's a product called Capital Protection Insurance, which you may have heard of, which enables you to offset the risk of you losing the case and, you know, never seeing a return of that investment as a business. And that is something that we always talk to clients about as an option. Increasingly, though, alongside funding, we usually talk about an insurance product to go hand in hand with funding, which is after the event insurance, ATE, which ensures that you can cover your costs if you lose the claim and then are asked to pay the other side's costs. So usually that will form part of a funding agreement in most cases, and as well as the legal budget, a funder will often pay the insurance premium to cover that ATE expense as well. And that's, like I said, something that very much goes hand in hand with the discussion around funding. In most cases, we are actually seeing funding and insurance working together, but then increasingly we're looking at companies who are looking at insurance as a standalone option.
Okay. Now, the funder is in, the door has been opened, the funder is in, and the question is what happens with the management of the claim? There could be a situation, for example, Joe, there could be a situation in which the party would be interested to settle, but the funder may have other thoughts. How are these things handled?
Well, it may well, and cutting straight to the chase, I mean, there has been, I'm sure it's not been missed recently. For those who really are against third-party funding, this may be the case you've been waiting for, because it's people are all over it. It's a case that was filed in Chicago, the Cisco court case against Burford, which is the biggest litigation funder, I think, in the world, they claim. And it's kind of eye-watering when one looks at it. I think I should just say, as we've been talking about disclosure, I'm not involved in the case, so my understanding, I don't have any insights other than what I've been reading in the legal press and the main press about it. But it's an enormous case, and essentially it's alleged that Burford had advanced up to 140 million. I repeat that, 140 million in costs to fund the company's antitrust litigation against some chicken, beef, and pork suppliers last summer. Cisco reached proposed settlements with several of the defendants. But things seemed to go wrong because Cisco alleged that Burford undermined those settlements and brought arbitration proceeding to enjoin Cisco from finalizing the proposed deals. And so the arbitration panel issued a temporary restraining order at the end of last year. And Cisco's lawsuit, this is why we all know about this, because obviously it's out in the public domain from the court filings, to vacate that order. In essence, Cisco was arguing that in the case that it was a litigation hostage that was being forced by a greedy funder, their words, not mine, so don't take it personally, to keep litigating cases that it wants to resolve. Obviously, Burford have a different view on all of that. What is interesting on this is that Cisco also had to go to his own counsel in that case, who it claimed was secretly in cahoots with Burford and as betraying Cisco by aligning with Burford in the hope that the continued litigation would boost the law firm's contingency fee. Essentially, Cisco's position is, look, you know, Burford, as many funders say, they go out of their way to say we don't interfere, in a nutshell, certainly within settlement decisions. And they're saying, look, you're in breach of that. Their claim is, as with all these things, there's another side of the coin. They claim the relationship was excellent until Cisco started entering into side deals with some of its customers, where it was going to assign a potential of whatever it recovered to them, which therefore would have diminished potentially what Burford would have been getting. So it's very much on its facts. Burford themselves say this is an exceptional situation, and they make great pains to point out that they don't normally get involved. I think the reality is they are involved. They have money at stake, but it's a grown-up, normal conversation. You would expect them to be involved. It would be my candid observation. So I think to think that they just sit on the sidelines and just twiddle their thumbs is naive. But the reality of it is that, in my personal experience, it's all, I mean, when you're dealing with money, it's all about time and cash and turning money around. And so actually there are a lot of funders who would actually prefer things to be settled sooner, because that means that's money that they can use elsewhere. So I don't think it's as black and white as it's portrayed. And I don't think, you know, those, as I say, that may well think that this is the one that's going to bring down the whole house of third-party funding may well be disappointed. But it is illuminating, because, you know, we really do get to, for the first time, be able to look under the bonnet, so to speak, and also just to realize, the numbers of potential funding involved. And this is not an insolvent company. This is a multi-billion turnover company. So it shows the extent of where third-party funding is being used. And again, from practice, we're seeing increasingly where you get clients wishing to hedge their risk by getting third-party funding in. So the answer is, I suppose, it depends. As always, I think in this case, it was very much the specific circumstances of the case. Obviously, we'll have to see how it all transpires in the end. But generally speaking, it's not a good image for anybody, I don't think, certainly. But as I say, I think generally speaking, I would expect them to be involved, but certainly not putting a hindrance or in this type of scenario, which would be, I think, the nightmare type of scenario, because it's not, as I say, good for anybody.
Can I cannot refrain of not saying something on that particular case, because really I think it's quite symptomatic that these kind of cases where funders are being sued is at the core is a breach of contract by the client. I mean, you enter into a funding agreement and you do all your work, and at the end the funder has to secure that it receives its return. And what happened actually in the Cisco versus Burford case is that the original funding agreement did not contain a control right, but it contained a provision that prohibited Cisco from divesting collateral without Burford's consent. But they did this. And so they had to renegotiate the agreement in order, because, obviously Cisco recognized that they did something that they shouldn't have done. So they renegotiated the funding agreement, and only then did Burford get consent right with respect to further settlements. And Cisco again breached this and entered into settlements that would even, they settled for such a low amount that not even the investment, the 140 million that Burford had put into the case, would have been able to, be paid back to the funder. And that's when the funder said, hey, listen, I mean, we gave you all the money, we helped you to get to a way where you now can negotiate settlements, and now you're, settling beyond the line where we would receive back our sort of investment. And I think that is the problem. So all these disputes sort of arise at the moment when the client has already got the share, has already reached a certain stage with the age of the help of the funder, and then really breaches the agreement in doing that. And usually, I mean, with respect to settlements, as Joe said, funders like settlements. Sometimes we even, put in the pricing mechanism incentives for early settlements, because you deploy money over time. Everyone gets back the money, the better for everyone. And in that sense of control, exercising control or not, I think continental European funders, they do not want or cannot exercise control, because otherwise they would act as a quasi-lawyer advisor, and then the quota litis prohibition kicks in, that puts the success fee at the risk. But we would more act like a sparring partner. Some decisions will be discussed with the funder, but that strict veto right, as we had seen here in the Burford case, usually does not exist, and is really a result of the particularities of the case.
Yeah. The one nuance on that is that I think actually Burford did say they were not happy with the proposed settlement. So they actually went contrary to an express state. And that's an interesting debate as to whether, of course, Cisco said it was a reasonable settlement offer and they shouldn't have objected. But yeah, I agree with what you said.
Alice, is there any preferred profile of the cases which are funded? And I'm thinking, about investment cases. Are they preferred? Infrastructure cases, are they regarded with more cautiously than other type of cases? And could you elaborate on this?
Well, the first and most important issue is you have to have proceeds at the end that you can share with the funder. So any sort of only declaratory claims is difficult to fund. This is also why defense funding is much more difficult unless you have a counterclaim, because you need something to share. So in types of cases, I think all areas of private and commercial law, even inheritance disputes, even funding of the insolvency estate on behalf of the insolvency administrator is thinkable. And usually funders would focus on corporate and contract disputes, or energy and infrastructure, or intellectual property, especially in the United States. I think when it gets more difficult is when the case is very fact-based, when you have a lot of witnesses, where you don't know. I mean, you all know that sometimes your own witness is the biggest enemy. So that's why also construction disputes are usually rather difficult to fund, because you have a huge you have huge amount of facts. You are reliant on experts that come to very different, numbers, depending on the method that they deploy on calculating the damages. So here you really have, probably as an external DD expert for the funder, an accountant or a damage expert that really gives you comfort on that issue. So yeah, but everything is possible, and I think it's always worthwhile to approach the funder, because they will give you immediately thumbs up or thumbs down if they think that this is fit for funding. And as Lucy said, it's worth shopping around, because different funders have a different focus.
Okay, so I promised that we would take some questions from the audience. I saw at least one person, please.
Thank you. Do you have microphones, or I think we probably don't need one with my voice. Quick question for Lucy.
I'm not so sure about our online audience, so if we have a microphone, that would be helpful. It's okay? Okay, good.
Thank you. The first question was for Lucy. Lucy, you mentioned the recoverability of funding costs, which is something I'm quite interested in. And I know that some courts have been willing to include the cost of the uplift. So for example, if the law firm is working on a CFA, they'll allow that uplift to be recovered by the claimant. Have you seen cases where the actual multiple that the funding is being funded under is considered? Because I can envisage cases where the recovery is such that the funder is getting 95% of the recovery and the claimant is getting a very small amount of the recovery. And it would seem that if the tribunal is unaware of the multiple or how that works out, that may or may not factor into what they think is a fair and just resolution of the dispute. So have you seen the cost of funding be extended to the actual multiple that claimants are required to pay to the funder?
So just in terms of that particular example, so currently with tribunals, there isn't any really clear guidance for them in terms of the circumstances in which they should be awarding those costs, and to the extent which they should be going into the detail of the funding agreement to look at what are the multiples, were they reasonable, how much should we actually agree to add to the costs award. So in terms of the tribunals, it's very much a sort of an ad hoc approach around what they feel in that particular case is reasonable. We've only really seen it a handful of times, because up until a couple of years ago, I think it wasn't just simply not permitted. After the Jackson reforms, it's the recoverability of third-party funding costs was simply not allowed. And it's only now under the Arbitration Act that tribunals are starting to sort of read into the wording around what can be included as part of a costs award, and they're starting to sort of reinterpret the extent to which funding costs can be recovered. I think it remains to be seen to the extent that multiples are awarded, and the extent to which those multiples are awarded and at what level. And I think that is just very much an outstanding sort of point around having some clear guidance for tribunals on that. And I think that is still to come.
Yeah, I mean, what I've seen, those those judgments or awards that have been out there where the arbitral tribunals have awarded, they had made it a precondition that the other side had given rise to funding being used, being sort of that they have put the other side in a financially situation where they could not have pursued the claim without funding, and therefore they have said, okay, you should be compensated for that one. And a situation where the funder takes 95% of the claim and 5% is with the claimant, I think then the whole funding agreement was not really well negotiated. You would have had a totally inflated claim on which you base the budget, and when you then only receive 10%, of course, then probably that could be the case. But we would avoid that, and if that is a likely outcome, that would be a reason why we decline funding, because that's not what at least we want.
No, that was exactly the point. I think it all depends on the facts of the case, and if the other side is responsible for putting you in that, the obvious examples in insolvent company, for example, where you have no resources, you've had to go, then I think it's entirely within the discretion. And so even in the scenario where you have that 95% recovery, I mean, you may not get awarded all of that. A tribunal will be open, I think, to saying, well, what would be a reasonable recovery? So it is a little bit, it all depends, and it's up in the air. But I think that certainly there's a growing exception acceptance that is a potential that heads of damage, basically, for recovery.
Any other questions?
Joe has touched upon an interesting point, and I think I would like to hear more, namely the idea where the funder is the lawyer. And I have two questions. Where is the threshold where one can tell that the lawyer is the funder? Because in between the two extreme situations that I can imagine, one or left extreme, the lawyer advances all the costs exactly like a funder and then is a funder. And the other opposite is the typical situation where the happy lawyer is billed on hourly rate basis and it doesn't advance anything. In between, I can imagine 1,000 shades of gray. And a lawyer that only defers the payment of a success fee and is very generous with not charging a fixed fee is financing the case. This is the first question. And the second question is, are you aware, is it legal in any jurisdiction for the lawyer to actually be a funder under the statutes organizing the legal profession? Thank you.
It's always good to know you make an interesting point. So it's I think, well, dealing with your second question first, number one, there is no distinction. I think effectively, as it currently stands, if you're, however it's framed, if it comes under the umbrella of client-attorney relationship, then it really doesn't matter how you structure it, is my understanding. And I think, it is out there for discussion. And I can see why, in one way, it's a bit like a professional privilege issue, which is almost a little bit too complicated, that year on year we have debates about which jurisdictions privilege applies to. I suspect this may be one of those thorny issues where we just kind of bat it away, but I'm also slightly concerned that the reason we're batting it away, as I say, is because there is an inherent conflict and interest that it's in our own interest not to really address it more transparently and head on. But so to answer the first question, I don't think there is, as you say, I think there are several shades of grey in there, and I think the fact that you are the lawyer, and that's effectively the cover, certainly as the ICC, as I read their note, would say you're covered on that. And as for the legality, I think it was back to what Sarah was saying. Essentially, certainly in the UK, you can have uplifts, which is one form of funding, if you like, that is certainly recoverable in the UK. So you wouldn't be called a funder in that sense, well, strictly speaking in that sense, but that's a form of funding that is recoverable.
Can I just wanted to add that, in the most jurisdiction that I'm responsible for, like in the CEE region, purely contingency fee agreements are prohibited, and also the amount of success fee really depends on the bar rules and on the jurisdictions. Some have, for example, in Switzerland, the rule is that the portion of the success fee cannot be greater than the fixed fee. In other jurisdictions, it must not be excessive, for whatever that means. So in that sense, you're really in a gray area when you deploy that. But what we see sometimes is that, the lawyer, they also take a sort of share, like a bit skin in the game, that they say we work for a slightly reduced fee, and then if the case is successful, we also get a portion of the award, but never sort of a proportion of the actual sort of proceeds, but just the uplift on the hourly fee, because otherwise that would again go against the prohibition of quota litis agreement in most of the civil law jurisdictions. So it's much more complicated than in the common law world.
Any other questions? Oh, please. For sure you can, but we have people online, and for them it would be difficult to hear what you have to say.
Thank you. It was mentioned in the beginning that funding is more often than not granted to claimants. And my question is, taking that into account, are respondents eligible to being granted funding? And if yes, are there any particular additional steps that a funder might consider when assessing granting him a funding? Thank you.
Well, I think respondents are equally eligible, especially if there is a counterclaim and then you have proceeds that you can share. if there are, if it's a mere defense funding where the best case scenario is that you don't have to pay what you have been asked to pay by the claimant, then it's difficult, because what can you share with the funder? That you don't have to pay anything. So two issues are important. First, you have to define success. What does success mean? Is it only if you are not asked to pay anything? Is already a success if you only have to pay 50%. So I think this has to be defined. Then the second issue is you need a collateral as the funder. So you have to put away the potential success fee that you have agreed somewhere, so that the funder can have access to that money in case you decide you don't want to pay. Or you put defense funding into a portfolio of sort of cases where you are on the claimant side, where you actually wouldn't need funding because you're pretty sure that you're going to win, and with that you kind of cross finance. Or you have a squeeze out situation when you are asked to leave as a shareholder, and you will receive a certain return for being squeezed out, that you can share. But if there are no proceeds, I think it gets so costly for you as the defendant to put away some money or the success fee on an account, trustee account or whatever, to ensure that the funder at the end receives the success fee, which is not only the costs that has been advanced, but also a multiple on that.
Okay, so we're obviously running out of time. We started a little bit late anyway, but still. And we have covered less than half than what we have aimed at. I would invite you to make a few concluding remarks before we wrap up, we end our panel. Lucy?
Yeah, sure. Yeah. Okay, so I mean, I suppose from my perspective, as someone who works as an intermediary, working with claimants and with law firms, I mean, for me, the biggest takeaway that I, like law firms and claimants to think about is really about not rushing the process of obtaining funding. It's really important to approach a funder at a time where you've got a proposal that is compelling. The litigation funding market has a reputation for being opaque, for being very slow, for being very expensive. And part of my role as an intermediary
undeserved
is
reputation,
yes,
probably.
well, perhaps undeserved, but in some cases. But actually, the process is slow, and part of what we try to support law firms with is actually by the time they've gone to a funder to speed up the process. So often, law firms are in a really big rush to get their case funded. Claimants quickly taking their case to market.
Any minimal value of the claims, or is
so well, in terms of value, the economics essentially have to work. Any value can work if there's a decent ratio, so that the claimant can take home a decent return and the funder can take home a decent return.
So the door is open to everybody.
The rule of thumb is basically roughly 1 in 10. So for 100 million in damages, you'd be looking at a budget of roughly 10 million. But that varies between funders. But I think in order to speed up the process, actually what you need to do is slow down, make sure that you prepare your case properly, and that you take good advice, that you build an investable opportunity, as it were. And then by the time it's sitting with a funder like Alice, they're going to be in a much stronger position to give you a yes or no quickly. And actually a quick no in itself is very valuable, because you don't waste any time with on the process. And in terms of its reputation for being expensive, it's important to create competitive tension. We know that competition helps to bring prices down. And so, going out to market and getting an opportunity for more than one offer means that funders are competing against each other, and you're more likely to end up with a good offer. So yeah, those are my tips for you to take away.
Alice?
Yes, thank you. Well, I think I want to conclude with, asking myself and yourself, is sort of, are funded cases stronger than non-funded cases? And I think there is you never know. I mean, we all know that, you know, in litigation, in arbitration, we have won cases where we thought we will lose, and we have lost cases where we thought for sure we will win. So in that sense, you always have this risk element. But at least if you have a funder on board, you have a second opinion of an independent person who has only a commercial interest and who is willing to put into the money because believes in that claim. And I think that can help also in deciding for a company, should I bring this claim, yes or no, irrespective whether I have the funds or not, but you know, is it strong enough that someone else would put in money? And I think it also sends a signal, and that's why I'm rather pro disclosure, a signal to the other side that someone else was willing to put in money. So also it can help, you know, to negotiate settlements at quite an early stage. So there are advantages that you might not even think of. Yeah, that's my concluding remark. Thank you.
And I would just say that, well, I like to think myself as a guy, a glass half full kind of guy. So on the positive side, I mean, third-party funding is here to stay. You can see the way it's evolved. It distresses me. I would say it strongly as that a client of mine based in London can have access to third-party funding, but a client of mine based in Ireland can't because it's against the law there. That doesn't seem inherently fair to me in terms of access. I think there are issues there, so I don't think we should, and we've touched on some of these issues, but I think most of them are addressable, both in terms of changing the rules and actually, frankly, just coming more into the light. Part of the problem with third-party funding is it lives so long in the dark, and when you don't know something, people become suspicious, and it's ignorance that kind of breeds but I think coming out, for the reasons that Alice have just said, can be a real force for good, and generally, I think courts accept it because of the access to justice and the ability to shift and lighten the court docket elsewhere. So I think overall the pros outweigh the cons. There are issues there to be addressed, but on the whole, it's as I say, I think it is a force for good, and it's something that that you can certainly help yourself. I think in terms of the preparation, you're right in terms of if you prepare your package that you go to. It's worthwhile taking a little longer preparing your package, I think, when you approach a potential funder and then giving them really all they need. And in that, there is an interesting relationship. On that, I would just, because you have your client relationship, but there is a quasi-relationship with the funder. They're not your client, and you make that very clear. But equally, you know, you are making representations to them, so you have to tread very carefully, and you really want to be, as I think, as transparent with them as you can, including identifying the problems. But if you're smart, you're not just identifying the problems, you're also highlighting the solution to those problems. So you need to anticipate all of that, and that will really save a lot of time and convince a potential funder that you've got a claim that is worth investing in.
Okay. Thank you so much. Thank you to the audience for the patience, and thank you for the organizers for making this possible. Thank you.
Okay, thanks everybody for coming back. My name is Andrew Mackenzie. I'm the Chief Executive, there I am, of the Scottish Arbitration Centre. It's a great pleasure to be here. Thanks to the organisers for asking me. Just responding to Joe's comments about the Brits not getting excited. Well, let me tell you, I'm excited, but then I am from Scotland rather than England. So the Scottish Arbitration Centre is a promotional body doing ad hoc appointments, providing hearing facilities and offering training. But since September, we launched as an institution with rules and a secretariat offering administration for cases. So I'm delighted to be asked to be here because I can learn from these experts about what I'm letting myself in for. So let me introduce them, and I'll start with the local. That is Roxandra Chiru. She's the Deputy Chief Assistant of the Chamber of Commerce and Industry of Romania. She's an in-house lawyer there working at the Court of International Commercial Arbitration attached to the Chamber of Commerce. We have also Stefano Azzali, and he is the General Director of the Milan Chamber of Arbitration. He is a lawyer and arbitrator. He's also a visiting professor of arbitration law at Bocconi University School of Law in Milan. We also have Niamh Leinwater. She's Secretary General of the Vienna International Arbitration Centre. A lawyer, she previously worked at various international law firms in Austria. Niamh is from the Republic of Ireland originally, though, and was once an attaché at the Embassy of Ireland in Vienna, where she organised and coordinated the embassy's events relating to Ireland's national holiday, St. Patrick's Day. I'm not sure why you left that job, to
I've
be
never
honest.
been introduced with with that aspect, but yeah, it was a very fun job.
It was the best thing on your CV, to be honest. So, we're here to talk about the essential role of the Secretariat in terms of institutional arbitration. Now, I would say in terms of the various stakeholders involved, we are the most important. But let us understand a bit about the different types of arbitration and how it's processed. So looking at, for example, ad hoc arbitration, as well as institutional, as we try to at least explain the background for you. So, Roxandra, maybe you can explain a bit about ad hoc arbitration before we talk about institutional arbitration.
Yes, thank you very much. First, I would like to welcome you here in Bucharest, together with my colleague. We hope you like here. And also, here is the seat of the Court of Arbitration and the seat of the Chamber of Commerce and Industry of Romania. So, welcome. For second, I would like to start with a brief introduction of ad hoc arbitration. Ad hoc arbitration means arbitration organized on the basis of an arbitration agreement concluded between the parties, organized by the parties or by a third party other than an institution, arbitration institution. Ad hoc arbitration is conducted without resorting to administrative authority and usually without the aid of institutional procedural rules. It depends entirely on the cooperation of the parties, who must appoint the sole arbitrator or the panel of arbitrators that will resolve the dispute without institutional oversight and must define their own applicable procedural rules. National arbitration laws and national courts generally function as a last resort to correct procedural errors in arbitration or to settle procedural incidents such as challenges or of arbitrators and others. However, parties sometimes adhere to pre-existing set of procedural rules intended to govern ad hoc arbitration, such as UNCITRAL rules in international arbitration or the fourth book of Romanian Civil Procedural Code in domestic arbitration in Romania. Also, party may designate a nominating authority other than the national court, with power to appoint arbitrators if the party do not agree on the appointment, or with power to appoint the chairman. But why the parties choose ad hoc arbitration? Essentially, parties favor ad hoc arbitration when they wish to be in control of the arbitration proceedings rather than subject to institutional management or control, usually when the amount in dispute is not significant or when the parties are unable to agree on a certain institution. On costs, maybe at the first glance, ad hoc arbitration may seem to be less expensive than institutionalized arbitration because there is no institutional secretariat to pay. However, even in ad hoc arbitration, the arbitrators themselves or the secretary appointed by them will have to perform basic administrative functions, which may incur expenses equal or greater than those of an arbitral institution. In addition, if judicial intervention is required, the cost of representation in court may be substantial, and also the arbitrator's fee are established by arbitrators without any control of an institution. Thank you.
Thanks very much. Yes, so there's a bit about ad hoc, so arbitration that operates without an institution, without a secretariat supporting. But Stefano, can you explain a bit about what we mean when we talk about institutional arbitration?
Thank you very much, and thanks for the invitation. It's really a pleasure to be to Bucharest. In a nutshell, as we heard, ad hoc, our colleague just mentioned that parties do organize the process. In institutional arbitration, parties still can organize the process. So there is no, let's say, lack of party autonomy recognition. Parties' autonomy comes first, also before an institution. But if they fail to do so, and I think we all have in mind how many arbitration clauses poorly drafted are around the market, we call them monster clauses. We know that they don't do it. Parties, they have the power to be detailed in governing and in administering the process, the rules of the game. It's not a game, of course, it's a dispute, but they fail to do it. So if you are in an institutional environment, you have, as in the back of the party's autonomy, you have a set of rules that stands for, gives you the rules of the game as for the process, as for the fees, as for the rhythm, as for the time, the duration, and all that kind of process, the rules of the game. If you are in an institutional framework, parties are still free to govern the rules of the game. If they fail to do so, the rules of the institution, the chosen institution, will come into play. Plus the structure, the secretariat, the people, the offices of the chosen institution will support parties and the arbitrators for a smooth and effective and efficient conduct of the process as a kind of tutor role within the process. This is, I cannot be shorter than this, so I would not add much because that might take more time.
I would have been sad if you were shorter than that. Niamh, do you want to add anything around, for example, why parties might pick institutional or ad hoc and the sort of things that parties and their counsel have to think about?
Sure. I have to start by thanking the organisers for the invitation. It's a pleasure to be in Bucharest, not just because of the beautiful weather and the impressive buildings, but particularly for me, the people. So I think you have a very special arbitration community here, and it's a pleasure to be here. I think there are a number of points that I would probably draw out as advantages of institutional arbitration. And because, Roxana, you said about the costs, I think the predictability of the costs for parties is important. But what we also see is a trend towards, if there is an ad hoc arbitration clause, that actually the arbitral tribunal asking the institution, and many institutions have this ability to act as an appointing authority or an administering authority. And one of the main motivations from arbitrators is because they have difficulty opening bank accounts with all of the money laundering regulations that they face at the moment, and they want to simply take the burden away from having to deal with the costs and advance on costs and discussing fees, etc., with parties. So I think that's a huge offering that an institution has. The second point that I'd make briefly is the monitoring of the institution. So not only the support network that we provide for hearing facilities, etc., but also trying to support the parties in getting their award on time. And the final point I'd make is the support on appointing arbitrators, removing arbitrators. And we heard in the keynote speech this morning about the role of courts in arbitral proceedings. And in my experience from counsel times, you know, if you do end up actually in a state court looking for the president of a court or whoever it is that is the appointing authority, it may be a difficult situation for the individual judge who doesn't have the requisite experience in arbitration, and maybe also not the ideal outcome for the parties. Whereas in an institution who is appointing on a regular basis, they have the knowledge and experience in, you know, finding the suitable arbitrator for your case.
Okay, thanks, Niamh. I mean, there are also different models of institutional arbitration. So different institutions have different approaches. And that could be a very light touch approach where the tribunal is really in charge. And the alternative is that the institution is very much involved. So you're all involved in your own institutions, and maybe you could just touch on a bit about the models that you employ in terms of how involved you get in managing the cases. Stefano, do you want to start?
Thank you. Well, I tell you, the Milan Chamber arbitration system is nothing new. I mean, and today I think that if you look around the institutional rules and systems, they are pretty all the same. We sometimes one institution is trying to have, you know, some revolutionary idea or proposal, but at the end of the day, the system is more or less the same. How it is applied, then it makes a difference. In Milano, we have, let's say, a very light approach as for almost everything, not on everything. We have an hands-off approach on the process, on the rules. The rules of the game, again, are with the parties. But we have a quite hands-on approach on two issues. One is the control of the neutrality of the arbitrators. We are obsessed by the control of the arbitrators' neutrality. We do confirm all the arbitrators. We are quite severe. That's something on which we really believe that you know, we can succeed or not. Secondly, the duration of the case. That's something on which we do control. We do act. We do exercise our role. Last but not least, I would say that a feature we do support from a secretarial point of view, the process. We welcome hearings at our premises. Now they are still, they were telling me, around 70% still in remote mode. But before the pandemic, we had something like 250, 300 hearings at our premises. So, and in each hearing, one of our case managers does attend. That is something that you really have, I would say, control is not, let's say, a look to the process. You see how the arbitrators do perform. You see how the parties do perform, their counsel do perform. You really follow almost day by day the process. And that's, I think, is a key feature of the Milan system.
Yeah, that is interesting because lots of institutions are not involved at all.
It's a question of money. It's a question of money.
Yeah.
Because if you have 800 cases as the ICC, for example, I think it would be very difficult for them to have one case manager to every single. First of all, they cover the world. So how can they send someone in Asia or in Latin America? So we are a regional institution. So Italy and let's say Europe. And then, of course, I'm thinking of the hearings that they were taking place at that time in Milano or in Italy, because we have also an office in Rome. Then it's possible. The day we will have 5,000 cases, never in a lifetime, but that's, you know, who knows, then we will stop having someone, probably a case manager in every single hearing. But so far, but it's a question of money also.
I think after being at this event, it could well ratchet up to 5,000. Ruxandra, do you want to talk a bit about the chamber here and the approach that you adopt in terms of whether it's light touch or how involved you are as a secretariat?
We also have here at the Court of Arbitration a light touch in managing our cases, and in this means, for example, when after the arbitral tribunal is established, we have a minimum involvement in the case. We let the arbitral tribunal do their job, but we also participate to each hearing as arbitration assistants. So we are doing our job, but not messing with the job of the arbitral tribunal. And we have a maximum involvement, I can say, before the arbitral tribunal is established. So we are doing everything. We are taking the case. I will talk about this later when we will present our secretariat. But we don't scrutinize an award. We let the arbitrators do their job only when they are in big delay. We are telling them, but we don't have means to, I don't know, compel them to do something in a certain period of time. So I believe this is, in general, what we do here at the Court of Arbitration.
Thanks. Niamh, can you add, in terms of the Vienna Center, but also maybe talk a bit about an example where there might be a lot of oversight, where an institution is very much involved in what's happening?
Sure. So I would also say, have a light touch. I'd echo what you said, Stefano, about the neutrality of the arbitrator. So obviously that's something that I think as an institution you have an obligation to ensure that the parties are, that you're confirming arbitrators that are independent and impartial. The second point that I would say where we keep an eye on the case in particular is on the costs point, because that's, you know, one of our main roles. So if there's an increase in the amount in dispute or a decrease in, well, the decrease of the amount in dispute is usually irrelevant, but if there's an increase at some point, that we keep an eye on the costs, that the parties do have the correct amount at the advance on costs. But the third point would be the award. So two sub points. One is the monitoring of the award, so to make sure that to keep an eye on the arbitrators and making ourselves popular, or unpopular potentially. But Stefano has confirmed to me that if you're popular, you're in an institution, you're doing something wrong. So you know, keeping on the toes of the arbitrators and gentle reminders that when their award is due. That's the one point. And then when we do receive the award, we don't have the official scrutiny model that the ICC have. So it's not foreseen in our rules, but we do review the individual awards. We review them on the formal the aspects to make sure things, simple things like the seat of arbitration is the correct seat of arbitration, that the costs are correct, to avoid any kind of an application for correction, those kind of formalistic things. But we do also read the substance, and we will provide arbitrators with substantive feedback if we think that something is inconsistent. Obviously, you can only do it to a certain extent if you haven't read all of the submissions. And I think the decisive point is that it has to be proportionate to time. So we have an internal deadline whereby when we receive the award from the arbitrators, we try and turn it around within 3 days, because we don't want a scenario where we have been stepping on the arbitrators' toes to provide us with the award, and then the award, you know, gets lost in somebody's inbox at VIAC. So within 3 days, we try and provide both formal and substantive comments, and the arbitrators are obviously not obliged to implement them, but in our experience, they are actually very happy to get a second set of fresh eyes on the award. And I think that's essential to ensure that the institution is supporting arbitrators in providing quality awards.
But do you want to touch on maybe the ICC, for example, and the approach that it might take, which would go further than just your sort of checking to see if there's any obvious errors?
Yeah, so I mean, obviously I'm not from the ICC, so I'm not involved in their scrutiny process. And I know that it's much more detailed and much more much more invasive, so to speak, in the awards. So they're actually, you know, really getting into the substance and really providing arbitrators with suggestions as to how they may want to rephrase or redraft or reassess certain aspects of the award. And from what I understand how the system works, there are a number of steps. So I think the general feedback is if the period of time that is required to provide that kind of substance, the question mark is whether or not it is beneficial in the long run. So I think you know, absolutely scrutiny of the award, but I think it needs to be proportionate to the amount of time that the actual scrutiny takes.
Thanks very much. Now, there is sometimes criticism of institutions and institutional arbitration. They often are linked to cost, so the time it takes, and neutrality of arbitrators, which we talked about. Roxandra, can you touch on some of the criticisms around cost and whether these are reasonable criticisms, bearing in mind that every institution will have its different approach and different levels of costs, and maybe how that might compare to local courts, for example, if you could touch on the costs issue.
Yes, thank you. I know this kind of criticism is widely discussed in Europe especially, and also in Romania, but the main aspects are well known by everybody. Arbitration is sometimes considered a luxury justice only because of the charged fees, administrative fees, arbitrators' fees, experts' fees, attorneys' fees, meaning that this kind of justice is too expensive for all those who need it but cannot afford it. At the first glance, yes, but arbitration has many other reasons why it should be preferred to state justice, and two of the main reasons are quality of the process and specific specialization and experience of arbitrators. I believe this subject was also emphasized by the president of the High Court of Cassation this morning. I met parties that really considered that the arbitral fees are not so high because of the time that must be dedicated to the arbitration process, to the degree of novelty and complexity of the issues put before the arbitrators, and to the need of their documentation, constant documentation. I believe the right balance between what is given and what is offered has to be taken into consideration when judging costs. Of course, the quality and quantity and services provided by the arbitral institution is also relevant. In order to ensure lower costs for simple cases, the rules of arbitration in force since 2018 provide for a simplified procedure for lower valued claims. Sole arbitrator, if the party did not agreed on otherwise, limited duration of the process, limited evidences administered, and so on. On the comparison to local courts, I believe costs in arbitration and costs in local courts are similar from 2 points of view. Regarding the moment of payment, both have to be paid in advance in order to start the process, and also in Romania, in both cases, the costs are advanced by the claimant. On quantum, the cost in arbitration will in many cases be higher than the cost in court proceedings, but this depends on how attorneys' fees and other costs compare. I think that special rules on small and mid-sized claims make arbitration accessible and more convenient than court proceedings. Also, for large claims, we have to consider all the steps in reaching a final decision and the costs and time incurred to taking those steps. In arbitration, we have a final award that may be enforced immediately, and it may only be submitted for annulment to the Court of Appeal for limited reasons, and then only with recourse declared to the Court of Appeal decision. On the other hand, the national courts' decisions are not final and enforceable at the first instance, and may be rejudged multiple times, generating higher attorney's fees, higher administrative fees, and so on.
Yeah, thanks, Rusandra. Niamh, Stefano, do you want to add anything in on costs? Given that obviously there are different levels depending on the institutions involved.
Me first? Ladies first. I go first. Well, I don't know. I don't think there is a magic formula as for cost, because it's impossible. Arbitrators, they do complain. I'm thinking of, Milano. They do complain that they're not paid enough. Parties, they do complain they pay too much. So maybe we are in the right position. Maybe because if one of the two players will stop complaining, then I would be worried, because I would say maybe we are paying the arbitrators too much, or maybe we are not charging the parties too much. So it's very difficult. What we are trying to do, so there is no answer. What we are trying to do, and that's why we do follow the cases on almost a day-by-day cases, to know exactly what the work was, how difficult the case was, how much work the arbitrators did produce. You never get to the reality 100%. It's impossible. It's impossible. But at least you are aware. You have not the control, as I said, but you are aware of what happened. Because all of us, we do apply the fees based on the value of the dispute. And we have a minimum and a maximum. Where do you go? If the case manager did follow the case from the beginning, he or she knows, let's say, get close, to be honest. Get close to what was the real work done by the arbitrators, and can, place the fees in the, let's say, right position. But again, it's very difficult. We still don't have an answer to what is the magic formula. But, if they all complain, we're happy.
Yeah, I think I just add to that. I mean, one advantage I think that you do have if you're in institutional arbitration, like many of our rules do provide the possibility, like you said, Stefano, to increase the fees for the arbitrators if it's a particularly complex case, or if the arbitrators are particularly efficient. So then they'd be on the higher end of the scale. And in my experience, if it is a case where you see, okay, they were particularly efficient, or they got their award in, a very short period of time, the parties are very unlikely to object to an increase. So then kind of everyone is happy in theory. I mean, except the losing party, but the arbitrators are happy that they get a bit more. The parties are happy that they got their decision quite quickly. And that's that kind of tool you don't have in ad hoc arbitration or in the local courts. So, there is some positives.
Okay, stay with us, Niamh. Can you address the criticisms around time, though, and the time it takes, and look at that from the perspective of whether that is reasonable?
Yeah. So when I was thinking about, why does it take so long? You kind of think, who are the culprits for why, arbitration takes longer? And of course, it's not the institution. I'll just, spoiler alert. But I mean, the first point I think is, particularly complex case where you have lots of multi-party scenarios or something, that is also obviously going to take time. That's the nature of the dispute. Second, the parties, their inability to agree on arbitrators. So if the whole appointing process takes a particularly long period of time, or if they have unreasonable or very differentiating ideas of who their ideal arbitrator is, or this ideal arbitrator has not been born yet, which is, sometimes an issue. Classic dilatory tactics, numbers of challenges to arbitrators, which I feel is on the increase. Insolvency, inactivity, defaulting parties, all of these factors I think can, make the time period longer than necessary. The third culprit, I think, is, and apologies to the arbitrators in the room, the arbitrators. So one aspect, I think, is the due process paranoia. So, giving parties an unlimited opportunity to comment and re-comment and comment again, and unnecessary submissions and expert expert opinions and unnecessary hearings, where sometimes I think that maybe a heavy-handed tribunal would say, so enough, everyone's had, you know, their opportunity to comment, and we can't go do this forever. The finalizing of the award, like I said, if that takes a disproportionate amount of time post hearing or last submission. And another point on the arbitrators fund is the availability. So, you know, the availability of arbitrators that maybe, you know, is not always submitted at the beginning of the proceeding, or, you know, unexpected events maybe happen that make the arbitrators less available, and then coordinating with the tribunal can obviously delay the process. So they would be the culprits. And what can an institution do to counteract that? Because, you know, that's the position that we're sitting in today. I think the institution has the obligation to make swift decisions, so decide on issues as quickly as possible when it comes to challenges, when it comes to appointment of arbitrators, when it comes to consolidation, that we turn around those decisions quite quickly. Make sensible decisions. I think that also is relevant to impartiality and independence when it comes to confirming arbitrators, just because I think there's something that you might talk about, Stefano, just because an arbitrator discloses some kind of circumstances doesn't necessarily mean, in our case anyway, that they're immediately disqualified. So I think a sensible decisions from the institution will also reduce time. Electronic case management is another factor I think that can make arbitrations more efficient. You know, many of us administer our disputes on the Thomson Reuters platform. I think that speeds up the arbitration time in general. And the last point that I already mentioned is the award monitoring from the institution to try and ensure that, you know, there's not an unnecessary amount of time between the last submissions or last hearings and when the actual award is issued. And in fact, the you know, incentive that I talked about, this maximum amount that the arbitrators can get, can also be reversed in the other direction. So you can also, theoretically, we don't like to do it, but penalize the arbitrators if they're particularly behind schedule. But that's something that we obviously don't want to implement.
Thanks. I should say that other platforms are available, and indeed the Scottish Arbitration Centre has developed one with Opus 2. But Niamh, can you mention a bit about how the time that things take might compare to the courts? And I don't know if you want to use Austria or Ireland or any other examples, but not Italy, but give us an idea of if someone's trying to decide about arbitration or litigation.
Sure. So, well, our average duration of a dispute at VIAC is about 18 months, and I think probably a lot of the institutions are between 12 and 18 months. You know, it's a kind of a classic lawyer answer because it always depends on the type of dispute. I mean, the Austrian courts are quite quick and efficient, but if you're looking at, and I had this intense conversation with someone about this yesterday, you know, if you're in the commercial court in Vienna with a complex construction dispute, you have some poor judge there who is trying to mill through all of this material and all of these experts, and it will take longer than 18 months. I don't know if I want to shock anyone by saying how long it could take, but longer.
Excellent, thank you. Stefano, neutrality of arbitrators and the approach of institutions, that again is something that comes up as a potential criticism, so do you want to talk about that?
Yes, if I may, I would like to make a preliminary remark about criticism. I think that sometimes criticism to arbitration in general are grounded, and sometimes criticism to institutions are grounded. Not all the time, it depends. Like in many markets, there are good players, bad players, good restaurant and bad restaurant. In Italy, food is a real issue, so I know what I'm talking about. Don't throw away the baby with the water tub. It's not, stop saying arbitration is expensive. Arbitration can be expensive. That makes a big difference. Arbitration is slow. No, arbitration can be slow. Arbitral institutions do not perform well. That's not true. Some institutions do not perform well. It depends. So this is my pray, please stop thinking. Any generalization, I think, is dangerous, but in this case, I think it has to be carefully handled. Then as for neutrality, why it is a delicate issue? Because this is a clash between the fundamental right of the parties, party autonomy, the fundamental right of the parties to appoint the judging authority on one side, and on the other side, the fundamental right of the parties to be judged by neutral judges. So there is a clash. There is something in between that might conflict. So why we, when I said before, we are obsessed, why we are obsessed? For one, let's say, technical reason, because we, at least in my country, the neutrality of the judge is a public order principle, period. There is no semi or quasi neutrality of arbitrators issue. Either you are neutral or you are not neutral. And it's a public order principle, period. So there is no discussion. This is the technical one. But then there are also additional arguments. One, it has a direct impact on the trust, on the reliability of the system. We were talking with Professor Berman and Cristina Florescu before during the coffee break. Trust is a key word. If we want to have trust on the system, on arbitration, the judges must be independent and impartial. The quality of the judging authority must be high. So it's a more practical, let's say, reason. Then, because it does affect the quality of the decision, because if there is a judging authority that is not fully independent and impartial, also, let's say, unconscious bias, then the quality of the outcome might differ from the reality, or let's say the procedural reality, because we are not talking about justice in the sense of the dive-in sense of the term. So what we do, and here when we prepared this roundtable over the phone, I was telling them that what we do sometimes, we do not confirm arbitrators, notwithstanding the absence of any objection by the parties. A party does appoint an arbitrator, the arbitrator discloses a conflict, both parties, they say, no problem, we want to keep it, keep him or her. We have no problem with this arbitrator. Sometimes, thank God, in rare case, we don't accept the appointment. The arbitrator is kicked out. This is not strange. If you look at the IBA guidelines, the non-waivable red list, that's exactly what they say. There are extreme situations where, no matter what the parties say, that person cannot play as an arbitrator. Again, period. You don't like it, then you don't grant this right to the institution. You don't come to Milano. You go somewhere else. Again, thank God we do very rarely, but if you don't like, go in an ad hoc environment. Then you take the responsibility that maybe the award will be challenged. Maybe there will be other issues. If you want to stay, and funny enough, when we do not confirm an arbitrator, of course, that's a criticism moved to the institution. By whom? Guess? Most of the time by the arbitrator, not by the parties. The parties, they complain, but, very softly. They say, well, but okay, we appoint someone else. The arbitrator is, and that shows, I think, a different conflict of interest, but I don't want to talk about it. So this is my comment.
I mean, that does come back to the importance of what goes into the contract in terms of whether it's going to be ad hoc or whether it's going to be institutional, but what institution is going to be selected, and making sure that whoever's drafting that understands the differences between the institutions, and that they know that sort of approach is going to be taken.
Well, because we should give for granted that when they do use an arbitration clause, they do draft an arbitration clause. When I say they, I think of the parties. They know what they're doing. I should give for granted they know the rules of the game applicable to the case. They should know what the implication of the seat, the selection of the seat should be. I'm not sure this is always the case, especially for arbitration clauses that in the States, they're They're called the midnight clauses. Midnight because they come at the end, and I think also midnight because sometimes they bring nightmares after. If they are poorly drafted and then the dispute arises, then it leads to nightmares. So, that's how it should be. You go in a restaurant, you check the menu, you check the price, you get the reputation. We don't have a TripAdvisor for an institution, but maybe one day there will be. You get the reputation, you know what they are offering. And many institutions now, they are transparent. The Vienna, the Romanian chamber, ICC, Milano, they open the door and they show the system. You don't like it, you go somewhere else. But you should be aware.
Okay, the benefits though, we did a bit about the criticisms there. So what are the benefits? So we touched on some of this already. Clearly having a secretariat supporting the matter is a benefit. But can we just quickly run through your institution's approach to selecting arbitrators first? Niamh.
Sure. So, well, like Stefano said, I think the key is the transparency, so that the parties know how arbitrators are selected. And at VIAC, the board selects the arbitrators. So there's an internal process in place whereby 2 board members are selected in the form of a subcommittee, and those 2 board members, they get the facts of the case and any criteria that the parties specifically want for their arbitrators, and they have a short period of time to come up with a shortlist. They will get information when they do come up with their shortlist. They get an information from the secretariat, for example, as to how often this person has been appointed by a VIAC before by the board, how often they've been appointed by the parties in VIAC cases, and whether they are still active in cases, just so that the board has a rounded view of this individual and how active they are within the institution. And then after this 3-day period, the entire board is presented with this shortlist and are also given a short deadline to agree or disagree. If necessary, and thanks to COVID, which is something we don't say very often, but thanks to COVID, we can have a very short Teams call or whatever if the board members feel like they need to discuss it in person, if it's not around the time of a board meeting. And the idea of having a short list of 2 candidates is so we try and achieve gender diversity, but also regional diversity. So we try and appoint arbitrators within the region that we're most active in, which is here. The idea being that you have a short list of candidates if the first candidate is not available because they're conflicted or otherwise, that you can automatically, without losing a lot of time, move on to the second candidate. And our list of arbitrators is on the website, so it's transparent that everyone knows, who's been appointed in what case, to kind of, improve the or build trust in the system, like Stefano emphasized before.
Thanks, David. Yeah, so you have a panel. Ruxandra, what's the process with your institution? And do you have, for example, a panel of arbitrators?
Yes, we have a panel of arbitrators. We have 116 Romanian arbitrators on our panel and also 72 foreign arbitrators. They are elected and confirmed once a year. If you want to reach the list of arbitrators of our court, you have to submit a request together with all relevant documents attesting that you are fulfilling the requirements set forth by our regulations. In Article 4, you have all these requirements. It's a law degree, a minimum of 8-year experience in law, outstanding reputation, high level of qualification, professional experience. These requests are analyzed by the management board and of the Court of Arbitration, and then the new arbitrators confirmed by our board are also confirmed by the management board of the Chamber of Commerce and Industry. Also, our panel of arbitrators, our list of arbitrators is an open list. any party may choose an arbitrator from outside the list, but this is where we have to confirm, the Court of Arbitration is confirming that person. They have to fulfill the minimum requirement, at least the minimum requirement for the persons that are already on the list of arbitrators. I think that is why the parties have to give us all the documents attesting that that person is fulfilling that requirements. We don't have any other confirmation of arbitrators because we consider they are already confirmed on the list of arbitrators. And the parties have the power to challenge an arbitrator during the arbitration process in case they consider that there are conflict of interests. And those challenge requests are settled by a different arbitral tribunal that is designated, appointed by the president of the court. This is the main.
Thanks. It's interesting that they have to be lawyers because,
yes.
Yeah, and for example, in Scotland, a lot of arbitration is done by surveyors, for example, or engineers. So that's an interesting approach. Could you just add in, Stefano, the approach in Milan?
We in Milano, the arbitrators are appointed first by the parties or by the co-arbitrators, and that happens 60% of the cases. So more or less 60%, 65% of our arbitrators have been appointed either by the parties or by the co-arbitrators. When they do not find an agreement upon the chair first, or when we have to appoint all the panel, that's multi-party situation, or when the two co-arbitrators do not find an agreement upon the name of the chair, then we do intervene. We have no list, anyone can be appointed. We believe that the list is a little dangerous if you want to pick up the right person, or at least what you think is the right person. So we really move on a case-by-case basis, based on the selection, based on, of course, competence, applicable law, seat, language, and all the criteria that we know are necessary in the selection of an arbitrator. And we do publish the names of all the arbitrators appointed either by us or by the parties, by the co-arbitrators. So transparency comes from at the end. After the appointment, you can go to our website like it does, I think, Vienna does, right? And the ICC and other institutions. This is how we do select. We have no accreditation, no roster, or no other. It's really a case-by-case, on a case-by-case basis, and the appointment, sorry, Andrew, the appointment is made by our council, that is made not only of Italians, and it's made of 11 people, and so it's sometimes it's a difficult process, it takes time, but we think that on ad hoc specific cases, it grants a higher level of quality.
Now we talked a bit about the Secretariat and the important role that they play, and Roxander talked about encouraging the tribunal to move matters forward. But maybe, Stefano, you can talk again about how exactly you would do that and what rules you have to allow you to push matters forward.
Well, we do apply, let's say, a soft supervision or look, let's say, to the correct application of the rules by the arbitrators and, of course, by the parties. We have to be reasonable, but what we do, in general principle, is we do grant a dialogue, a constant dialogue between the Secretariat and the arbitrators. So they know who is in charge with the case manager, and we have a direct communication. And that helps a lot. Also, sometimes many of the issues, or let's say the possible problems, they are solved with a phone call. Very practical, you exchange your views, you collect the views of the arbitrators, and sometimes it's difficult because some of the arbitrators are, as we know, prima donna, so you cannot be too direct. You have to be, just in case you consider the possibility, but most of the time they do follow because you are the institution, and don't forget, we are also possible source of future appointments. So they tend to listen. And that happens to us when we are arbitrators. If the ICC tells me something, I do carefully listen because maybe they appointed me and I trust them. So I think that works. It does not solve 100% of the situation, of course, but it does help.
And I suppose that contrasts with the courts, and it's not so easy to push a judge to move matters forward. But what about enforcement, Stefano? About why might institutional arbitration assist with that?
Well, according to many arbitration laws that we are aware of, you cannot challenge an award on the merit, but you challenge the award because there was some violation of the process. If you have an institution, that's something we did not mention, talking about the comparison between ad hoc and institution, but that's actually a crucial issue. You are right, Andrew. If you have an institution administering the case and do its job properly, so overlooking what is going on during the process, ideally the mistakes, sorry, I mean, I'm using not a legal term, but the procedural mistakes during the process will be reduced. And at the end of the day, the award will be less attackable. That's something that we all know, that we have this feeling. There are few surveys. We did once at Bocconi in Italy, and the outcome was impressive, because the percentage of institutional arbitration awards challenge were very low. By the way, it does not mean much because you don't know the universe of the ad hoc awards. So I want to be, to be clear. But among those that have been challenged in 4 courts of appeal in Italy, that they are quite active, that they are Torino, Milano, Brescia, and Genova, so in the north where all the major numbers are concentrated, the percentage of institutional arbitration award challenge was something like 0.1, or very, very limited. And the ones that have been annulled, they were all ad hoc. And that's a little signal of something that I think we share as a feeling. But it makes sense. If the institution does properly its job, the mistakes during the process should be reduced. It's not the role of the institution, at least for me, to fix the problem, but to ring the bell to the arbitrators, to say, look, arbitrators, are we sure that this might not lead one day to the challenge of the award because of a violation of a formal requirements of this or that? And I think that if the institutions do play their role properly, they reduce the risk.
Yeah, maybe, Andrew, just one example of that, I think, is, if you have a defaulting party and the amount in dispute is very low, and VIAC always tries to, promote younger arbitrators and give them the opportunity to have their first arbitration. And if they happen to end up in an arbitration that with the defaulting party, the amount in dispute might be quite low, and it might not be a very particularly difficult case, but you have to be careful in how you draft that award in that way to make sure that at an enforcement stage it doesn't appear that the defaulting party didn't get every opportunity to be involved in the case or to receive all of the documentation. And I think an institution in the background there to ring the bell and say, have you documented everything carefully, and is the award really portraying all of the efforts that you made to give respondent the opportunity to comment or to be involved in the process.
Thanks, Niamh. Now we're quickly running out of time. We were going to touch on the other roles that institutions play. For example, the lobbying of governments to change or improve, for example, arbitration laws. And also the role that we play in just the promotion and development of arbitration and indeed the local seat, the jurisdiction. And some of the other campaigns that are out there in terms of diversity and inclusion, as well as the campaign for greener arbitration, which is supporting this event today. And also the collaboration between institutions, because although we're competing, we also work together, and we saw that in terms of Russian sanctions, and indeed Neve was involved in that. But because we are running out of time, I think I'll just summarize that as I did, and see if there's anyone that wants to ask the panelists any questions before we break for lunch. George. Do we have a microphone for...
Thank you. Reference was made to a light touch among all three. I don't know what the opposite is of a light touch. I hate to call it a heavy touch, but let's call it the heavy touch. I just wanted to, this is a hybrid comment question. Almost every institution before which I've arbitrated, I think, could be described as exercising a light touch. I won't name it, but too light is a problem sometimes. But it's none of you, but I have experienced that. But I did want to make reference to ICSID because it is an outlier in this regard, and even if an institution such as yours doesn't want to quite emulate ICSID because your circumstances are simply different. For example, resources. But there are some aspects to what ICSID is doing that I think are worth mentioning, because they could conceivably be received and incorporated maybe with modification. I just wanted to mention a couple of things. I'm sitting in a couple of ICSID cases right now, and one thing I think the tribunal is appreciating is when we're about to issue a procedural order, for example, the procedural order will be reviewed. We won't be told what to order, but the context of the procedural order, various aspects of it are commented on by counsel, at least in my experience. And I find that useful. The best thing that I have encountered, and I've never encountered with an institution other than ICSID, in fact, I've been met with ridicule at even suggesting this, but in my experience, counsel at ICSID has written the procedural history of the case. Honestly, that's very welcome from the point of view of the tribunal. I don't think if the institution composes the procedural history, it's overstepping its bounds. I suspect that counsel at ICSID even knows the procedural history better than the tribunal does, and has better access to the records of it. And they all routinely do the procedural history. We, of course, review it. But I just want to throw that out as an example of something that you might be able to take on board. Now, I realize that involves human resources, serious human resources. It also means, who are your counsel? And I'm sure you all have excellent counsel, but I think it's fair to say ICSID counsel are extraordinary. I mean, extraordinarily good, extraordinarily motivated. And they actually, I find, welcome an invitation to, and they sometimes don't wait for an invitation, to do something like the procedural history of the arbitration. So I'd like to know what the panel thinks about the feasibility, of taking a look at ICSID and seeing if there's something that you'd like to take on board with or without modification.
Okay, does anybody want to respond?
Yeah, it's a really, really good remark and suggestion. I think you kind of answered it for yourself in that the key point is the resources that you would require, you know, and I think as well, speaking for VIAC as a relatively small institution, that would be the issue, right? What we have done, however, in the past is we've had 1 or 2 arbitrations where we had appointed somebody from CESE who wasn't a native German speaker, an excellent speaker and absolutely competent to run the proceedings in the language, but wanted as a perfectionist to have everything perfect. And we did offer the service of proofreading procedural orders. So, but it wouldn't have required us to comment on the substance. However, if we had seen something in the substance that we considered maybe not accurate, we probably would have, like Stefano said, rang the bell. So I think it's an interesting development or interesting thought, and I think maybe it is something that could be considered. But exactly, it is a resources point. And then on the procedural history, I would probably see that more within our tribunal secretary role, that if you have one, yeah. So I think, you know, in larger cases, the tribunals should, I think the tribunal secretary role is a vital one, and I would actually like to see more tribunal secretaries appointed. Not just because they can, you know, take those tasks off the tribunals, but it gives young individuals a huge opportunity to see how a case is run and to get an insight into how it works. And I know for myself, if you have tribunal secretary experience, it makes your first role as arbitrator, you know, it takes the kind of sting out of the challenge of doing it on your own for the first time.
I don't know if I've got any more time, but is there any more questions? Joe, you're looking excited, which is impressive for an Englishman.
I am excited about it. I just wanted to pick up on George's comment, because I think one of the most used resources is indeed, I think, tribunal secretaries. In my mind, it's a bit of a no-brainer. And I think, candidly, I think institutions may be missing a marketing point, whether it's included as part of your costs or you actually increase your costs a little bit. Arbitrators can be a bit resistant because obviously it can take a bit of revenue from them, but actually, again, there's a bit of a conflict of interest in that regard. And my experience with ICSID, both as a conciliator and arbitrator, I found the standard extremely high, and it's a much more cost-effective use of our time, I think, on the panel. So I'm certainly with you on that, George, and I would encourage you to think more about that, because I think it's a win-win situation from everybody's point of view, and I'm a little bit surprised that it's not really been taken up more. So I would squeeze that in.
Okay, there's a question here.
Philippe Cavalieros from Paris. Thank you very much for your enlightening views on the role of the institution. There's one thing I'd like to ask your opinion on. You've alluded to transparency, and we've heard Professor Berman on the quest for legitimacy of arbitration. One institution, which may be the elephant in the room, has decided, and somewhat controversially, and frankly, I'm very opposed to this, but anyhow, to publish its awards unless at least one of the parties object. I just simply would like to have your views from reputable institutions on publication of awards. Thank you.
Yes, before I open it up, I would say Scotland has a very strict approach to confidentiality, and indeed our legislation means that if there is a reference to the court, and George talked about courts, you briefly mentioned confidentiality, in that case, the judges, if asked, can have anonymity for parties and would go as far as not to publish the decision. So that's a jurisdiction taking a very different approach, and as an institution we will look to ensure that confidentiality is built in to our systems, but it does show you the contrasting approach from jurisdictions as well as institutions. Stefano.
Well, honestly, I think that the confidentiality of the arbitral award is a little overestimated as an issue. And I tell you why. We it has to be handled with great care, no matter whether the parties at the beginning applying your rules did, accept the rule. Otherwise, unless otherwise agreed, they grant you the possibility to publish. It has to be very careful, the institution. So I fully agree with you. But I think there is one story. And for many years, we were asking the parties after the award whether they agreed on an anonymous basis to use the word. And the rate of no was very high. So we changed. We anonymized first the award, sending to the parties and saying, in this way, would you accept? And the level of yes increased. So I think that sometimes the parties, no matter what, they say no, especially the losing party, of course. They say no for many, because if you properly anonymize the award, I think that at the end of the day, you might have said no in principle, but then if you look and say, well, okay, well, so how do I suffer? It would be very good as a jurisprudence, as a case law, to have the awards published. That's for sure, for scientific reason, for the future generation of arbitrators. So I am in favor with great care, and then, but it has to be really, really, I think, very careful. So I agree with you. Sometimes it's a little, superficial approach.
Neve?
Yeah, I just add to that we, in our rules, we are only allowed to publish summaries or extracts of the awards, which, there's questionable. From what I understand, the trend is now to publish the full text but anonymized. So we would have to summarize them or only use extracts of them, which honestly is also, back to the resources point, a huge challenge for an institution to do that in a useful manner. But I feel like it seems to be a global trend now, and there's a push from various stakeholders to get their hands on as many awards as possible, to provide this jurisprudence. And like Stefano said, I think the idea is that the community would like to have the jurisprudence in theory, maybe not the individual arbitrators whose awards are being published. But if you ask the parties, generally they think, yes, in theory, we'd like to have it there for our lawyers to use it, but we don't want our awards published. Of course, you can have the flip side of the coin, and I've experienced that too, where the parties say, we want everything to be confidential. We don't want the award to appear, and then they win, and then they want the market to know that they won. So yeah, catch-22.
Yeah, I mean, I agree with that. I mean, I think we don't think enough about the parties. It's the community wanting to know the jurisprudence been there, but actually, if the parties have picked arbitration, and they might have picked it for a confidential reason, I think we need to think a bit more about that. I was told to finish about now, maybe a couple of minutes over. Thank you very much to the panelists. Thanks to you for listening. It's lunchtime now. We're to be back at 2:30 in the room, so 2:30 back in here for the next panel. Thank you.
Hello, everybody, and welcome back. Prior to actually starting our panel, the one that you all know about from the agenda, we take advantage of the context we are in, and you are about to witness the signing of a cooperation agreement between the SCC, present here and represented by Natalia, and the Romanian Arbitration Court, the acronym would be CICA. It's a cooperation agreement between two arbitral institutions. I am not going to get into details. Everybody knows that serious arbitration courts cooperate with each other, but for the benefit of the arbitration practitioners in the room, I would say that the most appealing consequence of signing this agreement is the fact that the SEC offers, and as a consequence, we are going to become the beneficiary of the SEC ad hoc platform, which I am told is one of the best soft instruments that are being used on the arbitration market, and which becomes immediately available for ad hoc and even institutional arbitration here in Romania. I invite Ștefan Deaconu and Natalia to sign the agreement. Please, Natalia, you first.
So we have 3 copies, right?
I don't know. 2. Okay. Thank you so much.
Thank you so much. So we are looking forward to our continued cooperation. Thank you.
Sure, I'm sure that it will be the beginning of the beautiful cooperation between our institutions. Thank you so much for coming in Bucharest. Thank you, Cosmin, for mediate this dialogue between our institutions, and thank you, all of you. Good luck.
Thank you.
Thank you.
Good luck. Okay, now we can get back to our agenda, and we have what we would call the SCC Innovation Panel. Under no circumstances I could ever dream to suggest a hierarchy between the panels of the Bucharest Arbitration Days. They are all great and perfect. However, the only panel that is going to provide you a full sensorial experience is the current one. There has been lots of debates about excitement. I'm not going to get into that dangerous area, but in all the panels, in all the good panels, people get to hear, see, and feel things, not in the tactile, old-fashioned way, in the sophisticated legal way. Well, in this panel, you are going to use the other 2 senses that are left out normally, which are smell and taste. And you are going to use them all because, and now it works, the SCC scent is present here. And it is not an accident. I find that image, the one that you have displayed in front of you now, perhaps the most suggestive to epitomize the innovative spirit that SCC is using, even if, or even when they have undergone the rebranding last year. And there is one missing piece of the puzzle, which is the taste. And I thought it was really necessary to bring it on the table. And you are all going to participate, that this is a surprise, in a collective exercise that would provide a sort of flavor of various participants and stakeholders
as to what is appealing and what is not appealing about institutional arbitration. The way to handle this is going to be a real-time poll that we are going to have with your support, and the results are going to be helpful or not for our distinguished panelists. Now, without further ado, I will very briefly introduce the speakers so that we have more time to actually touch upon the topics. The first one is Mr. Dragoș Adrian Voncu. Dragoș is, for a lifetime, head of legal with Alros Latina. Recently, he has also become a non-executive member of the board of directors. He's a very experienced lawyer, and his expertise covers both a really impressive plethora of dispute resolution mechanisms and jurisdictions, as well as sophisticated M&A banking and other corporate kind of stuff. Welcome, Dragoș.
Thank you, Cosmin, and thank you all for having me here. It's a real pleasure to be together with you. I was invited here, I suspect, from the perspective of the justice seeker for more than 25 years, I would say. I can say that I worked for my whole life in the industry, so I'm coming from another perspective which is interesting, working only for big companies and generally with international exposure. So I believe that my experience is relevant for the topic of today. Having said that, and jumping into the subject, I want to make a very brief statement that after more than 25 years of career and becoming older, I draw a very brief conclusion about arbitration in general, that it might look odd, but it is not first of all an instrument to solve disputes, but it's first an instrument which facilitates trade. And I can explain you why I'm saying this. During my career, one of the most stringent problems as internal lawyer and general counsel was to administrate international contracts. The client for which I'm working now is an international company with assets both in Romania but also in China and in West Africa, and selling in more than 100 jurisdictions. And obviously, every time you negotiate a commercial agreement with your partners, whether you sell something or buy something, there are certain clauses which are more negotiated than other clauses. And most of you would think probably that the most negotiated clauses are the commercial clauses, how much you pay or how you pay or what you buy, what are the characteristics. But you will be disappointed to find out that the most negotiated clauses, from my humble experience, are the liability clauses, jurisdiction, and place of judgment. So generally, commercial guys and engineers are closing the deals in a couple of days, and then lawyers are fighting for 2 months, whether it will be Romanian law or Swiss law or French law or I don't know, and whether we will use Romanian courts or Swiss courts or arbitration. And coming from this perspective, I think that the important role of the commercial arbitration, international commercial arbitration, is that it facilitates trade, because it is a dispute resolution instrument which is generally accepted not only in the EU but also in the exotic jurisdictions or across the ocean. Having said that, that is an instrument which facilitates trade, because usually you are concluding an agreement prior to have a dispute, not after you have a dispute. I want to speak also about my experience using arbitration as dispute resolution method. And here also it might be surprising. most probably our colleagues, lawyers, are thinking that arbitration it's a method of choice because of effectiveness of cost or because of the speed. It's not always an obvious choice, but as a justice seeker, when I'm choosing international arbitration as dispute resolution method, it's a complex method to calculate the costs and the effects. So it's not always a matter of cost, it's not always a matter of speed. It's a combination, it's a matrix which have to adapt to each type of transaction that you have. And here I can come with examples. For example, if you have a marine dispute related to, I don't know, shipping, most of the justice seekers are using LMAA in London. It's a certain standard. You know what you will get there. Most of the arbitrators are persons with experience in shipping and so on and so forth. If you have a metals and mining dispute, you go to LME arbitration. This is a more or less accepted standard in the branch. Speaking about SEC, which is also a well-known place of jurisdiction, at least from my experience, and I had a bunch of disputes in my career, SEC is mainly used and accepted for disputes related to energy and energy products, especially in the eastern part of Europe, and is also well known for its efficiency, speed, impartiality, which is also one of the very important criteria when we choose a place of arbitration. In the end, what I want to mention is that as a justice seeker, of course, I cannot be always pleased about how international arbitration goes. But to my mind, it's a primary choice whenever you do international transactions for several reasons. And what I hope to see in the future, putting aside the increase of the efficiency of the procedures, which are already very efficient, but of course there is room of improvement, it's a larger recognition of arbitration as instrument, because as I said in the beginning, this helps and facilitates the trade.
Thank you, Dragoș. Now we started our discussion about institutional arbitration and especially about SEC institutional arbitration, giving the floor to the very important stakeholder, which is the user. Now we are going to move to a different perspective, and it's going to be the counsel, but in between, as I mentioned, we are going to have that real-time poll. What I didn't mention is that I'm unable myself to handle the simple software. That's why my smart and savvy colleague Andrea is helping me. You are going to have displayed right now, you should have a QR code which must be scanned with the camera of your phone, and then it shouldn't take more than 30 seconds to actually complete the answer to the question. You are free to tick 1, 2, or maximum 3 answers, no more. There is only one question because we divided the 3 questions in separate slots. And then you submit the answer and don't close the page because the following question is going to pop up automatically later in the same, so you don't have to scan once again. So My colleagues are here and they can help if necessary. So what we cannot afford to do is to wait too much. And I'm moving on to introduce our next speaker, Ginta Ahrel. She is a very experienced lawyer and arbitrator. She is founding partner of Westerberg, a Swedish law firm. She has extensive experience in various industries, both as arbitrator and as a counsel. She currently serves as a board member of the Arbitration Institute of the Stockholm Chamber of Commerce, SEC. And according to one of her clients, Ginta is a very sharp and experienced lawyer, providing practical advice that gives value for the client. This is one of the reasons for inviting Ginta here to represent the voice of the counsel or the perspective of the counsel in this journey that deals with SEC experience. Ginta, the floor is yours.
Thank you very much, Cosmin, for this very kind introduction. And in this sense of giving you a tactile experience, I'm all about putting something on your, remembering things rather than just speaking. I tend to remember things better when I see them. And before I get into that, I would like to also thank the organizers very much for giving me this opportunity to speak to this distinguished audience here and for visiting you in this beautiful and warm city of Bucharest as opposed to not so warm Stockholm. Appreciate that a lot. So the counsel perspective, I think it would be one of the easiest ways to give you the feel about what are the procedural tools and possibilities in SEC arbitrations by taking you with me on sort of a mock case scenario, a case scenario. So imagine now that there is this case and for a Romanian corporation, which happens to be called Rompetrogaz. No, any associations with any existing corporations are completely incidental. So if I'm a counsel for this corporation, which by the way has already signed an agreement with a foreign company dealing with the delivery of gas. And in this agreement, they have introduced an SEC clause. So 2 or 3 years pass by, and that's what statistically is the time for disputes to arise under the ordinary commercial contracts. The dispute comes up about the foreign company refusing to pay. The disputed amount is about 500,000 euros. And the question is, what do you do as a counsel in providing advice to the client at this very, very beginning of the dispute? And of course, the first thing is like, try to settle it, try to talk to the people. And then you are informed by your client that, oh, well, we tried that, doesn't work. We all argued and we're hardly on any speaking terms, so just talking to them won't do. And unfortunately, the same is true for mediation. Mediation would otherwise require quite a lot of trust in parties to go in that. And surprisingly, people often talk about it, but when it comes to actually sitting down and mediating, not that many do that. So if negotiations are out of the picture and the mediation is not there, what other means there are today available for getting this settled and moving on with your business, as Dragos was saying, facilitating the trade, like moving on with your trade, because the Romanian company probably has quite a few years left on that contract with delivering the gas. So my suggestion would be that try the SCC Express dispute assessment. That is a procedure where the SEC appoints a legal expert, a so-called neutral. And this neutral will assess the dispute in 3 weeks for a fixed fee of 29,000 euros. And I dare to say that this is by far the most efficient dispute resolution method available today. There's a catch though, both parties have to agree to that. And the outcome of it will not be an award, it will be a decision, but it will not be an enforceable unless parties agree to make it enforceable. But what it does is it offers the parties the opportunity to see, okay, if we are to go to an arbitration, this is sort of a mini trial. This is like a mock trial, if you like. You will have, in these 3 weeks, you will have a couple of submissions. You might have or may not have a hearing, but it will give you sort of a quick answer to the question of how this dispute will resolve. And the idea of that is, of course, that this will facilitate the parties to agree. In its concept, it's sort of similar to the dispute adjudication boards for those of you who are dealing with construction arbitration. So let us assume then, moving on, that Rompetrogaz has indeed filed for and agreed with the foreign company for doing this express. They do that. The Rompetrogaz prevails in this, but the foreign company would just not accept that. Perhaps they thought that they had a good case, and they lost. So there's no way they are going to accept this. So what do you do then? You would, since you already have the SEC arbitration clause, you would think of naturally, okay, then we make a request for arbitration. But then another thought is, well, what happens if this nasty foreign company is trying to, dissipate its assets and do something that will endanger the possibility to enforce your award afterwards or sabotage the performance? Then you will need to have any provisional or interim measures. And in that situation, you have a choice. Do you go to a national court, or do you stick with the arbitration? And just to illustrate that the two options is that, of course, if you are looking for a immediately enforceable, by force enforceable interim measures, national court is the only choice, because the arbitral tribunal's interim award will not be enforceable, not at least in many countries. There are some that have enforced it. But the tribunal does not have the power to coerce parties. It's only the national court. If you go into national court, you will have to find a local counsel. You will have to instruct a local counsel, and there are other range of aspects that might make you think about going to the local court for provisional measures, and that is, you will probably lose the confidentiality that was mentioned on, not least on the previous panel. And you will most probably also have some issues with the efficiencies, depending, of course, on what country it is and how efficient the courts are. And the third issue is of the expertise on being a national court judge, which are typically generalists, how they will approach the issue, which it turns on some international commercial issues. So the drawback, as I said, of the emergency arbitrator's decision is that it's not enforceable as such. But the research shows that most of the parties do actually comply with the emergency arbitrator's decisions. And the reason why arguably that is so is that the parties are, they do not want to risk this non-compliance to impact their position before the arbitral tribunal. And that's why they prefer to maintain the status quo as ordered by the emergency arbitrator and comply with that decision. So the emergency arbitrator is a procedure which is you can deploy it before you send your request for arbitration, and then the SEC will appoint an interim arbitrator within 24 hours who will decide the issue in 5 days for a fixed cost. This decision will then stay, or award rather, will stay in force until it is changed by the arbitral award or until the final award is delivered. So now back to the case. Rompetrogas has decided to file for emergency arbitration. That goes on. Rompetrogas prevails in that one too. And now it's important for Rompetrogas to move on with the real request for arbitration, because otherwise in 30 days, if the real request is not filed, the interim award will lose its power, the magical power, so to speak. And then the last tool to illustrate I would like to illustrate is the expedited arbitration, as again opposed to the ordinary arbitration rules. So here I have put an arbitration, standard arbitration clause where I made some changes marked in yellow. The first paragraph is a standard one, just referring the disputes to the SEC. The second paragraph does allow you to differentiate. If you have disputes under 600,000, here I change it to 600,000. You can put whatever is appropriate for your businesses. That will go to expedited arbitration. Otherwise, it will go to ordinary rules. The issue with, or the beauty with the expedited arbitration is that it's a short proceeding. The award is delivered in 3 months. You have a sole arbitrator, which makes things move faster, typically. And the number of submissions is only 2, and the deadlines between the submissions is 15 days. So it's a quick proceeding. Oral hearings are held only if the party requests and the arbitrator finds that necessary. So to sum it up, here's a little table talking about costs. We see the 3 E procedures, and I can admit that when I started, I had great difficulties in telling these apart. They all start with E and all convey some sense of urgency. And one is quicker than the other. But having done this exercise now, and I hope that you will be able to tell them apart, express dispute assessment is not really an arbitration. It's a service for parties. And there it doesn't matter what the disputed amount is. It's a fixed cost, and the time it takes is 3 weeks. Emergency arbitrator, 20,000, 5 days. Expedited rules, if the disputed amount is 500,000, then the arbitration cost will be 30,000 in 3 months. And then you see in comparison to the ordinary rules. One thing that I would like to particularly mention here is that there is this elephant in the room that's called counsel costs. Because these are only the costs for the arbitrator's fees and the SEC fee. As studies show, the counsel costs are in approximately, or rather I should say, the arbitration costs are approximately 1/5 of the total amount of counsel costs. And as you are all well aware, the more time you give to a counsel, the more time the counsel will use. And from that perspective, I always, even I know that that sort of goes against the nature of the counsel, but I believe in repeat work for the same client, is that the less time the procedure takes, the cheaper it will be, simply also for the counsel cost. And speaking about these arbitration costs, this is also on the assumption that the opposing party, the foreign company, simply refuses to pay, and that in that case, the claimant will have to finance this. But as in many jurisdictions in Sweden, the costs follow the event, which means that the winner takes it all, and the loser, besides standing small, is have to pay for, sorry for this bad ABBA reference, has to pay all of the costs if so decided by the tribunal. And if we look at the time, if, as in this example, we used express emergency and expedited rules, then with if everything goes smoothly, you are in and out in 4 or 5 months. And I hope that this has been a useful example for what considerations and options there are when you are in international arbitration, and particularly under the SEC rules. And I would like to pass back the words to Cosmin.
Thank you, Ginta.
Thank you.
Thank you for your very meaningful counsel perspective. Now, prior to moving on to arbitrator's perspective, let's spend a little bit of time on our poll. Apparently, half of the people in the room, or more than half, managed to vote, which is okay-ish for a start. Now I'm going to apply a very important legal principle governing the life of a lawyer. When you start something, you take it till the end, no matter what. So here we go with the second question. While you have the 30 seconds to answer the second question, I'm going to articulate what was displayed before of you. We have the answer to the question, which are the most important factors that would influence the choice of an arbitral institution. And the champion is international recognition, 30 votes. And then with 29 votes, so basically equally important, are the fees and the arbitration rules. Now, please answer the second question, and I hope this time is easier for everybody to vote. I am told that we finish with this second question. You have the answers displayed in front of you. You can also vote. You don't have to immediately stop. And I'm going to make reference to it immediately after Crina's speech. Our next guest is Crina Baltag, and she is going to share the arbitrator perspective. It is difficult, but I like challenges, to briefly introduce Crina. First of all, she's a superstar. Secondly, she is a professor with the Stockholm University, where she handles one of the two persons that handles first and foremost their famous LLM program. She's a very experienced arbitrator. She's member of the SEC board, as well as many other professional organizations, main editor with Kluver Arbitration blog, and so on and so forth. What people don't necessarily know, and this is a good context for me to advertise it, is that Crina is a fantastic and fanatic supporter of Bucharest Arbitration Days, and I use the opportunity to publicly and warmly thank you for everything you do for this event. And now the floor is yours.
Thank you. Thank you very much, Cosmin. And it is wonderful to be back home and to support the arbitration community and to have the support of all of you coming to speak and to attend the event. I was just going to pick up on the result of the first question, indicated international recognition of an arbitration institution. And I was asked to provide the arbitrator perspective on the SEC experience. And I have that. I also have from inside experience as the member of the SEC board. But I think international recognition is something that we should all, in an institutional form or individually as arbitration practitioners, we aim at, and we want to achieve this. But the question is, what does it mean? And I think the first thing that would come to my mind is that it doesn't matter where you go, somebody will recognize the arbitration institution. And you could see many of these examples today in the previous panel, as well as in this one. And I think one of the most important innovations of the SEC, besides sometimes being ahead with introducing certain tools in the dispute resolution toolbox for users, such as the SEC Express assessment. We had the first officially submitted case a few weeks ago, is to provide the users, and in particular parties and arbitrators, with I would say, the complete experience when it comes to SSC disputes. The first one, the first innovation I would like to refer to is the SSC platform. You could hear that the Court of Arbitration here in Romania is going to receive access to the ad hoc SSC platform. But what is it? Started in September 2019, all SSC arbitrations are administered on the SSC platform. And this is a secure digital platform, and trust me, it's so intuitive, but you don't need special skills to be able to maneuver it. You are provided with a guide on how to use it, as well as with training if that is needed from the very helpful members of the Secretariat. Starting with 2020, during the pandemic, the decision was made for the SSC platform to be used in ad hoc arbitrations. And it is more than just a sharing platform for documents, for submissions of the parties for the evidence. It is actually used to communicate within the arbitration. All the messages coming from the institution, from the Secretariat, from the arbitrators, from the parties are exchanged by way of this highly secure platform. And this is very important, and trust me, I know what I'm saying. Just to give an example, at Stockholm University, we don't work with junk folders. That was removed at the level of the university, which means that if one of your emails is not responding, it might be at the level of the university in the junk inbox. So that is one of the major issues we're seeing today, that we need to be able to receive the communications, arbitrators and parties and the institutions. And this is done by way of the platform. Everything stays there. The moment something happens on the platform, in the file of the case, that is notified to the inbox, the arbitrators and the parties will log in onto the platform and they will see the movements in the file. It is very easy to see the calendar that is locked, the procedural calendar that cannot be changed. It is also very easy the moment you log in onto the file to see for the arbitrator that there is a deadline for the award, and that is like displayed quite centrally on the page of the file. And it is very important because it serves, as I was saying, to keep the file of the arbitration. And sometimes we see in practice the problems with the parties who might not have the resources to have a file sharing platform to share large files. That is also a cost benefit for the parties. And I think the last point I wanted to stress when it comes to the SSC platform, from the arbitrator's perspective, there is an obligation to keep the file of the case for a period of 1 year. And the case will be archived on the platform, the file, and it will stay there for that period of 1 year. So that, I would say, concern for the arbitrators is no longer there because the file is already on the platform. I wanted to, of course, highlight that increasingly with other institutions, we're working with platforms, VIAC as well. You could hear the Scottish Arbitration Centre, the ICC, and so on. And I think this is an incredible tool for everybody, and they are made in a way to be easily accessible and used by the arbitrators and by the parties. Now, the second, I would say, innovation, I would not call it innovation, but I would say advantage of the SSC in terms of what it provides to arbitrators and not only to the arbitrators, is the constant publication of different reports. And we heard in the welcoming speeches and also the keynote of Professor Berman, as well as in the panel with the arbitration institutions, transparency is a critical issue nowadays. And some of the institutions, of course, they cannot publish the full text of the awards. What the SSC does is to provide reports on different issues on a certain period of time, summarizing the SSC practice, and not only the SSC practice, but also the Swedish practice and Swedish law on different issues. The most recent report is on prima facie jurisdiction. Some of you may be aware that the SEC board is the one addressing whether the SEC manifestly lacks jurisdiction to hear a case. The report was just released, and it has the decisions prima facie between 2013 and 2023. And these are very useful, not only for arbitrators, because of course the prima facie jurisdiction doesn't prevent the arbitrators to rule on the jurisdiction, but in particular for the parties to see what it doesn't work at an institution. And just to give you an example, in this 10-year period, 5 cases were rejected by the SEC board because the arbitration agreement provided for ad hoc arbitration. 3 cases have been rejected because the respondent party was not a party to the arbitration agreement. 2 cases in which the parties have provided in the arbitration clause different arbitration rules. You can imagine SEC cannot administer LCIA arbitrations. And 1 case rejected because there was no arbitration agreement at all. And these are very good examples for counsel, for in-house counsel, external counsel, how to draft an arbitration clause. Other example of reports, especially for arbitrator, I think already 3 published on the challenge of arbitrators. It clarifies the practice not only of the SEC board in addressing challenges to arbitrators, but also keeps the reader up to date with what, for example, the Swedish Supreme Court has decided in various cases, in particular with the seat in Stockholm. And some of you may know that Sweden has objective standard of addressing challenges to arbitrators, but also the fact that in Sweden, arbitrators can be summoned as witnesses before the Swedish courts. So all this relevant information constantly published by the SEC is very helpful. The last example of report, which was quite revolutionary 3 years ago when it was released, was on diversity of arbitrators. And of course, as an arbitrator, it's important to see how you sit in the a large number of arbitrators in the SEC cases, but it also showed the trend, I would say, broadly with arbitration institutions. In 2020, when the report was released, the diversity report, shockingly, I would say that 14% of the appointments made by the parties were for female arbitrators, and I'll let you guess the rest of the 100% percentage going to men. SEC board has appointed 30% women, so double in terms of percentage compared to the parties. Last year, the SEC board hit the record with 54% women appointed in SEC cases, and overall 34% women. In terms of nationality, there is good diversity. What is not so, I would say, optimistic from the point of view of the arbitrators, in particular female, is that on an average, female arbitrators would earn 75% of the fee of a male arbitrator. And let me translate you that. It means that females are appointed in cases of lower value. And this probably is the signal, for example, for the SEC, or also for other arbitration institutions, to seek to address the problem. That is, the parties are the one making the appointments. The parties should think about more diversity in terms of the appointments, and in a way, making sure that we get even at some point. I recommend that you check the SEC website. I always tell my students, you have no idea the incredible resources arbitration institutions have on their websites, not only the calculator of fees and not only the arbitration rules, but all these reports which summarize their practice for counsel and for arbitrators are extremely valuable, especially when arbitral awards are still confidential. Thank you.
Thank you, Karina. Now we are getting close to the last perspective, which is going to be the institutional perspective of the court itself. But until then, we have the final question. And while you have the traditional 30 seconds to answer this question, which is, I like it a lot, it's challenging, because we are supposed to indicate what we would like to see new, what kind of innovation we expect from arbitration institutions. And meanwhile, I draw the attention that there is a very clear preference in the room, at least, as to what is the expectation of the parties and arbitrators and actors from the secretariat of an institution. The answers show 42 votes, respectively 39 votes, and the rest are not so important, that the parties expect the secretariat to support the parties and the arbitral tribunal, to assist the parties with all aspects of the procedure. It's obviously a key word in the answer, which is support. The parties expect a sort of proactive and living relationship with the secretariat in all matters related to the case. Now I take advantage, and while you are going to answer the last question, I introduce our fourth speaker, which is Natalia Petric. She is the Deputy Secretary of the SEC. She is, prior to the current job, a lawyer with extensive experience in international arbitration. She is in charge with SEC's development strategies, and I hope, Natalia, I'm not wrong if I say that you are the foreign minister of the SEC, considering your agenda and the things that you do and the cooperation agreements and everything. The floor is yours, Natalia, please.
Thank you. Yes, thank you very much, Cosmin, for your kind introduction. Good afternoon, everyone. It's my pleasure to be here today, and I'm very grateful to the Romanian Chamber of Commerce International Arbitration Court and to the organizers of this conference for offering such a wonderful opportunity to be here. And in my short presentation, I will focus on three issues. The first one is why parties from Romania might end up in such a distant arbitration venue as SEC Arbitration Institute. The second is what the SEC is and how it stands out. And finally, why institutions cooperate and how this benefits the arbitration stakeholders. So let's start by recognizing that, and this is the point which has been already made by Dragos, that perhaps Romanian parties do not have an urgent need to go to a foreign arbitral institution or foreign jurisdiction. They have already a good arbitration institute here domestically, and which is very reputable and which has successfully operated for the past 70 years on the Romanian market, fostering new generations of arbitral practitioners. I have also heard that the set-aside level for the awards rendered here domestically is very low and is around 3%, which speaks strongly for the quality of the awards and quality of the services. And therefore, we can assume that for Romanian parties, accepting a foreign jurisdiction sometimes is a forced choice because they cannot agree on a domestic venue for one or another reason. And each and every foreign arbitral institutions present here has advantages which can make them good fit for a particular case. For instance, geographic proximity of Milano and Vienna, excellent secretarial services and facilities make those arbitral institutions quite attractive for Romanian parties. And I will speak a little bit also about the SEC, but what are the downsides of foreign arbitration venues? And they have been, of course, mentioned already. It's the costs. When we speak about dispute resolution in Western arbitration jurisdictions and Western institutions, the costs tend to be higher. And I try to compare the costs of arbitrating disputes with a sole arbitrator here in Romania at the Romanian International Arbitration Court, and ICC, VIAC, and SCC, and can only say that the arbitral services locally cost around 40 to 50% less compared to foreign Western arbitration institutions, at least speaking about disputed values up to around 10 million euros. So the cost is something that the parties should consider, and it looks like that the trend today, speaking about the costs at the ICC, they are much higher, even compared to the cost at the SCC and Vienna, which between these two institutions are relatively close to each other. And speaking about the sophistication of parties in choosing various jurisdictions, it's there is a very interesting trend out there, which was confirmed by the Queen Mary School of Law survey from 2021, which revealed that depending on the potential value of a given dispute, practitioners would be willing to consider less well-known institutions offering competitive fees. And this is also confirmed by the results of our survey, right, Cosmin? It looks like on the second place, after the international recognition of an arbitral institution, come the costs of arbitration, which is no wonder. And it also looks like to be an indicator for a change on an international arbitration market generally. Perhaps 30, 40 years ago, domestic parties were more or less aware of two alternatives to go when they have a dispute, when they had disputes. The first one being a local arbitration institution if there was one, and the second one ICC, because ICC has a big name, big brand, and generally is quite very well known all around the world. Now we see that the market changes and regional arbitral institutions begin to take over quite considerable parts of the market. And in the very same arbitration survey from 2022, it is stated that ICC's overall percentage dropped considerably from 77% in 2018 to 57% today. And today, under this survey was 2021. Of course, a big share of those cases were taken by the Asian arbitration institutions, but it again speaks a little bit about the trend. That was my lengthy introduction of the topic, and now let me say a few words about the SCC and how the SCC stands out, what this institution is. It has been already described quite in detail by my fellow co-panelists. I included here some basic information about the SCC. It is relatively big arbitral institution, handling around 180 to 200 cases per year. And the distinctive feature is that the international caseload is quite high. It's 50% of services are exported outside Sweden to foreign parties. We handle also not only commercial disputes, but also investor-state arbitrations. And the SCC is one of the very few arbitration jurisdictions in the world which has quite a considerable ISDS caseload. And of course, it has been mentioned already, ICC historically and traditionally has been very active and recognized on the CIS markets and Central East European markets as well. The rules have been already described and discussed, so I will not stop here in detail. We operate both with arbitration rules, but as it has been already mentioned, use SCC Express, which is not an arbitration procedure and which is not even connected to any SCC arbitration clauses. Express can be used for any dispute resolution, regardless of the jurisdiction chosen for the arbitration dispute resolution clause, which might be included into the parties' contract. And we also focus quite a lot on various ad hoc services. On this timeline, you can see the innovations introduced by the SCC. SCC is very focused on innovating both procedure but also services. It all started yet in 1995 when the SCC was one of the first jurisdictions in the world to introduce expedited arbitrations to handle small disputes. That's what we do even now, and the parties have also choice to use less expensive and quite quick procedure in arbitration. And I would also like to stop by a little bit one of the latest additions to the SCC services tool, and this is the ad hoc platform. Offered to ad hoc tribunals, but also tribunals dealing with cases under different rules than the SCC. Our mission is actually to promote arbitration in any form, of course. Of course, we work a lot on developing of SCC arbitration procedures and our services, but we are very keen to assist all arbitral practitioners. And during the pandemic period, we introduced the ad hoc platform for free to all ad hoc tribunals to facilitate the proceedings, to make them as digital as possible, and to, in this way, assist our colleagues, assist our users, and all the stakeholders. In the end of the pandemic, we went over to a small yearly fee, which are paid by ad hoc by the parties in ad hoc tribunals using ad hoc arbitrations using the ad hoc platform. And it's a very useful and good way to digitalize arbitration proceedings. It assists the parties not only in organization of the files, in communication, but it also assists the parties when they end arbitral proceedings, because at the stage of enforcement, they still might have access to this platform and the full case file as well. The Express has been discussed and described quite in detail already. So the answer to how the parties choose arbitral institution, of course, is a complicated one. There are a few factors which influence the choice, and usually you will not get like a straightforward answer. For each case, the parties will be choosing in accordance with the parameters of the case, in accordance with their preferences as well. And the interesting part of this is that the more we conducted, by the way, in the end of last year, a special survey for the Scandinavian market of arbitration, just to measure how the markets are ready for arbitration, how they are advanced in arbitral proceedings. And we discovered that the general perception of arbitration as a good dispute resolution service promotes strongly institutional arbitration, but not the other way around. Before the parties use and know something of arbitration, they will not choose an arbitral institution. And therefore, it's a part of our policy to promote cooperation with institutions, because institutions are the motors and the drivers of development of this industry and of the markets. And therefore, we are for cooperation between institutions. We are much more we are much more friends than competitors, let's put it this way. So why we cooperate and what we can do together? Because it benefits the stakeholders, it benefits the users. When we speak about our routines, when we can align our routines somehow, when we can discuss our common problems and resolve them together, because we give career opportunities to our arbitrators. I can mention that we do have Romanian cases, but we don't have that many Romanian arbitrators on our database. And if we need to make an appointment and the candidates are lacking on our database, we can reach out to local arbitral institutions and to collect and receive recommendations. So this increased the opportunity for the foreign arbitrators to be appointed as well. We can overcome challenges, and it was also discussed during the previous very, very interesting panel how we try to cooperate to resolve some policy issues, sanction-related matters, for instance, and in cooperating and having joint projects together. And finally, we can grow by educating the market and by being present, of course, in our own markets, but also internationally. Well, at this, I would like to end my presentation, and thank you very much for your attention.
Thank you, Natalia. We have roughly 10 minutes for questions, and I will only address two while encouraging the audience to make their comments or to address questions. The first one is sort of a question generated by the answers to the last question. Very interestingly, 23 votes, which is number one, say that people or users would like to, for the arbitration rules, to provide for fully remote proceedings. The second position with 21 votes, more efficient control of the arbitrator's compliance with time limits, discussing about too loose or too light touch of the arbitral institutions. And the third one is include provisions on electronic signature of the awards. And here comes my question. I fail to understand why everybody is so reluctant in using electronic signature for the awards. I don't know whether it is a legality issue. I also fail to understand it. But we are happy with 3 arbitrators sitting in different jurisdictions deliberating, and then everybody seems not to be happy with the electronic signature, and sometimes you get to spend 3 weeks for gathering the signature on the same piece of paper. And the question is it possible to electronically sign awards today in an ICC, in a SCC case? And you have the freedom to tackle.
I actually wrote an article on that, so thank you for the question. No, it was just a couple of weeks ago. There was a court decision in Sweden saying that there is a requirement under the Swedish arbitration law that the tribunal has to be signed, and the court interpreted that as being signed in wet ink. And in that case, the arbitrators had written their award. It was an ad hoc arbitration, I should say. They written award in a Word file, and then they did, as many of us in many instances do, they copy and pasted in their scanned signatures into the Word document, and then they PDF the document, and off they went to the parties. And then, like 2 weeks later, they did do the effort of sending around a signature page to everyone. And it was, by the way, fully Swedish arbitration, so it wasn't all that difficult. But so after, then they collected the signatures and incorporated into this PDF file and sent it over again to the parties. And the court said that, when this PDF thing with scanned signatures won't do. And well, then being a pragmatic Swedish court, they said, well, the award did not really, did not fulfill the requirements because it wasn't signed, but because they circulated the actual signature page later and sent it out within the time frame, then that was a correction to the award, and the award was not annulled. But it was, you know, it was almost there. So I would say when in Sweden, please do sign in wet ink until we have heard anything else from the courts. I would say that my bet is that the court perhaps would accept properly digitally signed, but I'm not the one testing that one.
I think this is going to change. LCIA, as you know, in the latest rules has the electronic signature. And there are other arbitration institutions, for example, in Brazil, CAMS, CBC, where the electronic signature is possible. And of course, if you think about it, this facilitates exactly saving costs, having an efficient or expeditious end of the award or during the arbitration, in particular when you have terms of reference to be signed. So I think this will change, and we can see this, I don't know, in Romania. We're expecting.
The other question refers to the SEC Express, which is, I simply love it. I don't know why it took so long for somebody to invent it, and it was obviously SEC. I find it a very useful tool, and I'm pretty sure as the parties are going to discover its existence, it is going to turn out to be useful. But my question for you, the inventors of the Express, is the following. I imagine that two parties that go to an early determination that can remain non-binding and confidential are not ready for various reasons to go to arbitration. So they are reluctant, they are not sure, whatever, because if they were ready to go to arbitration, they wouldn't have used the Express. My question is the following. What do you anticipate? What do you foresee in terms of future development of the institutional landscape? Is it enough to provide that early determination that may make both parties unhappy or both parties partially happy, or something new should come up and a sort of supplementary alternative dispute resolution mechanism should be in place to continue to provide further on assistance to those parties who may not be ready to settle following the early determination, which is quite efficient following the usage of Express. So I'm wondering, I'm sure it is going to be successful, but I'm wondering whether only the Express and that early determination suffices, or perhaps as time goes by, Express is going to have some brothers and cousins within the SEC umbrella to allow the parties to reach a settlement.
I was just good, but I'll give Natalia the floor, obviously, and I with the disclaimer that I was part of the final committee reviewing the final draft of the SEC Express, and we had various discussions because the idea of having the SEC Express came from the users. So it was the corporate counsel actually looking at the toolbox at the SEC and thinking about the necessity of having this tool and the three main reasons why this was requested, and Cosmin was right pointing out that there was trust in each other to accept this kind of dispute resolution mechanism. They were not ready for the arbitration, or they wanted to have a resolution in a way or a position on the dispute as fast as possible because of their nature of their business or the relationship between them. Now, I understand your concern, obviously, but and we're yet to see in practice. What I think is not missing is creativity and the fact that there are enough dispute resolution tools up there. And I think what is important is for the parties to be aware of them, and not only to be aware of them, but to be aware how they can use them for the specific dispute which occurs under the contract. And to have, I would not say this creativity, but trust to some extent also in this institution that it is possible to find a suitable dispute resolution mechanism for that particular type of dispute. Natalia would add to this.
Yes, thank you very much, Karina, for the explanation. And I just want to mention and comment on Cosmin's question. It's very right to the point. And the trend today has been picked up by Working Group 2 in Ancitral, which works on creation of something similar that Express. And Express is actually used as one of the sources for inspiration for the Ancitral group. And the idea by the Ancitral Working Group 2 is to create what is in-house called supersonic rules, very fast dispute resolution. At the first stage, non-binding, but currently they are very extensively deliberating on how to make such a mechanism binding for the parties and enforceable. And this is the trend. Perhaps we will see a very interesting result of the working group's work and project. I'm really looking forward to it. And we will see who will be first to invent this mechanism, Working Group 2 or perhaps the SEC. Because if it is demanded by the parties, then we will definitely try to develop such a mechanism.
Questions? Comments, please. Just a second, because we have online audience and it's better with a mic. it will come right away.
Philip Peters from Vienna. First of all, thank you to all of you. That was quite interesting. I have a follow-up question regarding the issue of the signature under the award. And I find it rather interesting to hear it called wet ink signature, because as you briefly mentioned at the end, a qualified electronic signature might actually suffice. Now, if I'm not mistaken, I think that in principle, in all EU countries, something like a qualified signature exists, and it is legally equated to a wet ink signature, right? So wouldn't that mean that in principle, if using a qualified signature, all these discussions could be done away with?
In principle, yes, but I wouldn't dare to test. No, but it's under the Swedish Arbitration Act has this particular requirement, and that is even the one that is considered to be public policy issue. And even though in the Swedish courts, in line with this EU directive, you can file your, for example, statement of claim or application for summons with digitally signed. So that speaks for that, but until this requirement is there in the law and is considered to be public policy issue, I wouldn't dare. But someone's got to test it.
Okay, let's see. Thank you.
Can you please the mic to Stefano back there, because he wants to add something?
Well, Natalia mentioned the work of the working group 2. Within the working group 2, the issue of the electronic signature came up, because the real issue, I think, it's not the application of national law, but is according to the New York Convention. If you try to circulate an award signed electronically, you might encounter a lot of problem in many jurisdictions that apparently they are friendly, but they are not friendly with ink signature. Try to picture with the electronic signature. So in many jurisdictions, as he said, in Italy, we absolutely, I think it would resist a challenge in a award signed electronically, because in our jurisdiction, you can do almost everything with electronic signature. So that's not what does concern me. But when you wish to circulate the award according to the New York Convention, then you have a problem. So it's not a domestic issue, it's an international recognition issue. To the best of my understanding, being the delegate at UNCITRAL, I think that we are discussing, because that's one of the key features of an expedited process, as Natalia mentioned, not to spend 3 months, as it has been said, circulating the piece of paper.
Other question, or please?
Thanks. Karina, you talked a bit about diversity and the fact that the SEC has done quite a lot, as have other institutions. At the Scottish Arbitration Centre, we now have a provision in our rules so that you have to, in terms of appointing arbitrators, consider diversity and inclusion in terms of the pledge and also the real campaign. I wonder if you think that your institution and others actually need to go further like we have. The other thing we've done is put in place a panel, a new panel. That initial panel is just women as we try to move towards a diverse panel. So do you think these sort of measures can help, and is it something that you at SEC would consider?
Yes, the SEC is also the signatory of the pledge and also supporting REAL in terms of diversity. And it is a conscious effort to address this gap in terms of appointments. And to be honest, for me, when the report came out and being on the SEC board, of course, we can see this. But when you have the full picture and you realize that in terms of appointments and the fees received, it is not the numbers. You might have the right numbers there. You might get to 54%, as the SEC did last year. But in terms of the cases or the nature of the cases and the value of the cases, there is still inequality. Now, by the nature, and probably this is you're going to see with the Scottish Centre, inevitably, in terms of nationality, there will be I would say a gap in the appointments, because naturally you're going to receive like the SSC more connected to the Nordic countries, and therefore you need the arbitrators matching the nature and the applicable law in that case. But the idea is when you do have the possibility as an institution to, in your appointments, to be diverse, you should grab that opportunity, and in particular with the remote hearings nowadays, to be able to expand the pool of arbitrators. But I think the key issue is to reach out to, and Natalia and the Secretariat is doing this constantly, reach out to users and discuss all these concerns with the users, because the institution can do as much as the institution can do. 35% of the appointments in the past 10 years have been made by the SSC board. It's a large number for an institution, but the rest, until 100%, is done by the parties.
Yes, and I have one point to add to this. There is one role where female appointments are dominating, and guess which? Secretary of the tribunal. Do you recognize the picture? Well, and of course, this also confirms that actually the system and the picture in general is by far more complicated than institutional appointments. We have to influence the industry in the whole. We have to educate by producing the numbers and correct statistics. That's like figures actually convince by far more than just discussing that this is good to appoint female arbitrators. That's what we try to do.
Thank you, Natalia. While listening to the very interesting explanations, I've had an epiphany. 21 of you have 5 minutes earlier said that you expect more efficient control of the arbitrators' compliance with time limits, and I'm 5 minutes behind schedule. This is the end of the sensorial journey. It's about time for a coffee. Join me in the round of applause for our distinguished speakers. In 10 minutes, we are going to be back. Thank you.
and I would like to thank the organizers, Cosmin, Krina, and Sorina for having me here. It's quite a difficult task for us because it's the last panel of a day, which was quite intense. But still, I think we will be, as Cosmin stated before, also great and perfect. I count on the speakers in this panel who will introduce us in the deepest side of the involvement in the arbitration by the parties. In fact, the arbitration is for the parties. And with this panel, we will see how the parties effectively live their involvement in arbitration by the most authorized voices of the parties in such an involvement. We'll have today I will make the presentation of all the speakers first, and then we will go in a series of questions, which will be transversal, and each of them will answer and provide his input in respect of those questions. First, I'm very honored to have beside me Mr. Edgar Martinez, who's International Dispute Resolution Senior Director of JTI HQ. He's arbitrator and dual qualified lawyer in Mexico and Paris. He's also professor of arbitration, mediation, and negotiation and private international law with the Law Faculty Panamericana, University of Mexico City. He's working, as I was telling you, for JTI, but he was before president for the Mexican National Tobacco Industry Association for 2 terms, and he was spokesperson before legislators, media, radio, and TV interviews in this capacity. Mr. Oscar Goddard is counsel and arbitrator for Biro Legal. He has acted as counsel in arbitration proceedings under ICC, LCIA, SCC, and FAA, and rules as an arbitrator in institutional and ad hoc arbitrations procedures. He worked as a litigation counsel with Baker Hughes, as a co-head of dispute resolution at Dotir, as senior associate to Rothschild, and as visiting international arbitration counsel at General Electric. Mrs. Crina Ciobanu is head of legal business at head of legal and business affairs at POR Romania, and she was before, and this is interesting for our panel, as Oscar, she was also external counsel. She worked for Suciu Popa. She was managing associate and partner to Suciu Popa before she was working with Mușat și Asociații and with Rodel and Partners. And also Cristina Vâlcu, who's genuine inside counsel for having an excellent, prodigious career within BRD Group Société Générale. She was director of the legal department, and she is now executive legal director of this important Romanian bank, Romanian-French bank. Or multinational bank. So with this impressive distribution, we'll try to see how various in-house counsels in various industries and in various levels of international business involvement see the arbitration, and we will start with the first episode, when deciding which contract goes to arbitration. I would like to ask you if there are or not if within your companies or with your previous experiences, there are pre-established policies of the companies providing the criteria for selection of the transaction submitted to arbitration, or you take this decision based on a case-by-case analysis. Oscar?
Good. Yes, well, from my point of view, I've always worked in housing companies where the standard terms and conditions always contain an arbitration clause, and where the policy and philosophy was essentially that everything that we can put to arbitration, we put to arbitration, the only exception essentially being contracts with state companies or other similar parties where they wouldn't agree or accept arbitration, and we would have to utilize the state courts. Briefly put, everything to arbitration.
Thank you, Edgar.
Well, we do have a contract policy that applies all across the jurisdictions where the company operates. And before, it used to have a provision that said that if a certain threshold was exceeded, then we would take this to arbitration. But this provision was removed because it creates all types of problems. Whenever you, for example, the other party doesn't want arbitration, and if you accept this, you would need to process an exemption to the policy. So it's one of the things that I've heard across the panels is a lot of the concepts, no? But then the other thing is how we live them inside the companies. No? So this was removed because of all these all of these problems. So yeah, we definitely go on a case-by-case basis. But yeah, I mean, the general guidelines or understanding is that we would prefer for international relations arbitration. Then, of course, our markets are autonomous to make their own decisions. So we have the legal directors in each of the jurisdictions, and they would be able to choose either arbitration or local courts depending on their on the specific case.
Thank you. And Krina?
Hi. First, I would like to thank you for having us here. You have a very nice community here, and we, as users of arbitration, as your clients, feel in good hands with such professionals, so thank you. Now to answer Razvan's question, we are, as a construction company, in a fairly niched domain, so in our contracts with the private clients, we tend to use the FIDIC suite of contracts, where the arbitration, ICC arbitration clause is the standard jurisdiction. However, when the client is a state contracting authority, we are bound to use the so-called Romanian adapted FIDIC form of contract, which sometimes allows the contracting authority to opt for arbitration. But the truth is then that more often than not, they opt for litigation. And then for us, it's just a take it or leave it situation. If you participate in the tender and you win the contract, you have the litigation and no choice to make. With our subcontractors, however, it's a case-by-case decision. There is no pre-established matrix. We decide depending on the complexity of the contract and also on the value of the contract. We will not go to arbitration with very small contracts, but for sure we do prefer arbitration for the higher stake contracts.
Thank you very much. Christina?
Prior to your question, I would have said that in a bank you have a policy for everything, but we don't have a policy for arbitration. So I was wondering why, but in fact for the loan agreements where the Romanian legislation recognized the writ of execution, we don't really need an arbitration provision. But for other type of contracts, we do look at them from a different perspective on a case-by-case basis, let's say. So we don't have a policy, but we are open to having such provisions in the contract.
This introduces my next question, and you may continue to keep the floor. There are, however, some criteria that you always apply in order to determine, to make this case-by-case determination?
We look at the legislation that will govern the contract. We look at the amounts at stake. We look in case there is a breach of the contract, how fast we need to solve it. So this kind of criteria. Of course, when the moment comes, we really need to look at the cost as well. But we see a tendency when negotiated by the business, our colleagues in business, we see a tendency to leave this part either to exclude it from the contract because it's difficult to negotiate and it takes time, and maybe after a long course of negotiation, this is the last thing that they want, or they are asking us to step in and further discuss and agree on this kind of provision. But this depends on the business side, if they want to continue or they want to end the negotiation process.
Thank you very much. Krina, what would be your view on
Well,
this?
our aim, as all companies' aim, is to resolve the dispute in a speedy and effective way, and you will be happy to hear that we do advocate to the management arbitration always as being fast and effective. And the enforceability of the award in the same conditions as the decision of an ordinary court is also of help to convince them that arbitration is the way to go rather than litigation. So these are the criteria, the manner in which the award can be enforced as quickly and as efficiently as possible, and how quickly the procedure unfolds. That's obviously cost is also an issue, but not always the most important.
Let's continue the tour of table. Oscar?
Yes, well, as I said, from my experience, generally there hasn't been any let's say, criteria on whether to choose arbitration or not, because choosing arbitration is always the choice to go, in my opinion. Especially if you're discussing, let's say, contracts that have some sort of substantial economic value. Like obviously there are contracts that are so small that it might not be sensible. I do think that there's, however, criteria where it's better to not contract if you can't get a good dispute resolution clause. And especially in international trade, when discussing between contracting parties from countries that are not, for example, within the EU and would be subject to Brussels I, you get situations where if you have to go to the national courts, the whole contract might be essentially void, right? Because you wouldn't be able to enforce the awards or decisions given by a national court in a certain place in the other jurisdiction, right? So there might be those red lines where if you are forced by the contracting party to either take a national court that effectively provides you no workable legal recourse, that you not contract.
Ooh, many things to say here. It's just listening to you. Okay, so for us, it's a little bit different. We do not treat this as a deal breaker. No? So I mean, we discuss it. We give of course, our opinion and say like these are the risks. But at the end, it's a business decision, no? And we act sometimes in this regard as advisors, no, to them. But it's very interesting that of course the opinion by legal matters, no, and they take it into consideration a lot. So here I can think of several examples just for purposes of time. Let me give you one or two. It's whenever the other parties really wants their local courts, it does create a little bit of suspicious, no? Like why do you insist so much on this, no? So we tend to tell the business, I mean, why don't we take this to a neutral venue, no? And arbitration, it's a perfect example for this. And sometimes when you put these thoughts in the mind of the business people, they start thinking, oh, and this was also weird, and this was also weird, and they start connecting dots, no? So it's part where you become a business partner with them and say like, we want the same thing, and at the end, if we end up in court, we are here to support you, no? And for example, there could be other cases where it's actually easier to when you say let's go to arbitration, it's actually easier for the other party to accept, because we can put ourselves into the situation. Now I want Swiss courts, for example, no? And then the tension, it's released through arbitration. So it really depends on how good the negotiations are with the supplier. Yeah.
My next question would have been if there are also criteria to distinguish between various arbitration bodies, rules, seat of arbitration. But I would add to this question the following idea: is this a different question of the previous one, or is just an issue which is viewed together with various national courts and various arbitration bodies, rules, seats of arbitration, and in fact the choice is multiple from all those various availabilities?
Yes, I mean, of course, everything is a holistic analysis. No, you cannot separate. But we also have other. We do not go only with one institution. No, we operate all over the world, so we try to balance this as well with institutions, with rules, with applicable laws. At the end, we have the capacity to operate all over the world. No? So the question that I normally ask external counsel when they support us is, okay, what would you recommend, no, in this specific scenario? So we have, for example, the unprecedented discussion with Russia, no, in the past years. So say, like, if you have, for example, an award issued in Geneva, will that be enforceable in Russia? And then everyone starts, well, yes, but it depends, but there is this risk, and there is a potential counter-sanction, but there is an exception here. And then, so then when you do the commercial assessment, you try to go, of course, for the more predictability and the less risk as possible. If you're already doing business, it already entails a risk. Why do add more, no? So we tend to then select either institutions or rules that would, you know, reduce that risk as much as possible. It's not only, oh, because I like this or this other institution. No?
Yes, well, it's a very multifaceted question. I think, well, first of all, the choice of the institution, the seat, I think is a very significant one. From my point of view, I think the first question is to make sure that there is a institute and seat where you can get a functional arbitration proceeding that is hopefully not too problematic and you'll get an enforceable award. I think quite often the choice of the arbitration clause and various components of it sort of becomes this bargaining chip, where, you know, one of the parties wants to pull towards their home jurisdiction or region. There may be discussions around applicable law and so forth. And quite often then you sort of, for example, when contracting with an Asian party, might agree to a SIAC arbitration or place the seat of the arbitration to Singapore or somewhere in the region to sort of give something in return while keeping sort of the institution you would trust in there. And generally, so what I've advised my internal clients usually is that if the counterparty doesn't accept a known reputable international institution, there's usually a reason for it, and usually you don't then want to go into that, right? So there usually shouldn't be a reason why somebody just wouldn't accept any of the, let's say, top 10 international institutions. Like one of them should be workable. Maybe one more aspect to this is sort of the strategic aspects. So when you are, for example, looking at a, let's say, for example, a large manufacturing company, your sourcing terms, like how you contract with your contractors, there might be strategic aspects with that as well, right? So if you have an ICC arbitrator with 3 arbitrators based in Paris, for example, that in itself becomes a quite significant sort of deterrent for smaller claims or unnecessary claims, and that could also be used as one sort of let's say a strategic aspect in contracting. And then maybe the final thought is, which is not necessarily that often discussed, is the aspect of cost. And at least from my experience, it's not the cost of the arbitral institutions or necessarily even the arbitrators, but it's the cost of the counsel that usually becomes the big issue when you actually have to go to arbitration. And it's usually then not the choice of the institution, but the choice of the applicable law that becomes the decisive question, right? So if you apply New York law or Texas law, right, you'll know that you'll get a more expensive arbitration process due to the cost of the counsel than choosing Sweden and SCC, for example. And therefore, I'm usually sort of rather, especially like if you want to arbitrate and you don't want to spend a lot of money doing that, I'd highly recommend considering institutions like the SCC and applicable laws like the Swedish law, which can then as a package provide you a much more efficient proceeding than some other options.
Thank you. Krina?
Well, we are a Romanian company. Our contracts are governed generally by Romanian law, almost always. So I advise my colleagues always to opt in the arbitration clause for a renowned, reputable institution. It's always easy to negotiate with the other party. They would accept it fairly easy. The seat of arbitration is also extremely important because in an arbitration-friendly seat, you often discourage all these frivolous challenges to the award. So in order to avoid any belated enforcement of awards, we would always go for the reputed institutions which were present here today, because they're always accepted by our partners.
Now, if the dispute starts, I suppose that you have another decision to make. Will you let that dispute to go into litigation, arbitration, or you'll try to settle? And I suppose when you're making this choice, you'll consider also the pre-assessment of the legal risks of each of those two options. What is the importance, the role of this pre-assessment of the legal chances of success in an eventual dispute?
It's essential, absolutely essential, because very often you think you have a case, and then when you start assessing it in depth, you see that you may not have a case. This is where I would say the role of the internal legal counsel is quite important. Of course, we team up almost always in serious disputes with external counsels, but I think the internal counsel is the one that can really, truly assess the risks of a claim, having access to more information, to the people who have the information, to maybe the documents that are available, and so on. So risk assessment is the first one. Second, indeed, mediation and settlement will be for the management the preferred, at least for our management, always the preferred option. We try it. I admit non-institutional, private mediation and negotiation. We have not really used the institutionalized mediation so far. And if there's no success, then we have to go to arbitration if the risk assessment show us that it's feasible. When we're claimant, if we're respondent, then we don't have much choice. We can still settle, yeah.
Christina?
Yes, I was thinking while Krina was talking that there are, in such cases, there are some important milestones. So this is the first important milestone, when the internal legal advisor steps in and assesses the situation. And building up on what you were saying, it's the role of the internal legal advisor to ask the proper questions. And being part of that team, you know how to ask the questions. You know how to ask to see the vulnerabilities of different systems or procedures, and to ask the proper questions, not to look like you are blaming somebody in order to obtain the truth. So this is part of the corporate world we are living in. So yes, I would say that this is important, and the role of the legal advisor is very important in determining whether to go on an arbitration, settle, or go to litigation, getting a lawyer or not. So the first milestone.
Thank you. Oscar?
Yes, fully agreed. Maybe just two notes. I think, first of all, I think it's very important to do that analysis as a written paper and a written exercise instead of, sort of falling to the trap, which is quite enticing for in-house counsel to sort of look at the papers and then come up with an opinion based on that and send an email. I think it's a good practice to actually write that out as a full report, go through the facts, go through the evidence and so forth. That then, you'll have that report with you 6 months down the line, and you'll know why you draw those conclusions, and you don't have to rely on your memory. The second point I would like to make on this is that I personally am a big proponent of putting numbers to the paper and to help your analysis. And there's a branch of analytical philosophy called decision theory, which is essentially the theory of assigning probabilities and numerical outcomes to different options and alternatives, which is in the very sort of simple case, you could do it as a outcome-related analysis. You look at, let's say, the best case, the worst case, the most likely case of a case, and then you assign, you go through the potential financial implications of those different scenarios, and then you assess what is the likelihood of these scenarios actually materializing. Then by multiplying those probabilities and the outcomes, you'll get a figure, right, which is the expected utility, expected value of that case. Alternatively, you could of course look at it as an analysis of the whole case, right? So if, for example, you have, let's say, 3 different questions, right? You have a question of damages, you have a question of causality, for example, and limitation of liability. You could analyze all of those different questions as a probability of winning or losing that, and then coming into a conclusion to sort of what is the expected outcome. And I think that both is a helpful tool to actually assess settlement discussions and mediation discussions, when you can go to a mediation saying, this is our expected outcome from the arbitration, essentially the Batna, Ratna, and Watna in negotiation literature, to give you like those walkaway points in a mediation context. And it can help you as a assessment tool, even if you are not, for example, able to be very precise on what the probability of a certain outcome is. You can say, well, if the probability of that outcome would be let's say 70%, right, which is quite bullish, what does this look like? So, and then if we reduce that confidence to let's say 50%, you'll get a different number. And that helps you, I think, quite well to identify, for example, good zones for settlement discussion and decision points for initiating arbitration as well.
Very interesting. They would love you in Japan Tobacco, no? give them an assessment with numbers and probabilities. Well, actually, you cannot get rid of that. I mean, the risk assessment is mandatory. I mean, it doesn't matter what you do, you need to go through that process. Either you do it super sophisticated, super light, but you have to go through the process. And yes, you normally ask external counsel, and normally external counsel do not give you a number and the probability, but you don't get rid of that. I mean, the business demands you that. Say okay, but now what do you think? Are we winning this? Yes or no? And then you have to answer. So it's I mean, of course, you need to review the evidence and everything. No, so for example, part of my role as international dispute resolution, it's of course to recommend the clauses when the contract is being discussed. But if people believe, or business colleagues believe, that we are in the verge of a dispute, we also do this internal assessment first, no? And then we tell them, well, you need to correct this, and what the culture that the general counsel wants to build internally, it's approach legal as quickly as possible, no, as early as possible in the process. We believe that rarely there is a dispute that you were completely unaware, really rarely, even being a respondent. So it's you know what the business is developing and how it's cooking. So the closest you are to the business and the earlier you get involved, it's the better, no? Then there are some situations in which you say, we are doing a mistake, no? You need to correct this, and you're still in time, no? And so it's international dispute resolution with focus on resolution, not on dispute, no? And it's how do you control this? It's you of course try to negotiate, you of course try to settle, but I mean, depending on the case, sometimes the opposing party will not even be open to a discussion, no? So then you do the assessment, and with that, you decide to move forward or not. It's very practical. It's really to the ground.
One more point.
Yeah, please.
So maybe one more point to this is to add, I mean, especially if you're working in or with as an articled counsel of a listed company, this sort of assessment plays into also accounting and reporting questions, right? Because you usually have to at least quarterly report your contingent liabilities, and the auditors will require you to provide a accurate percentage. Well, not an accurate percentage, but at least you know, whether it's more probable than not that you'll win or lose, and what's the implication of that. And having that assessment, case assessment, which you every quarter, you know, reviewing that and updating it also serves as very good sort of background documentation. If there are, for example, questions that you'll have a big case, let's say tens or hundreds of millions, which you lose, which you haven't reported as a, you know, more likely to lose than not. And then when that thing hits the fan, you'll have that documentation to show this is what we've based our analysis and reporting decisions on previously.
Thank you. Now, passing to the next topic. The next topic refers to the moment of drafting the arbitration clause. I suppose that you always use standard clauses, and my question would be, is any time any reason to deviate from a standard clause that you have decided to use? What kind of reasons might determine such a deviation? Please, Edgar.
Thank you. We tend to prefer, honestly, institutional arbitration, because it's not a deal breaker, the ad hoc arbitration, but yeah, we would discuss it a little bit more with the opposing party when we are discussing the clauses. Another recommendation is copy-paste model clause. It's as simple as possible. And yes, I have seen clauses proposed, like 2-page clauses, that I was like, no, let's put the model clause. And I try to refer the opposing party to, you know, look at the website, look at the recommendation of the institution. It's not me, you know. It's and try to blend in it. Normally, it's accepted. So I mean, deviations to the clause, I mean, only, you know, place of arbitration language, but like as minimal as possible.
Yeah, I would tend to agree. I think using model clauses is almost always the preferred option. I think that sort of also ties into the question of like who actually contracts. And I think having that sort of mantra in your company that always use the model clause, you know, in top of the head of the contracting commercial people is important. I think I would very much love to say that yes, there are these, you know, wonderful ways of modifying the arbitration clause. I'm a big proponent of mediation. I would love to, you know, use made-up clauses. I would love to, you know, impose stringent deadlines on the arbitrators. I would love to limit document production and many other things. It's just that even though it's very enticing, it's just the risk of having an issue with the clause and then not having, you know, access to arbitration is just a bit too scary sort of idea that I generally tend to just stick with the copy-paste clause.
Krina?
Yeah, we go for the standard clauses always. We don't want to leave room for any interpretation, so it's safer that way. We always copy-paste them, and that's it.
Okay, but in this case, how the defective arbitration clauses appear in practice? Because sometimes there are.
I can answer that because I fight that every day. It's because the negotiators are not lawyers. They are not the legal people. We have hundreds of contracts being signed daily. They get standard contracts from us with the recommendation not to negotiate clauses that have to do with liability, termination, jurisdiction, and so on. And they always come back completely changed because the commercial will always use as bargaining chip the clauses that he doesn't understand. So it's a complete confusion between the various components of the arbitration clause. The seat, they have no idea what it means. They just think that it's going to be the city where they're going to have the hearing. And then they cherry pick various elements that they think are interesting, and they cherry pick some sort of, I don't know what capital city of Europe, because they think it's going to be nice to go on a trip for the hearing there, if the case be, and you end up with pathological clauses. I am even now undertaking a process of automizing the contracts in such a manner so as to actually block the jurisdiction clause so that they cannot amend it, and if they do want to amend it, to the legal to get an automatic message that someone is trying to change the clause, and then it can only be changed with the legal department's approval. It's the only way out because we've been insisting on them not to intrude on the clause, and they still do. So it's not the legal's fault. that you do, that you're faced with some very weird clauses sometimes. It's the fact that people don't know what they're negotiating, and it's always easy to give it up for something else. If they get a 5% discount on their offer, they just leave aside the jurisdiction clause altogether. So,
Thank you. Do you like the multi-tier arbitration clauses, the mandatory negotiation or mediation before going to arbitration, the DABs and so on? Do you like this?
we as constructors, not really, because they're not directly enforceable and they take ages, and then you end up most of the time in front of the arbitral tribunal anyway, so it just prolongs the entire process. So no.
We don't use them that much, to be honest. It's we have in some contracts, but it's based on the negotiations with the opposing party, no. But no, we don't have them just ready to go for the same reasons. Yeah.
Oscar? Yeah, I mean, I'd like to use them. As I mentioned, I just usually wouldn't recommend it. The disputes where I've been involved, where there has been a mandatory mediation or negotiation clause, unfortunately, it seems that almost in each of those cases, one of the parties decides to sort of try to frustrate it one way or another. You know, they don't. If there's a negotiation or call-off period, they just won't actually negotiate. So I'm yet to be convinced of the value in relation to the risk of actually modifying the clause.
More generally, the mediation might be a competitor for arbitration, or rather traditional tools.
I can continue that. I mean, I think mediation and arbitration is definitely not a competitor. I mean, they are completely different forms of dispute resolution. Arbitration is adjudicative, mediation is amicable. But I do think, and I'm going to take, let's say, a strong viewpoint. If it would be possible to ensure that every single dispute I've handled goes through mediation first, I would opt for that option, and that flows from both my experience in settling every single case I've ever mediated, and from statistics. So Italy, for example, where I used to live before, introduced a mandatory mediation law. After that, 80% of cases settled. I think it's super efficient, and even if the sort of traditional view is that unless the parties are sort of willing to discuss and are willing to see eye to eye and commit to mediation, it doesn't work. I don't think it necessarily is so, especially the common law US-based mediation, right? The sort of parties in different rooms, mediator shuttling between them to find a commercial deal. Super effective. Even if I've literally been in a mediation where the parties were in so bad terms with each other that they couldn't be in the same room, and we still settled within one day in mediation. So very big proponent. It doesn't, of course, always work. There's always cases where it doesn't work, but I think the opportunity cost you lose with that is so limited that I think it just basically always makes sense. And maybe one more point. I think it's usually outside counsel who sort of prevent that. So if you're in-house counsel, make sure that your outside counsel doesn't sort of torpedo your possibility of getting to mediation.
Christina, would you like to intervene on this point?
Yeah, I kind of agree with you, but thinking it practically, whenever you face with a possible litigation, then first the business colleagues tend to have an informal mediation between them. Then it's clear for them that among themselves they cannot solve this, and they come to you, and then you come and say, let's go back to mediation, but this time in a formal manner. And then we go to court or to arbitration, and they say it's taking too much, I cannot wait. So then you make an assessment, where do you want to go? So yes, mediation might seem a good choice, but not always, and sometimes it's overlooked just because of the time constraints.
I see. Krina?
Well, mediation can help sometimes. I think maybe in contracts where you're still partner with the other party in other contracts. So you may want to keep the relationship going and not reverse straight away to arbitration. It shows a bit of good faith that can help in your relationship with your partner. We've not had great success with mediation, I have to admit. We tried sometimes, as said, with the long-term clients of ours with whom we want to maintain the relationship, but it certainly is not a competitor of the arbitration, no.
Thank you, Edgar.
I don't have that much to add. I mean, normally when they contact us, again, they have already tried to negotiate some sort, no? This is what we're trying to change, to get involved as early as possible to precisely avoid that they already tried this and they believe that the negotiation will not be possible. Then to include a mediator, you receive the same comments saying like, but why? I mean, we already tried and this is not binding, let's push forward. We're going to be perceived as weak. You know, you hear a lot of comments, no, different comments. So, I mean, yes, I mean, it can work, but we do not use it that often. It's, yeah.
Okay, another kind of choice that you would need to make in respect of arbitration would regard outside counsel, the arbitrator, the party-appointed arbitrator, the experts, legal, technical experts, and so on. Which is the exact involvement of the in-house counsel in making those choices? From where do you get the information? How do you participate in this process of decision making?
You mean for choosing, no? The external counsel and the experts, yes.
All those characters are important.
Okay, so this is it. Some companies have policies where the hiring of any external service goes through a procurement process, no, which is like internal. For us, everyone that wants to hire a service in Japan Tobacco has to go through procurement, and it's a whole area. For law firms, this we handle from the legal department, but still we need to go through a bidding process. So we, depending on how on the matter, you draft the terms of the bid, and then you invite law firms based on law firms that you already work with, but also with expertise, depending on the jurisdiction, depending on the threshold, and we have very specific rules for that. So we need to, because if you cannot choose just whomever you like, no, you need to prove to the business that it's a very objective or the most reasoned decision, no? And the same would happen with the experts. So we have a list of vendors, preferred vendors, you could say, but it's always open, no? And they compete every time that we have an arbitration, depending on the threshold, on the amount.
And the party-appointed arbitrator?
The party-appointed arbitrator, we have a very modest, I would say, list of arbitrators that have been in our cases in the past. Not all of them, but we have been building it little by little. And we include some comments, no, if we like them or not, if the other party has proposed them. But yeah, we go through a very thorough process, no? So starting from Google and telephone, which I love, calling people that, you know, I mean, who the other party has proposed this arbitrator, what do you think? Of course, with external counsel, I would never impose an arbitrator to external counsel, no? They need to be in agreement with this, so we try to align on this. But yes, we go through a very thorough process for arbitrator selection.
Thank you, Oscar.
Yes, fully agreed. I think that the tendering process for law firms is quite important in driving your costs down. Maybe to add to that, I think two other critical sort of, especially if you have, you know, fairly large litigation or legal budgets, is to use your own engagement letter terms and models for law firms. And if you have the opportunity to, you know, to use also a outside counsel policy, right, which you can then use to reduce that cost down, you know, significantly. So what we quite often see, or what happens quite often, is that you have maybe tendering, you'll get a quote from the law firm, but it's not binding, for example. And then, you know, they quote 700K, and then it's 1.5 million or something. So if you, you know, contract in the same way you would contract with any other commercial party, and essentially require capped fees on capped quotes from the law firms, which you can do through the tendering process, right? You can say, this is our assumption list for the case. We need capped fees, for example, capped by the face of the case. And then you get the quotes in, and then you can, for example, have a second round of bids. where you can say the lowest bid of the last round was this, would you like to meet that? And then when you have your own terms governing, you can generally ensure that your lawyers are not able to exceed the budgets that they give to you before you start the arbitration. And maybe one final thought, I think it's usually also good to add to that bidding process at least one smaller or alternative provider, because if you only have, like, let's say 5 Magic Circle firms in that bidding process, you'll get the same exorbitant bids from all of them. But if you include some smaller or more agile players, you usually get significantly smaller fees in those tenders as well, which can then be considered, not necessarily chosen, but it isn't usually a good idea, I think, to involve those firms as well.
Thank you. Krina?
Yeah, we have a similar policy as Oscar was describing. We procure the external legal services similar to the procurement department, just that the entire procedure is done by the legal department. We do organize pitches. It's not always the lowest cost that is triggering the decision. We prepare price comparison tables where we add also the experience, the track record, and so on of the law firm that has been sent a request for proposal. We generally choose among 5, 6 firms that we've worked before and that we trust, because at the end of the day, it's the track record and the trust that are the main criteria based on which we choose. It's not always the price. Of course, we're not going to go, if the price is high sky, we're not going to go with the most expensive, but most certainly not with the cheapest. It's always a combination of the price, the track record, the experience we've had with the firm. We try to partner up with lawyers and have long-term partnerships, and that's why we take into account their experience and expertise in similar cases with us, with other clients, but also with us, not only the price. So that's how we choose them. And arbitrators, if we choose them, then it's clear that we trust them and they help us choose the arbitrators. It's a common decision, but we generally trust the externals to indicate who they believe would be most suitable for the particular dispute.
Thank you. Christina?
I wouldn't have much to add, but we look first at the legal matter, that it's the core of the litigation, and then we tend to go to the specialists in the field. Of course, we have the same procedure of auctioning the court or the file. Yes, the price is not always determining in choosing the lawyer, but it's important. It's an important factor. And in choosing the lawyer, you somehow envisage the strategy that you want, because it depends whether you have a more aggressive approach or lighter, or you tend to just show off somehow, not to scare, but to be more aggressive at the beginning, but then to stop during the procedure. But it depends. You building up the strategy when you choose the lawyer.
Thank you. That would be my next question. Which is the role of the in-house counsel in establishing the strategy of the case? Oscar?
Yeah, I mean, obviously it differs in-house counsel by in-house counsel. I've always tried to be very active. I think it's a good idea for in-house counsel to view themselves as a part of the legal team that handles the case. Not sort of differentiate between the external counsel who will do the advocacy and then the in-house counsel. I do think it is a good idea to work as part of the team, read through all the submissions, work to understand the case and the submissions. And I think it's at times in-house counsel may have the thought that, well, I don't have the expertise to fully appreciate or understand the argument or the intricacies of the legal case. I think that if you are in that situation, there is something wrong, right? Because the arbitrators will need to have to understand the argument. And if you can't understand the argument, then the arbitrator likely will not understand the argument, right? So I think you should be, it would be good to be very well involved. And then of course there are those, specific sort of fields where only the in-house counsel can provide the support that's needed. So document production, for example, interview of internal resources, and then of course, getting access or tapping into your, company's resources, right? So for example, at Baker Hughes and GE as a leading engineering company, like, of course, we at times hire external, or they'll hire external experts to give evidence, but then, you have that depth of engineering, acumen that you can use to develop the arguments, to work with the experts, to provide materials and do analysis and so forth. So I think that is also an important bit for in-house counsel.
Krina?
I don't have much to add to that. I think it's important that the internal counsel is involved. Most of the time, the internal counsel has a better view of the business. It's true that the external counsel you choose has knowledge of the industry, but it may not have such a clear insight of the actual business. So involving the internal counsel is always useful. It's a second set of eyes that sees the submissions, that may come up with ideas and link things together. I think the in-house counsel is very useful with witnesses. Being a colleague of the witnesses, it always helps at least being there and comforting the colleagues that everything will be fine. So it's certainly a collaborative work, and the inside counsel needs, and also the inside counsel needs to know the intricacies of the case, because he's the one reporting to the management. He's the one that has to stand in front of the management and tell them what the weaknesses of the case are, what the strength of the case are, and if you're not there and you don't know, and you just ask the counsel and you base your decision on the external counsel's decision, you may be wrong, because as said, the external counsel does not have the inside knowledge of your business. So if you want to be accurate in your assessment in front of the management, you need to know the case.
Are you all involved in the production of documents?
Not really. It's not really specific to the civil law jurisdictions. It's quite a complex issues. You need, in my opinion, you decide this together with the external counsel, but I would say it not always produces the expected results. So you must outweigh very thoroughly whether it's worth doing it or not, because it costs time, money, and you may not always get the expected results. So we don't have much experience with that, and if we do decide to opt for it, it's together with the external counsel, who I would say can lead the strategy better.
Edgar, the same view?
On document production, don't get me started. We need a full panel here. I mean, I understand conceptually what we want to do with the IBA guidelines, etc., and it's fine. But I mean, in my personal experience, I have never seen a case that was, won or lost based on something that was produced during document production. So it's, and the more and more I see it, the more burdensome it becomes. I think it's kind of an arbitration within the arbitration, with cost, with time. And again, one thing is the concept and how do we leave them in the companies. I don't think, it doesn't matter how sophisticated is the company. I mean, people, I think, believe that we have a button and it appears all the emails that as the arbitrator requested, and it's not. You need to look who was there 5 years ago. You have to go through the list and then check with each person if they are still in the company in another position. Then you go and search, you ask IT, then you put everything together. It's super burdensome, and and at the end, I've seen document production and say like, okay, all this effort and burden, and for this, I mean, I don't know. I understand it conceptually, but it's
you risk to appear as being on a fishing expedition with not great results.
Yeah, I fully agree. I mean, it can be incredibly burdensome, and I agree that I actually haven't seen a case either way which would have, had that smoking gun discovered in document production. What does sort of appear quite often is that you have document production exercises where you have very relevant and material document requests and the counterparty is unable to produce. And then, you know, at least in my cases, tribunals have been, let's say, not that keen to draw those adverse inferences, right? Which I think is sort of, you know, would potentially be a key facet of document production. So one example, there's a dispute on the condition of a certain piece of equipment, right? And this is, you know, oil and gas industry, which is quite stringent in maintenance procedures. And if in document production the counterpart is unable to produce any maintenance records, right? That should be, at least in my opinion, a quite salient point to the tribunal in considering whether the equipment has been maintained, right? And it seems that there's and I think this goes through, let's say, all those decision points where tribunals should decide whether to draw adverse inferences on certain points. And I think that might be something where, if that were to improve, you know, at least those points of document production would be much more useful to the parties.
Thank you. Practically all of you mentioned this position, already mentioned this position of double translator that the in-house counsel has. He translates to the party the course of the arbitration. He managed the expectations of the party regarding the award. He managed the emotions of the party's employees who might be involved as testimonies in the arbitration, or who might be interested in the result of the arbitration because they were involved in the facts on which the arbitration is grounded. Also, is the same in-house counsel who should translate to the outside counsel, or sometimes even to the arbitrators directly, the internal processes of the company who might be of importance for the award to be given. So it's a difficult translation between two words. How do you manage, Edgar?
Absolutely, it's definitely like a translation, to translate the legal reasoning to the business and the business to the external counsel. So it works both ways. I mean, personally, of course, the external counsel with which we work are very sophisticated external counsel. They go through the bidding process. They have very experienced lawyers, very experienced arbitrators. That's all fine, but none of them are experts in the business. And I mean, we cannot blame them. Of course, they have their own business, which is being external counsel and having many industries or many clients, no? So I believe that also in relation to the previous point about the strategy, it's fundamental that in-house counsel is involved, no? You need to explain them the business and specifically what led to the dispute. If you understand everything that went behind and how the business is structured, your arguments, the quality of the arguments, it multiplies by 10. I mean, I just don't understand an in-house counsel that wouldn't be involved on that. And also vice versa. You can tell the business, your business colleagues, they are convinced that we are right. But then you have to tell them, you know, yes, you're right, but here says another thing. What you say says something different. No? And you need to explain to them that before a tribunal, that would look different. No? And they will not give you, they will not say you're right. No? So then also you have to explain all the legal parts to the business and to reach a consensus where the business understands exactly the status of the case, and vice versa, the lawyers as well understand the implications of the business. No? So it's a double translation, yeah.
Yeah, I would think that our most important role is to maintain balance, because we work with people are emotional, and they sometimes tend to take drastic measures, especially the business people who don't really understand all the technicalities of the legal proceedings and so on. And they are tempted to take some sort of dramatic decisions and measures which may not have a good outcome on the case, or quite on the contrary, they try to hide certain facts or minimize the liability because they are scared that someone is looking for scapegoats. We're there to find out the truth, I may say, and to balance the emotions of the people in the business and to translate them to the outside counsel. I would also say that it sometimes minimizes the fees to the external counsel, because if you get started, one of the business people who was involved in a project, especially in construction, where projects are years and years long and where they gather frustrations and they are so determined to win the case, they sometimes get too excited and emotional, and they can be a burden on the external counsel. So it's your job to balance things out so that everyone understands everyone, and to see where the middle way is, somewhere where the balance is found. It's also, well, I would say that we are kind of psychologists also, especially when it comes to witnesses and hearings, where I've seen people in the company who seem to, and you all as counsels have seen them being very strong and self-confident, ending up in front of a tribunal all shaky and scared, and it's up to you to train them emotionally. It's the external counsel that trains them on whatever they have to say and how they have to behave, and it's you that has to support them, because they're your colleagues first and foremost, and they turn to you for help with their mental stability because they do get quite emotional and scared when they end up in front of a tribunal. They don't understand what's happening. When they sit there in front of the mic, they are all lost, and they search for you sometimes. They have to see you in the room, and they calm down because they remember that no one's going to kill them, and they're not there to be responsible for an eventual bad outcome of the case.
Yeah, I was thinking while you were talking that I think this is a very important part of our job, to translate in complete honesty, transparency, giving all the necessary details, not getting out of proportion the situation, but not minimizing the situation as well. So yes, this is part of our job. The first part is identifying the risk, establishing the strategy, getting the lawyer, external lawyer, so on and so forth. But then you go back to your boss and say, this is the risk, this is the vulnerabilities that we have, this is goes in our favor, but and I say we go further or we stop. But of course, sometimes it's me that decides the strategy. Sometimes if it's a very big case with reputational issues, then it's a matter of a decision of a higher level. But of course, I don't know, maybe for the banks, this is a component that it's considered as well, the reputational risk, when deciding on going on different strategies. So yes, it's a very important role.
I don't know if I have anything to add to that. I think that's quite exhaustive.
We can move towards the last series of questions. I confess that we had a preliminary meeting for this panel, and it was a spontaneous agreement of all four speakers that the arbitration is something to be avoided. so they all, I not necessarily, but they all agree with this. And also Edgar mentioned before that in international dispute resolution, the resolution is the key, not the dispute. So in this respect, I would like to ask them how they how they prepare and perform their strategy, their long-term strategy to avoid the arbitration. And then in a second step, we will discuss if, however, if the strategy didn't succeed, is, however, any degree of satisfaction finally getting into arbitration and benefiting of this kind of dispute resolution. Please.
Yes, of course. Okay, it's a very complex subject, because of course if you ask the business, it's like in my case they will say our business is to sell cigarettes, not to sue people, no? or getting sued. No? So this is not the focus. The focus is of course this commercial part. But then How do you support the business to do this in an appropriate way and to reach the business results? So it's always a balance, no? And as a transnational company, there are efforts that are multifunctional, no? So what we do is try to train the business whenever sometimes they don't listen, of course, but you try to train them. You try to be present for them so they do not see you as the lawyer that is going to say no to everything, no? I mean, we try to be a business partner with a legal background. No? That's what we try to communicate internally. No? And it also goes with a PR internal campaign. No? It's about the legal department and how can you further support them. Then they start trusting you, the areas, and you start getting more traction into that and getting involved earlier. But of course, this is not always the case. And of course, you end up sometimes in litigation and arbitration. So it's not to avoid arbitration per se as a figure, but it's to avoid the dispute. No? It's what you want to pursue, because again, you are there to do business, not to, enter into a dispute.
I fully agree. I think it is largely for the business leaders to do business in a way that doesn't cause disputes, right? I mean, it's if your equipment works and doesn't break, you'll get much less claims than if your equipment breaks down. I think there's only so much, and I'm of course now talking from the perspective of an old in-house litigation counsel, right? So I haven't been in the role of actually contracting and working with the business. I've just been handling with what remains. There's a few things. I touched upon the idea of using arbitration clauses, for example, as a preventive sort of threshold to weed out some claims. I think it largely goes to sort of, in my opinion, to settlement and negotiation strategy. So I think you can avoid quite a few arbitrations if you sort of have the mindset of trying to actively seek negotiation opportunities, mediation opportunities, settlement opportunities. I think one step of that is to get rid of the mindset of, if we offer to negotiate, we seem weak, which at times you hear. At times you hear that from outside counsel. I think if there's some validity to that, of course, but I think the risk of not being able to settle because you seem weak compared to having actual negotiations to settle definitely outweighs that other side of it. And there's of course other ways to sort of demonstrate strength, right? One of them is not agreeing to settle to a bad settlement, right? So I think yeah, just having that focus on settlement strategy, and then of course having that good case assessment there, so you'll have that good visibility on when does it make sense to settle, right? Because I think there's quite a few arbitrations that you can avoid if you have good visibility on how good your case actually is and are willing to settle on terms that you might not be willing to settle for if you wouldn't have that visibility.
You, Krina?
Well, I think it's a matter of getting the operatives and the management to change their view of lawyers, because what I've sensed when switching boats from consultancy to business is that they perceive us as those attack dogs that should only accompany them when things have gone horribly wrong and there's no other way out, and then we take the lawyer with us, and we never take the lawyer with us before because it scares off the other party and they think that they were there to fight and we have no chance of reconciliation. I'm trying to change this within the company. I'm making a lot of efforts. It's not easy, I confess. What I have attempted lately, and I think it's functioning, is to involve one of the team members in the project as early as possible. So I have one member of the team that takes part when the tender is handing over to the operatives the project. And then he takes part in all the monthly expo meetings where the status of the project is presented. And we do not rely only on the commercials and technicals that are involved to report to us when a potential issue is occurring, because one of our team members is there and he gets an update on the status of the project, and he senses when a situation starts smelling bad, then we know that we have to interfere. And if you are there as early as possible, I think you have chances to save the situation. Because as said, generally, if you leave it at if the decision is theirs, they come to the legal when it's far too late, and then obviously we end up in arbitration litigation, and that's why they conclude that we are only there to fight and never with good intentions of settlement. It's the truth, unfortunately, yeah.
Christina?
Yeah. So I was thinking while you were talking that the days where the in-house lawyer comes and says you are allowed to do this or you are not allowed to do this, the law allows you, the law doesn't allow you, these are long gone. So you must be part of the team. You are there with the business in order to assess the situation and provide solutions, not just to say yes, no. And if the solution is not always very clear, you emphasize the risks, the pros and cons. Together with them, you take a decision. And if things do not go the right way, you are there with them in order to salvage whatever can be salvaged. So a team. It's not about legal and business. It's a team.
Thank you. Would be any questions from, please?
Well, first of all, thank you very much. It was super insightful what you have been telling us, and I have one comment and one question to the whole panel. The comment is, you know, from my previous role as VIAC arbitral secretary, I can really relate to the pathological arbitration clauses. I have a collection that I sometimes present to students when I do lectures, and they wouldn't believe it. They said, "Come on, you made it up." And I said, "No, trust me." I mean, and sometimes I really wonder, even if business people fumble a little around, there are clauses out there where you really have to try hard to end up with that situation. But I hope that this is now a thing of the past, because I think it has arrived with business people almost that at least copy-paste the clause. Well, and now to my questions to all the legal in-house counsels present. You have been talking about selection of arbitrators and selection of counsels. And we have heard in the previous panels that the parties are lacking behind in diversity. So I was asking myself, you know, listed criteria that you have when selecting arbitrators and selecting counsels. Is diversity not one of the issues that you take into account? For example, that you say, I'm you know, for the pitch of a law firm to represent me, at least they have to have a diverse team, because otherwise I don't even consider them. Or when you have a list of arbitrators discussed with your external counsel, do you insist that also female candidates are on that list? And if you have not a policy like that, why not?
That's a very good question. Honestly, we do not have such a policy, but it was never, I didn't feel it as a woman, I didn't feel it that we were not, or we were considering only male lawyers. In fact, we do work with a lot of female lawyers, and I could dare to say that maybe the male lawyers would have something against this at this point. But yes, it's something to consider and to have in mind in the future.
Yeah, I admit we don't have such policy either. I've not felt any disadvantages on one side or the other either. But we have begun ourselves being more careful to all these issues like ESG and the social side. And of course, we will align with the group who is one step ahead of us in all these proceedings. And we will for sure develop also policies like this. But in Romania, I've not really felt that there is any sort of discrepancy between the choice of ladies or men. We offer them the same trust, and we do have a variety of counsels of all sexes. So,
with regards to the selection of law firms, for the tendering of panel firms, I know that the companies I've previously worked for do use diversity, equity and inclusion criteria when selecting panel firms. I do admit that I haven't considered personally diversity points in selection of law firms for particular cases, but I think it's a good idea and I think we should do it. For the selection of arbitrators, I personally, and I think all of my colleagues from litigation functions previously have been signatories to the pledge. I have never seen a list of arbitrators that would have been put together by the team that wouldn't have been at least 50% women. I think that is an active consideration. I think also other criteria of diversity, so for example, age and other portions are also considered. So I do think that that is, at least I did think of that quite actively.
For us, absolutely yes. I mean, our general counsel is very, very keen in diversity and equity and inclusion. So yes, we have a criterion or RFP for the law firms that if we see two law firms that are identical, the law firm that has diversity, equity, and inclusion policies that are more alike to ours, they would be selected. So we share in the RFP our criteria. I mean, it's at the level of the policy for retaining external counsel. Of course, I mean, there are some situations where in some jurisdictions that it's difficult to find, and you'll still need external counsel, so there are exceptions, yes. And for arbitrators, we do not have it at a level of a policy, because for us a policy is something that needs to be elevated to the stock exchange, and then if you don't comply with it, you need to go to the auditors, etc. So we don't have it at the level of a policy, but we do internally. I mean, I've rejected lists of candidates by external counsel. I mean, sometimes a very small dispute, and they are recommending a former justice of the Supreme Court. I'm like, well, this is too much, no? It's a very small dispute, no? So then, yes, I have rejected lists of, like, full lists of arbitrators if they do not include gender, race, and age as well, because sometimes it's overlooked, I think. Yeah.
Please, sir.
Thank you very much. Thank you for this very interesting debate. I just want to pick up on one thing that you said at the end, which is, thank you very much, which is teamwork. I'll speak louder. Which is teamwork, and as external counsel, the most horrendous thing is to discover documents too late in the process, or even sometimes after the process. It seems to me that front-loaded arbitrations are key. And in this respect, I wonder whether appointing, I mean, you guys are very busy and you know your company better than anyone else, but you don't necessarily know the files and the documents. And appointing a sort of a contract manager, which is someone from the business unit who is, readily willing to answer questions on a daily basis and provide documents, is something that you would consider, or that you do consider already in your
Well, we do that. We actually do have contract managers, because that's how construction projects unfold. We have contract managers. They are the people that deal with the entire documentation, correspondence between the parties, claims and so on. So they would be the first we would go to. We like to be there too, so that we can assess on the importance of the documents, so that we can look together with them through the documents, through the emails and so on. But they would be, yes, the first point of contact, and they would then know to whom they should go to ask for further information, further documents within the team that they have worked with on site on that particular project.
Yeah, I fully agreed. I think the practice that I'm used to is sort of having discussing, let's say, project contracts as well, is that the project manager of the contract that's being disputed is generally being appointed as the contact person for the law firms to ask questions for documentation. If it's a large case, generally I'm used to a process where we also would use, let's say, an internal forensics team from the IT side to collect and image computers of the relevant stakeholders, and then use a third-party provider like United Lex or Banjetri or something to go through that document universe and at least sort it to, let's say, layers of priority to avoid using an external counsel to do all of the document review work in the first stage, and then with the combination of those, we will try to manage the risk you speak, and which is very much relevant.
For us, it's a two-layer discussion. So locally, at each of the markets where the company operates, they would decide if they would appoint. Normally, it would be the project manager. It's not like a contract specifically, but you train this project manager to keep the file in a certain way. And we include, for example, obligations in the contract to give reports. So once in a while, you ask them, do you have all the reports? No? And so it's not perfect, but it's how it works. Then from the global perspective, we have agreements that apply to all of the subsidiaries across the world. And for that, we are more careful. No? We have the file very well organized, and you have follow-up meetings with the suppliers. So every, I don't know, 2-3 months, depending, you would sit down with them and say, like, everything is fine, and then you will try to calibrate. Sometimes that's why I say that it's very rare that a dispute is a surprise. No? It can happen, but sometimes you see it cooking as it evolves. No? Mm-hmm.
Teaming up between external counsel, internal counsel, business, other stakeholders like management is probably the single most important factor that we decide whether you win or lose case, above all other assessments. And that was my comment. The question is, if you have a lot of experience and expertise in handling disputes in-house. If you had a wish to the procedure, what kind of procedural innovations would you, what kind of procedural innovation would you like to have, but haven't seen yet in the actual process, but maybe also beyond?
Well, I would say that at least at local level, we would like to have a better control over the experts. We do have a problem with the experts here in Romania. There are not so many, they are not so qualified, and they take ages to provide the reports. And it delays the entire case terribly. And it makes our life hard because we are the ones that have to promote and advocate arbitration to the management, and we go there and we say it's fast and you're going to get the opinion of very renowned expert people with a lot of expertise and so on. And when it takes 5 years, then next time you go, it's kind of difficult to explain why you want to go to arbitration. So I think that control over experts would be very helpful, at least here in Romania.
Maybe just one, let's say, very innovative thought that we had. We had a small discussion before the panel concerning the costs of external counsel. And this is sort of just a thought that I haven't thought that much more in depth, but one sort of key difference between local courts and arbitration generally is the lack of judicial control of cost in the proceedings. Now, obviously, we can't go to a level where the costs of the parties' own legal counsel would be controlled by the Arbitration Institute, but I've been in several arbitrations where the costs between the parties' counsel differ substantially. I mean, one example is where our costs were 1/10 of the cost of the counterparty. And in those scenarios, it might be useful in some form to have some form of, let's say, whether it be an indication on a cap on recoverability or something that would provide some form of control to legal fees. I mean, I think legal lawyers' cost is, I think, one of the biggest issues in arbitration, in my opinion, at the moment. I don't know how we can address that except through tendering processes, but if there would be a solution to that, I think it would be very helpful.
okay, I have several. So first, I mean, the comment completely agree. If you don't work as a team with your external counsel, it's the recipe for catastrophe. So yes, we need to work together. And for example, I mean, I was mentioning before, we could, I think, polish a little bit the document production phase. I think this is, without making it disappear. I mean, I understand the reason behind it, but it's kind of abused, I think, I perceive. No? Something that I have been, I want to insist, but I don't know if it's going to be popular or not, it's to restrict the length of the submissions. Like, honestly, I have to do reports for our CEO, 1 paragraph. I have to summarize the whole case in 1 paragraph. If I can do that, I cannot see how the arbiters cannot do with less pages. No, it's but then again, I don't know how popular is this. No? The experts, as the colleague was saying, and the counsel fees, of course. It's but I mean, counsel fees. It's something that, I mean, it depends, because if you see things in perspective, you also need to see the sales of the company versus the legal expenditure. And there are whole metrics on that, no? Saying like these transnational companies have spent this much in legal fees. So, and these are things that the general counsel discuss, like we're cheaper versus our competitors, for example, or we're more expensive, so we need to reduce the costs. So everything is relative. I'm not saying that we want things for free, no? But as you were saying, if it's relative, how much are others spending, and how can I better control this, no? It's a matter of predictability. So how can you make this predictable? Not necessarily the size of it, but the predictability. No, it's yeah.
We just came out with one comment. Yeah. Probably also in my experience, the biggest factor in reducing costs is having a really cooperative relationship. Because you want to go on with that relationship. It's not a one-off.
Absolutely. Sometimes we make it more expensive. I completely agree. No, sometimes if you want everything translated into 3 languages, and you have it's like, no, it's. But I think the business the business understands it very quickly once you confront them. So like, you can have whatever you want, but it's going to cost this. And then they say like, okay, no, we really don't want this. So but you need to be ready to stand up to them and speak them in the language that they understand. Again, coming back to the translation thing. Yeah.
That would be the last question.
You mentioned the institutions, Oscar, that you would pick. You talked about the top 10. As an institution that's just started 6 months or so ago, we know it's going to take a long time before people like you involved in putting clauses into contracts think about us in that way. But do you have any advice to me and to other smaller institutions about why you might pick them at some point? Things that we should think about doing to encourage you to.
It's a very good question, and I think the Scottish Institute is definitely showing us how it's done. I think the most important thing is to increase the, let's say, the profile and how well people know the institute, right? I think sort of at least for me personally, the question of sort of using an institute that I haven't used before, or which is not among the top, let's say, 5-10 institutes. It is sort of getting easily the comfort that there's nothing weird that's going to happen, right? So, if there's an institute that, let's say, the rules are a carbon copy of the ICC rules, right? And that's it. I'm fairly happy with that, right? I mean, it's going to boil down on the rules. So perhaps, for example, I've seen some institutes publish a comparison chart between how our rules work, what are the differences between other institutes. That might be one way of sort of easily being able to compare how does this actually differ, what I am agreeing to with this new institute.
Many comments as well, sorry. I think it all depends on how you want to position your institution. No? If it's an institution that will deal with all types of disputes, I think it's more difficult when you measure it against a bigger institution that has been there for long. No? But if you position it more for specialized things, for example, we operate globally and we are not married with a single institution. No? So it's, we try to think, I mean, will the award be enforceable in other jurisdictions? No? For example, what we were seeing of the sanctions in Russia, no? Or what institution will understand more the culture, for example, in Asia? Or which it's more effective to do business with Africa, no? Which can be challenging sometimes. No, it's so we take all of that into consideration. So, I mean, I see when we receive the speeches from the institution, they are incredibly alike. You know, neutrality of the arbitrators. We've heard this, and I'm not criticizing this. I think this is the basis. They need to start from that. But then, what else to see the difference? What is your real differentiator? But I mean, please, I'm happy to have the conversation and to think of it. Yeah.
One more thought on that is that I think one of the best ways, perhaps, for an institute to get caseload, and we see that in my home jurisdiction in Finland for the FIA, is this business discussion on where does the international cases of the FIA come from? And I think the primary source for FIA, for example, is the fact that they've been implemented to the standard terms of the large companies from Finland, right? So I think perhaps if I were in a new institute, I would be looking at the large companies in the area and try to sell the idea of implementing that as the arbitration clause of the standard terms.
Thank you very much. Thank you all the speakers for their very insightful contributions. Thank you to all the audience for the attention, and have a nice evening. See you tomorrow.